I'll begin with a brief overview of each of these bills, starting with Bill 25-345, the Accountability and Victim Protection Amendment Act of 2023.
This bill was introduced by me along with Councilmembers Parker and Bonds on June 21st, 2023. On June 21st, Councilmember Gray also co-sponsored
Councilmember Gray also
this bill is the
co-sponsored
product
this
of
bill.
conversations
This
I
bill
had
is
with
the
the U.S.
product of
Attorney's
conversations
Office
I
about
had with the
gaps
U.S.
that we're
Attorney's
seeing in our
Office
criminal laws,
about gaps
that
that
are
we're
making
seeing
it
in our
difficult
criminal
to
laws,
deter and
that are
respond to
making it
certain
difficult
crimes
to deter
and
and
hold
respond
people
to certain
accountable
crimes
when they
and
harm
hold
other
people
community
accountable
members.
when they harm
The bill
other
contains a
community
number of
members.
provisions
The
aimed
bill
at
contains a
strengthening
number of
protections
provisions
for
aimed at
victims or
strengthening
potential
protections
victims
for victims
of
or
domestic
potential
violence
victims
and sexual assault,
of domestic violence and
sexual
sexual assault,
senior
I'll
citizens
walk through
and
a
children.
few of the highlights
I'll walk
now.
through a
The
few
bill
of
would
the
create a
highlights now.
standalone felony
The bill would
offense
create
of
a
strangulation.
standalone felony
Strangulation
offense
is
of
a key
strangulation.
predictor of future
Strangulation
domestic
is a key
violence
predictor of
that can
future
turn
domestic
deadly.
violence.
Creating a
that can
standalone
turn
offense
deadly.
will make it easier to
Creating
hold
a standalone
individuals
offense
who
will make
engage
it
in this
easier to
conduct
hold individuals who
accountable
engage in this
prevent
conduct
the worst
accountable
outcomes.
and prevent the worst
This change would also
outcomes.
bring the district in line
This change
with
would also bring the
49
district in
other
line with
states
49
that allow
other
strangulation
states
to be
that
prosecuted
allow
as a
strangulation
felony.
to be prosecuted
Notably, this
as a
provision is
felony.
currently law
Notably,
as
this
part
provision
of
is currently
prioritizing
law
public
as
safety
part of my
emergency amendment act,
prioritizing public
which the
safety
council
emergency
passed in
amendment act,
July on an
which the council
emergency
passed
basis.
in July
This
on
bill
an
would make
emergency
that
basis.
provision permanent.
This bill would make
The
that
bill
provision
also
permanent.
provides for progressive
The bill
sentencing
also
for serial
provides for
misdemeanor
progressive
sex
sentencing
offenders.
for serial
Right now,
misdemeanor sex
individuals who have
offenders.
repeatedly engaged
Right now,
in
individuals who have
sexual
repeatedly
abuse are
engaged
only
in
subject to
misdemeanor
a
sexual
maximum
abuse are
of
only subject
180
to a
days
maximum
imprisonment
of
no matter
180
how
days
many
imprisonment,
times they reoffend.
no matter how many
This
times
change
they
increases the
reoffend.
maximum
This
sentence
change
to 3
increases
years
the
for
maximum
individuals
sentence
with
to
1
3
or more
years for
prior
individuals
convictions for
with
misdemeanor
1 or more
sexual
prior
abuse.
convictions for misdemeanor
This would help to
sexual
deter
abuse.
individuals who we know
This would help
view
to
the
deter
district
individuals
as a
who we
haven
know
for
view the
sexual
district
assault
as a
sprees.
haven for sexual
Next,
assault
the bill would
sprees.
create new
Next,
evidentiary
the bill
rules to
would
give
create
courts
new
discretion
evidentiary rules
to admit
give
evidence
courts
of previous
discretion
similar
to admit
crimes and
evidence
sexual
of previous
abuse
similar
and child
crimes
sexual
and sexual
abuse
abuse
cases.
and child
Similar
sexual
evidentiary
abuse
rules
cases.
in California
Similar
would
evidentiary
help
rules
to bring
in
Harvey
California
Weinstein to
or
justice
would help to bring Harvey
following
Weinstein to
decades of
justice
sexual abuse
following
allegations.
decades of sexual abuse
The bill also includes a
allegations.
provision that would
The bill
prohibit
also
individuals
includes a
who have been
provision that would
convicted of
prohibit
stalking
individuals who have
from
been convicted of
possessing
stalking
a firearm.
from
According
possessing
to
a
Every Town
firearm.
for Gun Safety,
According to
in nearly
Every Town for
9
Gun
out of
Safety,
10 cases,
in nearly
of
9
attempted
out of
murders
10
women,
cases of
there had been
attempted
at
murders
least
of
one
women,
stalking
there had been
incident
at
in the year
least one
prior to the
stalking
attempted
incident
murder.
in the year
This
prior to
change
the
would help to
attempted
prevent
murder.
domestic
This
violence
change would help to
situations
prevent
from
domestic
turning
violence
deadly.
situations.
The bill
from
also
turning
includes a
deadly.
number of other provisions
The bill also
intended to
includes a
protect
number
women,
of other
children, and
provisions
seniors
intended
from
to
violent
protect
crime.
women, children,
I
and
look forward to
seniors from
hearing from
violent
advocates
crime.
from
I look
organizations
forward to
working
hearing
to end
from
domestic
advocates from
violence and
organizations
sexual
working
assault
to end domestic violence and
with their
sexual
thoughts
assault
on these proposals.
with their thoughts on
The second
these
bill on the
proposals.
agenda is Bill
The second bill on the
25167,
agenda
the Wheel
is
Lock
Bill
Help Incentive Program
25167,
Act
the
of
Wheel Lock Help
2023.
Incentive Program
This bill
Act
was
of
introduced by
2023.
Councilmembers Bonds,
This bill was introduced by
Nadeau,
Councilmembers
Fruman,
Bonds,
Allen,
Nadeau,
and myself
Fruman,
on February
Allen,
28th,
and myself
2023.
on February 28th,
The bill would help establish a
2023.
rebate program
The bill would
to
help
help
establish a
residents
rebate
purchase and
program
install
to help
steering
residents
wheel
purchase and
locks
install
or lug
steering
nut
wheel
locks
locks
on their
or
vehicles.
lug nut locks
This is a
on their
timely
vehicles.
proposal.
We've
This
seen
is
a
a
huge
timely
spike in
proposal.
auto thefts
We've
this
seen
year,
a huge spike
over
in auto thefts this year,
100% over last year,
100%,
in part because
over
of some
last year,
significant
in part
vulnerabilities
because
in
of some
certain
significant
Kia and Hyundai
vulnerabilities
models,
in certain Kia
along
and
with
Hyundai
social media
models,
trends,
along with
like
social
the
media
quote-unquote
trends,
Kia
like
challenge
the
on
quote-unquote Kia
which has
challenge
encouraged
on
some of our
TikTok,
young people to
which has
engage
encouraged
in
some of our
repeated
young
thefts.
people to engage
I'm
in
interested to
repeated
hear from our
thefts.
government agencies
I'm
whether
interested
this
to
bill
hear from our
could
government
help prevent
agencies
these
whether this
crimes
bill
from
could help
happening
prevent
in the
these
first
crimes
place.
from happening
Next,
in
Bill
the first place.
25343.
Next, Bill
the Private Security
25343,
Camera System
the
Incentive
Private
Program,
Security
Small
Camera
Business
System
Expansion
Incentive
Amendment
Program,
Act of
Small Business
2023.
Expansion Amendment
This
Act
bill
of
was introduced
2023.
on June 13th,
This bill was
2023,
introduced on June
by
13th,
Councilmembers
2023,
Allen,
by
Gray,
Councilmembers
Parker,
Allen,
Bonds, Henderson,
Gray,
Lewis,
Parker,
George, and
Bonds,
myself.
Henderson,
The
Lewis,
bill
George,
provides
and myself.
proposes
The bill
expanding
provides
the district's private
proposes
security camera
expanding
system
the district's
incentive program
security
to
camera
provide
system
rebates
incentive
to small
program
businesses,
to provide
to
rebates
install
to small
security
businesses,
cameras and
to
glass
install
break
security
sensors
cameras
inside
and glass
their
break
businesses.
sensors inside
I am very
their
excited to
businesses.
explore this expansion
I am very excited
of
to what has already been a very popular
This proposal is also especially timely,
given the significant spike that we've seen in break-ins and retail thefts Small businesses are crucial to the district's ability to thrive, crucial to the district's ability to thrive, both economically and these crimes are having a huge impact. And these crimes are having a huge impact. I'm hopeful that this bill will give us another tool to deter these crimes and hold repeat offenders accountable. And hold repeat offenders accountable. The last bill on today's agenda is Bill 25-348. The ensuring safe forensic evidence handling for sexual assault survivors amendment. This bill was introduced by council members Allen, Robert White, Henderson, Lewis George, Robert White, Henderson, Lewis George, Gray, Fruman, June 26, Parker, and me on June 26. This bill is intended to fill a current gap. This bill is intended to fill a current gap in our protections. And I do just want to note for those listening, and I do just want to note discussion around this bill may be difficult. Discussion around this bill may be difficult for background. Following a sexual assault, victims following a sexual assault, victims seeking justice for their attackers, physical evidence recovery sometimes use physical evidence recovery colloquially known as these kits can preserve evidence for their attackers' identity. In cases where a victim reports the sexual assault to law enforcement, district law requires MPD to collect these kits and deliver them to the Department of Forensic Sciences within 7 days. But the problem is that for victims who don't immediately there's currently no equivalent requirement for DFS to This is a problem because sexual assault is an enormously for victims, and not all victims will be prepared to report the crime to police right away. In many cases, survivors don't come forward. It's important that we find ways to preserve evidence so that survivors have the ability to decide if and when their case enters the criminal justice system. This bill aims to give survivors that power to decide. It requires DFS to develop a protocol for receiving and storing anonymous kits from individuals who haven't reported a sexual assault to law enforcement. The bill also requires DFS along with the district's independent expert consultant on sexual assault on DFS's storage of these anonymous kits. These changes would give sexual assault survivors autonomy to decide how to proceed with their cases and would help hold more sexual abusers accountable by preserving evidence that might otherwise be lost. With that, before we begin with public witness testimony, I will turn to colleagues in attendance for any opening statement they may have. I will start with my colleague, Councilmember Charles Allen, the introducer of two of these bills.
Thank you so much, Chair Pinto. First, my thanks for holding this hearing today. Literally legislative recess, and I appreciate you making out of our legislative recess. I'm looking forward to hearing testimony on all the bills. I'm looking forward to hearing testimony on all the bills for us today, but I am here primarily for two bills on the agenda. First, Bill 25-343 expands the district's private security, which came out of legislation I introduced several years ago, which came out of legislation rebates for interior cameras and glass break sensors for small businesses. The program currently includes exterior cameras for businesses, small and large cameras for businesses, small and large individuals, but not interior cameras and not sensors. But not interior cameras and not sensors. Crafting this bill and proposal came directly from meeting with and hearing directly from meeting with small businesses and hearing the experiences along the H3 corridor, particularly along the H3 corridor. But many small businesses have seen strings of burglaries. Many small businesses have seen strings of burglaries and almost loss of retail inventory and almost always through a broken window or glass door. Those businesses didn't have interior cameras. Those businesses didn't have cited not only the cost barriers, but cited not only the cost barriers, but the lack of help from the district government needs to step in to support. The district government needs to step in, especially when they're hurting, and especially when they're operating on shoestring budgets. Especially when they're operating. This is a relatively simple step that we can take. This is a relatively simple step that we can take, and a common sense expansion of our rebate program is excellent. The current camera rebate program tens of thousands of cameras, and it is now distributed tens of thousands to help MPD investigate everything from But those rebates have been mostly given to individuals. Those rebates have been mostly given to individuals, not our small businesses. And this legislation. The second, Bill 25-348, came out of conversations with victim services providers and advocates and a colleague of mine. It has to do with the medical forensics evidence. It has to do with the medical forensics evidence that's collected at the hospital in the aftermath. If the victim chooses to report the assault to MPD, a protocol kicks in about how that evidence is handled and preserved. But if the victim doesn't report, which we know is the case for many victims and survivors, for a myriad of reasons, victims and survivors, it's unclear what should happen next, particularly it's unclear what should happen next, having the evidence that survivor is having the evidence collected outside of D.C. Many of these so-called anonymous kits are now stored voluntarily by the D.C. forensic forensic nurse examiners, if the kits even make it back to D.C. If the kits even make it back to D.C. But they don't have the capacity to store them for more than a short time, about 2 years. For more than a short time. Under legislation I introduced several years ago, the district now doesn't have a statute of limitations for our most serious, incredibly important crimes. That we preserve anonymous kits for decades. That we preserve anonymous kits for decades. The importance of storing and preserving this evidence. The importance of storing and preserving this evidence is to be able to come forward at a later date. To be able to come forward at a later date. It gives them a better chance at a successful prosecution. It gives them a better chance is properly maintained when that evidence is relied on, maintained, and can be relied on. As I said, justice for many victims may not look like the difficult process of reporting, and a conviction may not look like accountability or healing. A conviction may not look like accountability or healing. Victim-centered legislating is to give them the victim-centered legislating is to give them the option to choose for themselves and have them define if they do want to engage the police. I fully support that. I want to make sure that evidence is strong and that it can also be uploaded into national databases that can also be uploaded into national databases that may help. I want to thank the D.C. forensic nurse examiners. I want to thank the D.C. forensic nurse examiners, as well as the sovereign independent expert, as well as the sovereign independent expert consultant Elizabeth Silverberg and Nadia Hanau from their expertise in developing this bill, for lending their consistently demanding that crime survivors be allowed to consistently themselves get that justice and healing through our legislation, get that justice and healing through our legislation. Again, I want to thank Chair Pinto for holding today's very important hearing. That we're going to hear today, and to work together to make sure our laws and policies, and to work together to make sure our laws and policies are helping make sure we're keeping D.C. residents safe and just. Thank you, Madam Chair.
Thank you very much, Councilmember Allen. Thank you very much, Councilmember Allen. For today's hearing, we will hear first from the public witnesses to discuss the legislation before us, and then from our government witnesses before us, and then from our government witnesses. As usual, public witnesses will have 3 minutes to present their testimony. Those who represent their testimony. Organizations will have 5 minutes. While today is a hybrid hearing, I believe all of our witnesses, I believe all of our public witnesses are virtual. So we will proceed with our first panel of public witnesses. Mr. Ringler, Civil Rights Corp. Mr. Ringler, Civil Rights Corp. Public Witness. Jakia Carroll, Public Witness. Jakia Carroll Johnson, Public Witness. Kiana Johnson, Evans, Public Witness. Afeni Evans, Public Witness. Faye Aaron, Public Witness. DC Forensic Nurse Examiners. DC Forensic Nurse Examiners. Go ahead, Mr. Ringler, whenever you're ready. Go ahead, Mr. Ringler, whenever you're ready. And let me also note that our clock is currently experiencing some difficulties, so I will let you know when you are kind of monitor, but if you can for yourself, kind of monitor time as well. Sorry for yourself, your time as well. Sorry for the inconvenience.
Time myself, so I know it's within 5 minutes. Good morning. My name is Mr. Ringler, and I am an employee of Civil Rights Corps. Civil Rights Corps is a national nonprofit. Civil Rights Corps is a national nonprofit that protects the rights of people involved in the criminal legal system. We've won state and federal civil lawsuits challenging unconstitutional pretrial detention, and we've helped craft. We also represent survivors of MPD's. We also represent survivors of MPD's. So we all agree there's a problem. Our city is definitely collectively aging, and we absolutely needs solutions. And I'm here specifically to testify, though, that we should not expand pretrial detention, we should not expand pretrial detention, we should not create crimes, increase camera sentences, or increase camera surveillance. First, in regards to the Accountability and Victim Protection Act, carceral systems have never made those most vulnerable to sexual and gender-based violence, brown women, queer people, including black and brown women, people who use drugs, sex workers, people who use drugs. This bill does nothing to meet vulnerable survivors, nothing to protect them from evictions, nothing to protect them from racist family courts, nothing to protect them from racist family courts, nothing to ensure that immigration systems close, nothing to ensure house themselves and their children as they heal from physically and emotionally from violence. The bill also fails to recognize that victim and offender are often two sides of the same coin. Many of those charged with crimes in DC many of those charged survivors of domestic violence and sexual assault. Survivors of domestic violence
too often they're further assaulted by the
too
police
often
and
they're
jails.
further
Civil Rights
assaulted
Corps
by the
has
police
seen
and
MPD
jails.
officers
Civil Rights
under
Corps
the guise
has
of
seen
searching
MPD
people
officers under the guise of
grope and
searching
sexually
people.
assault them.
This is especially
Grope and
true
sexually
for
assault
Black
them.
men.
This is
and we
especially
believe it to be
true for Black men.
This
And
July,
an
an
MPD
MPD
officer was
This
found
July,
guilty
an
of
MPD
sexually
officer
abusing
was
a
found
9-year-old
guilty
child,
of
sexually
sexual
abusing
abuse
a
in our
9-year-old
DC
child,
jails is
and sexual
rampant.
abuse in our DC
My
jails
testimony that I
is
submitted has links to
rampant.
all of these
My testimony that I
citations.
submitted has links
Police
to all of
cannot
these
keep us safe
citations.
from sexual assault.
Police
when
cannot
they
keep us safe from
themselves
sexual
use their
assault
badge and
when
their
they
power to
themselves use
inflict
their
it.
badge and their power to
Incarceration will
inflict
never
it.
end sexual and gender-based
Incarceration
violence.
will never
We would
end
do
sexual
far
and
better
gender-based violence. We would do
by
far better
survivors
if we would
if
invest in support
by
that they
survivors if we
actually
would
need to
invest
heal,
in support
such
that
as
they actually
expand
need to
resources
heal,
available to
such as
survivors, expand
regardless
resources
of whether
available
they
to
report
survivors,
the police,
regardless
and
of whether they
decarcerate
report
the survivors
police,
of sexual
and
and gender-based
decarcerate
violence
the
that are
survivors of
currently
sexual
sitting in
and
our jails
gender-based
and prisons.
violence that are
Free them
currently
so they
sitting
can
in our
heal.
jails and prisons.
Free them
Second,
so they
as
can
far as
heal.
Second, as
Pretrial
far as
detention.
pretrial detention.
Increasing pretrial detention makes us less safe.
Increasing
which the
pretrial
council
detention
did
makes
this
us
July.
less safe.
Pretrial
Which the
detention,
council
even
did
just
this
2 or
July.
3 days,
Pretrial detention,
especially
even
for
just
young
2 or
people,
3 days,
substantially
especially for young
increases the
people,
risk they will be
substantially
of someone
increases the risk
reoffending
they will be
and future
of someone
incarceration.
reoffending. Pretrial
And
detention
future
also drives
incarceration.
poverty. Pretrial
Poverty
detention
in
also
turn
drives
drives
poverty.
crime.
Poverty in
I
turn
spoke to someone
drives
just
crime.
last week and did
I
intake
spoke
with
to
them.
someone
His
just
case
last
was no
week and did
papered.
intake with them. His case was
But
no
he
papered.
nonetheless lost his job.
But he nonetheless
now
lost his
struggle to
job
feed his children.
and
as
will
a
now
DCRS
struggle
man.
to feed his children.
Pretrial detention
As a
is also
DCRS.
family separation.
Pretrial
It
detention
isolates
is
children
also
from their
family
parents.
separation. It
It
isolates
isolates
children from their parents.
Another driver of
Isolation.
violence.
Civil Rights Corps
Another
has
driver of
represented
violence.
hundreds of
Civil
individuals
Rights
whose
Corps has
lives have been
represented
ruined
hundreds
by
of
pretrial
individuals whose
detention.
lives have been
And
ruined by
third,
pretrial detention.
about the expansion of private security camera program,
of private
also
security
thus
camera
expands
program,
surveillance footage
also
available to
thus
MPD.
expands
And
surveillance footage
surveillance is a
available to
tool for
MPD.
social
And
control.
surveillance is a
originates
tool
with
for
this
social
country's
control,
brutal
originates
commitment
with
to
chattel
this country's
slavery.
brutal commitment to
Justifications
chattel
for
slavery.
surveilling black and brown
Justifications
people
for
have shifted,
surveilling
but the
black and
purpose
brown people
has
have
remained the
shifted,
same.
but the
Surveillance
purpose is a
has
powerful
remained the
means
same.
of destroying
Surveillance
community
is a
sense of
powerful
safety
means
and
of
destroying
crushing
community
dissent.
sense of
The
safety and
psychological
crushing
impacts of
dissent.
police surveillance,
The
no matter the
psychological
degree of
impacts of
severity,
police surveillance, no
force or
matter the degree
invasion,
of
are
severity,
devastating.
force
A
or
program
invasion
like
are
this is a
devastating.
deeply
A
misguided
program
use of our
like this
public
is a
funds.
deeply misguided
As
use
far
of
as
our
what we
public
can
funds.
do to curb
As far
harm
as
in our
what we
city,
can do
first is
to
to
curb
create
harm
and
in our
fund
city,
universal
first
basic
is
income
to create
as
and
outlined
fund
in the
universal
district's
basic
gun
income
violence
as
reduction
outlined in the
strategic
district's
plan.
gun violence
Fund
reduction
violence
strategic
objectives.
plan. Second,
Fund
don't
violence
prosecute
objectives.
children as adults
Second,
and pass the
don't
redefinition
prosecute
of
children
Child
as
Amendment
adults
Act
and pass the redefinition
Third,
of Child
pass
Amendment
the
Act.
Drug Policy Reform
Third,
Act, decriminalize
pass the Drug
personal
Policy
possession of
Reform
drugs,
Act.
decriminalize
Four,
personal
remove
possession of
police from
drugs.
schools by 2025
Four,
as the council
remove
had
schools
committed
by
to but has now
2025
reneged
the
on.
council had committed to but
And
has now
five,
reneged on.
Invest in
And
green
five,
spaces. We can reduce
invest
violence
in
by the
green
environment
spaces.
around
We
us.
can reduce
Hundreds
violence
of
by the
recent
environment
studies in
around us.
multiple cities,
Hundreds
including
of
Philadelphia
recent studies
and
in
Baltimore,
multiple
found
cities, including
maintaining
Philadelphia
green
and
spaces
Baltimore,
reduces
found
some forms of
maintaining
crime.
green spaces
And Seattle had a
reduces some forms
program
of crime.
that offered
And
matching
Seattle had a
funds to community
program
organizers
that
so
offered
that they
matching
could
funds to
complete
community
neighborhood improvement
organizers so
projects
that they
and
could
also
complete neighborhood
substantially
improvement
decrease
projects
violent
and
crime.
also
You,
substantially
the council,
decreased
know
violent crime.
better than to pass
You, the council,
draconian,
know
tough on
better
crime
than to
punitive
pass
laws.
draconian,
Those measures
tough
will
on
leave
crime
our communities
punitive
even
laws.
more traumatized
Those measures
and
will
will
leave our
worsen mass
communities even more
incarceration.
traumatized and
Stop
will worsen
punishing
mass
people who are
incarceration.
struggling and offer
Stop
help
punishing
instead.
people who are
Thank you.
struggling and offer help instead. Thank you.
Thank you very much. Next, Ben Reese, public witness. Next, Ben Reese, public witness.
Hello. 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 Can you hear me? Hello.
Yes, we can hear you.
Can you hear me? Sorry.
Yes, we can hear you.
My name is Ben Reese. I'm a DC resident. My name is Ben Reese. Interested. I'm a DC resident who is interested in the legal system, sure that it and investing in making sure that it benefits job correctly. To that end, I've been observing hearings at the Superior Court. I've been observing hearings at the Superior Court over the past. There is much that I could say about the system as a whole. There is much that I could say about the system as a whole, especially its pretrial process. Considered today is centered on domestic violence. Considered today, that is where I will direct my attention. So that is where I will direct. The central thing I've learned from actually watching the process in action flatly, not equipped to handle domestic violence issues. To handle domestic violence issues. Not a matter of the courts being restrained, not a matter of the courts being restrained or evidentiary maximums, nor is there a failure of the criminal code, nor is there a failure of the criminal code to properly define domestic violence. Problem is much more basic. Problem is much more tools built to determine fault. Courts are tools not to diagnose causes of harm, not to diagnose or to disentangle complexly interwoven or to disentangle complexly interwoven lives. Courts one answer. Because of that, separate from the community, whoever is hold separate from the community, whoever is rarely a useful problem. Is rarely an elderly man, possibly in the early stages. When an elderly man, possibly in the early stages, be a danger to his wife of 30 years. Be a danger to his wife of 30 years. When unaddressed mental health needs cause a daughter to lash out at her mother, cause a daughter to lash out at her mother. The court has when a man is accused of abusing his girlfriend. When a man is accused of abusing his girlfriend, is also the sole leaseholder and source of income has their household. Answer. The court has victims know this, of course. They do not call the police because they think a law enforcement response is the right answer the right. They call because the city insists that it is the only answer. This bill, the Accountability and Victim Protection, the Accountability and Victim Protection continues to double down on this assertion. Continues to double down on this assertion. Most of the time, Chair Pinto. Most of the time, flatly counterproductive. This attitude is ordering people suspected of theft to stay away from their places of employment. Imposing vagrancy fines that leave a person unable to pay rent. This bill does clear that low bar. This bill does clear that low bar. Council considers a response that is merely off. Council considers a response that is merely off. We can do better than throwing people in a hole and hoping they do better. Throwing people in a hole and hoping they do better later. We can build a proper mental health crisis. We can build a proper mental health crisis. Provide counseling and interim housing. Can provide for those who need a pathway to leave a toxic relationship. For those who need a pathway to leave a toxic relationship. If the council is interested in addressing domestic violence, I'd rather see it exploring these tools. I'd rather see it exploring these creating ever more specific descriptions, creating ever more specific descriptions of the violence that occurs without them. Thank you for your time.
Thank you very much. Next, we will hear from Jakia Carroll, public witness. Okay. Kiana Johnson, public witness. Afeni Evans, public witness.
Hi, I'm here.
Hi, great.
Hi, I'm here.
Hi, great. Go ahead.
Hold on, give me 1 second. Sorry. I did not expect to be called next. Okay. Hi, my name's Afeni. I organize with Harriet's Wildest Dreams. And I'm here to talk about. And I'm here to talk about things that are happening within some of the things that are happening within the city council body today. First of all, I'd like to start by saying, victim of sexual assault, quickly tell my story. I was sexually assaulted in my high school bathroom. In my first year of high school. And I went through the whole criminal legal process. The person that harmed me, the person that harmed me, he pled guilty. He pled guilty to everything that happened. And the prosecutors, the detectives, they made it seem like that was supposed to make me feel safer, make me feel better. To be honest, all that did was re-traumatize me, make me relive this entire experience, sit on a stand and be re-traumatized again by a defense lawyer. So I'm speaking from the perspective of a survivor, especially a survivor that has dealt with the criminal legal system, and I can tell you that it does not work. I can tell you that it does not make survivors of sexual violence feel any more secure, even though this person was held accountable, they are not actually being restored. They are not actually being restored. They're not being transformed. All of the violence that they were exposing other people to outside of incarceration, they are now outside of incarceration. Behind the wall, they are now experiencing it. Further compounding the violence and the trauma. Further compounding the violence and the entire cycle of this entire cycle. You say that we are here to prioritize. You say that we are here to prioritize. Yet there's no safety. Yet there's no culturally responsive programming for you, job programming for you, increased recreation or arts for our youth. Increased recreation or arts members like Repento. We have council members like Repento and Treyon Wright. The increased criminalization of children. They are children. Councilmember White even went so far as to say that we needed the National Guard. We needed the National Guard to police children. So, if we're prioritizing public safety, but there are no discussions about increased family support, creating and facilitating better opportunities for mobility, because crime is a socioeconomic problem, mental health services for those youth that are growing up violent in neighborhoods, then we are not actually talking about prioritizing public safety. Over-policing and incarceration do nothing to interrupt the cycle of violence. In fact, it just compounds the violence in these neighborhoods. It just compounds the violence in these neighborhoods. It continues to predispose not only people that are victims of harm, people that are victims of harm, the perpetrators of harm. Now they're experiencing more harm through the carceral system. Now they're experiencing more harm through the carceral system. Accountability does not have to be cruel and unusual. Accountability does not have to be cruel and unusual. And should be accountability can and should be a closed loop process that properly supports all parties involved in the harm. All parties and if we want to keep DC safer, and if we want to keep DC safer, then we should fund harm reduction centers. We should fund harm reduction centers of the many socioeconomic issues of the many socioeconomic issues.
I'm sorry to interrupt.
That's all I had to say. Crime.
Okay. Thank you so much, and thank you for sharing your story. Thank you so much, and thank you for sharing your story. I'm so sorry to hear that happened to you. I'll have some questions for you. After we're done with this panel. Faye X, public witness. Faye X, public witness.
Actually, that'd be Jay Brown. Actually, that'd be Jay Brown. It has a Faye X, but it has a Faye X, but
Yes.
You hear me? Okay.
Yes.
Okay. Violence. Cannot be solved with violence. Cannot be solved with violence. And most of your bills violence against violence the African American community. The African American community. When you're talking about surveillance, talking about over surveillance African American over surveillance African American. You're talking about what you're doing. When you're talking about to having police have the justification to have the justification to people that's on probation parole. When you're talking about what's happening in California. When you're talking about what's happening in California. If I'm not mistaken, Georgetown University was the same university founded and built personally, my ancestors who were enslaved by Georgetown University. I don't really respect that university. I don't really respect that things that they teach there. Things that they teach there. Got 3 years of emails. Got 3 years of that emails sending you. That I have been address crime, to address crime, proactive solutions for our community. Proactive solutions for our community. You need to reach out to me. So that we can talk about these proactive solutions. We can talk about can't come with a blanket approach. We can't come from a blanket approach who is really not a native, not familiar with native culture, not familiar with the culture community. And right now, what she's doing is right now what she's doing reactions to these knee-jerk reactions to residents is not going to be proactive. It's not going to be proactive. In Ward 7 and 8 and all the Ward 7 and 8 and all the mostly black and brown. We need to revisit black and brown, so that we can have a balanced proactive, so that we can have a balanced approach to solving these crimes in our community and solving these crimes in our community and mitigating these crimes in our community. There you have it. There you have it. Hello?
Hi, we can still hear you.
Okay.
Hi, we can still hear
you. Having, like I said, police, like I said, having police, what you're doing is encounter, engage. What you're doing is basically giving justification for MPD, giving justification for MPD to go around and what you search, have you and Pintos, I would like to know, have you Pintos, I would like to know, ever witnessed, have you personally MPD ever witnessed MPD jump out, search an African American in our community, an African American in our community? You can answer.
This is your time for testimony. Happy to hear from you. We won't be testimony. Happy to hear from you. We won't be answering questions.
I didn't think you had. We really need to revisit some of these laws that you revisit on the bill because they sound like slave codes on the bill because they sound like slave codes. It's not going to be productive. And they're not going to be. It's not going to be productive. They're not going to be a deterrent in our community. They're not going to prevent a lot of crime. That's my community. That's my time.
Thank you very much. And just to confirm, you prefer to go by Jay Brown as opposed to Faye X? You prefer to go by Jay Brown as opposed to Faye X? Thank you. Okay. Aaron Polite, DC Forensic Nurse Examiners. DC Forensic Nurse Examiners.
Good morning, Chair Pinto and committee members. My name is Erin Pollitt. My name is Erin Pollitt. I have the executive director of the District of Columbia Forensic Nurse Examiners or Columbia Forensic Nurse Examiners or testifying today in support of two bills under consideration, Bill 25-345, the Accountability and Victim Protection Amendment Act, and 25-348, the Ensuring Safe Forensic Evidence Handling for Sexual Assault Survivors Amendment Act. Sexual Assault Survivors DCF&E supports the creation of a standalone felony offense for non-fatal strangulations for non-fatal strangulation as proposed in Bill 25. DCF&E has previously testified regarding the severity of strangulation and the life-threatening consequences that can result from this violent form of assault. Notably, of the patients examined by DCF&E in 2022, 1 in 4 had experienced non-fatal strangulation as part of their assault. In fact, nearly half of those who have been strangled reported that it had happened multiple times. As strangulation is such a strong predictor of future lethality, DCF&E continues to support this measure in support of our mission to lessen the impact of violence in the District of Columbia. DCF&E also supports increased accessibility to HIV prophylaxis medicines. As forensic nurses, our utmost priority is the health and the wellness of our patients. When our patients are being treated for a potential HIV exposure, time is of the essence, as medication must be initiated within 72 hours of the exposure. The assailant's HIV status, whether known or unknown, is just one factor among the individual medical considerations and circumstances related to the assault that influences whether a patient is deemed to be at risk for contracting HIV. Bill 25-345 proposes pre-conviction HIV testing for individuals charged with sexual assault to help victims make informed decisions about their health care. While well-intended, it's unlikely that this legislation will benefit victims within the time frame that is necessary in order to impact this critical decision. One thing that victims would undoubtedly benefit from is better coordination by the district to reduce the costs associated with taking MPEP, which can also hugely impact their decision-making process. DCF&E supports a formalized process for the storage and management of non-reported sexual assault kits as proposed in Bill 25-348. Annually, DCF&E provides medical forensic care to approximately 150 victims who do not make a police report at the time of their exam. To date, there's been a lack of guidance on sexual assault kits in the district that are not accompanied by a police report. DCF&E has relied on an internal process to manage sexual assault kits, but this practice is simply a Band-Aid on a much larger by our most recent projections, DCF&E will be completely out of storage space for non-reported sexual assault kits by December. We've escalated our request for more space at our hospital center, but the reality is that the National Institute of Justice does not advise sexual assault kits by hospitals and SANE programs. Lastly, DCF&E supports the expanded legal definition of medical forensic care as proposed in Bill 25-348. A broad definition is important as it allows clinicians to tailor the medical forensic exam to the individual needs of each patient and honor their autonomy. And on a systems level, the expanded legal definition for medical forensic care will ensure that victims of crime are not excluded from social services or reimbursements that they may be otherwise entitled to, simply because they did not select the proper item from the forensic menu. The new definition will also help to fix a misconception based on the language of SAVRA, which guarantees a victim's right to a perk. This language reduces the overall medical language reduces the overall medical forensic care process to an evidence collection process only, and it sets an unrealistic expectation for victims as evidence collection is not indicated in every situation. Strongly supports a victim's right to access medical forensic care tailored to their own care and tailored to their own unique. Thank you to the council for your time today. Thank you to the council for your time today. For your unwavering support for victims of crime in the district. DCF&E will be submitting additional written testimony for the record, and we're happy to answer any questions.
Thank you so much. And thank you to all of our witnesses on this panel. Thank you to all of our witnesses on this panel. We're going to do 5-minute rounds of questions. I'd like to start with Mr. Ringler, and thank you so much Mr. Ringler, and thank sharing your ideas and perspectives. Sharing your ideas and stood out to me was one thing that kind of stood out to me ideas around access to green space, ideas around access to that individuals and making sure that recreate and play safely, recreate and play safely. And you mentioned Baltimore as being an example, Baltimore as a place that had explored this. Do you have any more information about what that looked like in practice, and if they've explored in practice, and specifically what effects that had? Specifically, what effects that had?
Yes, in my testimony I submitted, I included links to that specific study that looked at Philadelphia, specific study that looked at Philadelphia, more specifically the program then in Seattle, the program then in Seattle, probably the most substantial increase that was also found, probably the most substantial. And the general sense is that in violent crime, and the general sense is that impacts how we feel, our environment really impacts what our stressors are like, if we're able to, what our stressors are like, if we're able to, and whatnot. So if we are generally bonds and whatnot, so if we are generally able to more welcoming space and space that allows more welcoming space and nature that allows for us to be access nature as well as form community bonds, magnificent improvement of that, magnificent, and there's some really great programs out there, and there's some really great programs out there that models out there from Baltimore to Seattle to Philadelphia that we could. I can link links in my testimony if you want. I can link links in my testimony.
Great, thank you so much. We definitely will. I appreciate that. Thank you so much. We definitely will. I appreciate that. Afeni Evans, thank you again so much for sharing. Thank you again so much for sharing your story. I was particularly moved when you talked about. I was particularly re-traumatization. That you re-traumatization going through the justice system and going through the justice system and felt comfortable in sharing kind of what you think more of a restorative model could look like in the district that could benefit survivors and that could benefit survivors. What you talked about around do some more of what you talked about around restoration, rehabilitation for those who have committed for those who have committed sexual
Absolutely.
assaults.
You know, that time, you know, that old time saying that says hurt people is really true. That says hurt people is really true. And I think that there is a lot. I think that there is a lot on the table when people don't look left on the table when people don't look at alternative systems of justice. Right. In my personal experience, when I talk about traumatization, I was not. I did not have like. I did not have like to go through these things, and I was to go through these things, and I was at the time 15 when the trial actually and 15 when the trial actually like started to kick off. So you know, being a 14, 15-year-old, you know, being a 14, 15-year-old, that is your first. When like that is your sexual experience, and it is real sexual experience, and it is, you know, void of consent. It's like, you know, void of consent. There are a lot of things that need to be like put in place. There's a lot of support that needs to like put in place. That was not there. That needs to be there. That was not there of my trial. During the time just having to retell the story over and over again. Just having to retell the story over and over again is re-traumatizing. Having to is re-traumatizing. Having to go through interrogated and questioned by was very traumatizing. Was and also very traumatizing. And also, you know. Sorry. Sorry.
Take your time.
Yeah. Just that entire experience. It kind of made me shy away reporting again. Reporting when I was sexually assaulted again. Because when I was sexually assaulted years later, I did not tell anybody. Years later, I did not tell anybody. 2021. Until about 2020. 2021, I didn't really tell anybody else. And as far as restorative practices, you know, I think there are a lot of really great. I think there are a lot of research in New York City, and I was in New York City, and I wish I had pulled this stuff to actually pulled this stuff, but I was glad to ready some of the restorative justice practices that have restorative justice been effective in New York City as far as been effective in New York City as far as domestic violence, victims of sexual violence, victims of sexual violence, to have what it looks like to have a by the process that is led by the person that is harmed, having it be led instead of having it be led by a criminal legal system that lacks general empathy around sexual assault victims. So definitely. So making sure that everybody, impacted by the situation, whether it is the person that committed the harm, whether it is the person that committed the harm, or the person is actually getting the support that they need, whether that's getting the support that they need, whether that's any type of like mental health support on any type of like mental health support on side, perpetrators side. Job placement, some sort of like, and I don't, some sort of like, and I don't sort of like, and separation period, things like that, separation period, things like that. As well, making sure that making sure that on the other side of the harm, the victim of the harm, on the other side of the harm, the victim also getting, the counseling, making sure that they're getting like the counseling, making sure that they're getting like any needed. If you have to take that is needed, if you have to take like I missed about 2 weeks of school. If I was an adult, that'd be 2 weeks of work. If I was an adult, that'd be 2 weeks of work. So like, what does it look like to make sure that we're supporting victims while they are taking time off? While they are taking time off because things like you need to take time off and things like that. But yeah, hopefully that answers the question. And I'm also like super willing to like send over, super willing to like send over the studies from the New York City study that happened as well.
Thank you so much. I really thank you so much. I really important perspective. Appreciate that. And thank you for everybody else on this panel. And thank you for everybody else on this panel. I'm out of time, but really appreciate you all being here. And the ideas shared. And thank you so much. And the ideas shared about the cost covering about measure, the cost covering measure idea in particular. We're gonna. I'd now like to turn to my colleague, Councilmember Allen. I'd now like to turn to my colleague, Councilmember Allen, for a 5-minute round.
Thank you, Chair Pinto. My thanks to Thank you, Chair Pinto. My thanks to given this whole panel as well. Given this round, I'm going to focus my questions with Ms. For this round, I'm going to focus my questions with Ms. Pollitt, but I do want to appreciate everyone's testimony and Athene in particular. Appreciate everyone's testimony and Athene in particular, which is re-traumatizing in itself, which is to share your story with us. Thank you for sharing your story with us, as well as helping highlight, that justice and what is an outcome that is desired is what is an outcome that is desired is survivor and may not always look the same survivor and may not always look the same. So our laws and policies need to reflect that. So our laws and policies need to reflect that. Your courage and be able to share your experience publicly. Your courage and be able to share your experience publicly. Your recommendations. So I look forward to seeing the follow-up that you also said you're going to be sending to us. So I look forward to seeing the follow-up that you also said you're going to be sending to us. So Ms. Pollitt, I'm going to turn to you if I can with a few questions. Ms. Pollitt, I'm going to turn to you if I can with a few questions. I want to make sure we understand as we consider this legislation. I want to make sure we understand as we consider this legislation fairly quickly. And I'm going to have to kind of move through these fairly quickly. When we think about how many perks, you have to handle annually. From the district's perspective, if we take this on, how many perks would you anticipate that the bill would cover annually? How many perks would you anticipate that the bill would cover annually?
So it's hard to fully say annually, just simply because we're contacting folks and asking would they like us to continue holding their perks, and I'm assuming that we didn't ask people what the disposition of their kit should be. They might elect to hold them longer. They might elect to hold them longer. So I don't know if our current numbers we have more than 200 in holding right now currently. And so that's not just from this year, but that's not just from this year, but years as well. So that could help to give a little bit of insight. So that could help to give a little bit of insight. I'd anticipate that folks would held even longer to have their kits and held even longer up to 150. As I mentioned before, up to 150. Seek a medical forensic exam from us, which could potentially which could potentially include evidence collection.
Okay, and I think your last part was the number I think I was looking for. So as we try to think about this, it could be up to about 150. It could be, and obviously we have to figure out 50. And obviously we have to figure out there will be variability, but that there will be variability. But we think about 150 per year that could about 150 per year that could lead towards from an exam anonymous per kit. Lead towards an anonymous per kit. Okay, thank you.
That's right.
Okay, thank you. Can you help us understand, maybe paint the picture about the conditions in which the perks are in storage right now? In which the perks are in storage right now? Is each one a large box? Is each one a large space do they take up? How much space do they take up? If I've got to work with DFS and others to think about what that storage capacity would look like, can you help outline for us and paint a picture about what the storage looks like? Paint a picture about what the storage looks like?
Conveniently, I have a sample perk here, a sample perk here. So this is the size. So this is a sexual assault kit. It's a sexual assault kit. It's a box. And so right now, we are simply only able to collect what fits inside the contents of that box. I do anticipate that once a formal storage solution is in place, that folks might also submit additional clothing items, which doesn't fit within the size of that box, and is typically packaged in brown paper bags. So it might be more than just that box. So it might be more than just that box. But that's what we've been able to offer at this point of time due to
Thank you.
our limitation.
Are there agreements that you have to enter into with victims for storing their materials? With victims for storing their materials, they want them back. Let's use an example. Let's say that they want them back. Can you just talk about that relationship you enter into? Can you just talk about that relationship you enter into with the victim?
So for us, we are typically informing folks and having them sign off that they understand our process for kit storage. And we're calling the survivor usually at the 90-day mark, usually at the 90-day mark, and at 1 year and a half mark, what they would like us to do if they'd like us to storing their kits. Many of them during that time, many of them during that time might elect to have their kit destroyed. That's the case. Then our destruction process. I have not encountered a patient that has requested to have their kit back. I don't think that's out of the realm of possibility. I don't think that's out of the realm of possibility. It's not something that we've had to navigate.
And final question. Thank you. And we're talking about two universes of forensics. We're talking about two universes of forensics evidence that's collected from assault. Evidence from a DC assault, collected evidence from a DC assault, and then secondly, evidence from a DC assault, and then secondly, evidence from a DC assault is collected at a hospital. If you could just very briefly just help. If you could just very briefly just how you currently come into possession of evidence, how you currently come into possession of evidence in that second to hospital in a different jurisdiction. How often does that happen? Jurisdiction. And just how often does that happen? Hospital find you. And just how does the hospital find you? And with chairs, just help walk us through that understanding. Extra time. Just to help walk us through that understanding.
Sure, and I can actually, correct what might be a misperception is that what might be a misperception is that chain of custody. We have not concerns. We have not actually taken concerns. We have not evidence from other hospitals. Although evidence from other hospitals. Although we get frequent. I've had multiple requests from the state of Maryland, calling the state of Maryland, and I know they've calling either myself, and I know they're trying to transfer kits in, but trying to no formalized process, due to no formalized programs lack of storage space, my programs lack of storage space. We're unable to accept the kits that we collect ourselves. Hold the kits that we collect ourselves. We have had accept extras, but we have had multiple in Maryland, actually very recently calls from Pennsylvania, asking how should we transfer our kits to you. We've had to say there's not a formalized process. There's not a formalized process. We can't accept them at this time.
I know I'm out of time. Just one quick observation to help make sure we understand how critical this is. Observation to help make sure we understand how critical this is. So. Those kits are just going to languish, and those jurisdictions are just going to languish if they're even maintained there. If they're even maintained there, which means that damage done to a victim and survivor, the damage done to a victim and survivor, who may want to then there is almost literally no way to be able to prosecute. There is almost literally no way to be able to prosecute the way the system is currently. So because the really can help reinforce this, and I appreciate really can help reinforce this, and I appreciate ability to go just a little over there with our expert. Ability to go just a little over there with our expert to make sure we. Thank you, Ms. Pollitt. So thank you. Thank you, Ms. Pollitt.
Thank you, Councilmember Allen. Thank you to all of our witnesses. Thank you to all of our witnesses on this panel. Really appreciate we're going to move on to our next panel. We're going to move on to our next panel. First, public witnesses. Nene Taylor, Harriet's Wildest Dreams. Nene Taylor, Harriet's Wildest Dreams. Harriet's Wildest Dreams. Frankie Seaborn, Lindsay Silverberg, Network for Victim. Lindsay Silverberg, Network for Victim. Kristen Eliason, Network for Victim. Kristen Eliason, Network for Victim. Sandra Seegers, Crave. Sandra Seegers, Ali, NAACP, Ali, NAACP. Charles Hopkins, A Voice for a Second Chance. Charles Hopkins, A Voice for a Second Chance. Public witness. And Michaela Deming, public witness.
Go ahead, Nini, whenever you're ready. Go ahead, Nini, whenever you're ready. You're still muted. You're still muted.
Sorry about that. I'm kind of frustrated because I have a meeting to go to because I have a meeting to go to and I was on the first panel and got moved. And I was on the first panel and got moved. I'm the executive director of Hurry's Wildest Dreams. I'm the executive director of Hurry's Wildest Dreams. I'm also I didn't even prepare for this testimony. I didn't even prepare for this testimony. Last time I can be heard before. Last time I can be heard before. Bill is criminalized in D.C., which I'm totally criminalized in D.C., which I'm totally as you all know that I am a true believer. As you all know that I am a true believer. Crime that's happening in D.C. The violence and crime that's happening in D.C. I'm totally against it. And as executive director, I'm totally against it. And as executive director of Hurry's Wildest Dreams, I can speak on this because I do the work. I can speak on this because I do the work. We are prevention. To prevent where we have a court watch program where we have a court watch today at 1 o'clock, and I will today at 1 o'clock, and I will for the council to sit in on the court. For the council to judge it on the court and watch the judges operate and how criminalizing black operate and you already have black people and you already have for like laws in place in D.C. for like someone committed a crime with a gun, like someone that's coming back, someone that's actually coming back in prison. They actually get it's already in prison. It's already in D.C. It's already in D.C. have one of the toughest. D.C. have one of the toughest gun laws in the country. Gun laws have one of the toughest gun laws. And the only reason I know this is because I watched the court. And the only reason I know this is because I watched the court. And I know the law. I have the D.C. Safety Squad where we are prevention. I have the D.C. Safety Squad where we are prevention. We are actually out here doing the work. And we know that criminalizing people, and we know that criminalizing people does not actually reduce crime. It doesn't actually harm. It's not rehabilitation. It doesn't reduce harm. It's nothing there for these people. It's nothing there for these people. Just because you think they committed a crime, just because you think innocent committed a crime, when you're innocent, proven guilty. You're innocent. It actually harms. It actually harms families. It actually causes people. And the only reason I'm telling you this is because and the only reason I'm telling you this is because I do the work. So once you put that person in a cage, and we literally fight for their rights, and we literally fight for their rights from that cage, once we get them free from that cage and go to court, when they finally go to court, they've lost their job, they've lost their job, they've lost their family, and nothing is being done while they're in that cage. And nothing is being done while they're in that cage. It's because the reason I'm telling you this work is because I do. I've been bailing black women out, and since 2017, you got a bail. 2017, you got a bail, and I'm going to fight your case because you cannot fight your case because you cannot fight your case. I have never had any, but I have never had one woman since 2017. One woman since 2017 committed that had to go back to the system while they were had to go back to the system while they were out on our watch. So it's to say that people commit crime. So it's to say that people commit crime. That is false. Another crime, and you fear mongering. That is false. You making people believe that the laws making people believe committing right now is going to keep committing right now, and they're not. DC safe. The juvenile, and they're not. The juvenile curfew. The juvenile. I need to know because I've been waiting for the stat. I need to know because I've been waiting for the stat. Last Friday when y'all first started. I was on last Friday when y'all first started. You are actually arrested for you. You are actually arrested for you. And took him to DYRS. And know how many cops I saw on the street? And know how many cops I actually got a ticket because they had time that day. I actually got a ticket because they had time that day. So they literally pulled me over and gave me a $25 ticket. So they literally pulled me over and gave me a $25 ticket. Wasting time. They had nothing but overtime. They can do shit like that. Wasting time to do. So I literally got a ticket because cops was down there. So they gave me a ticket for talking out my window. So they gave me a ticket for talking out my window. Because that's talking out my window. Because that's instead. And I said, why don't you go to Southeast? So reality is what you all are creating. It sounds good, but it doesn't prevent crime. It sounds good, but it doesn't prevent crime. The number shows for itself. At 12 to 6, 11 to 6. You got a curfew for the youth at 12 to 6. Crime doesn't have a time. Crime does not have a time. Crime does not have every day at 1 o'clock. We have crime every day at 1 o'clock, 2 o'clock, 8 o'clock. So I want you all to stop acting like I want you all to stop acting like in the cage. Criminalizing people and putting them in the cage. It's not decrease crime. And stop doing that. And actually stop doing that. And actually as you have the youth off the street, and as you have the youth off the street. More crime can happen because guess what? Actually take away from crimes, being prevented from crimes being prevented. So I'm just here to say, like, stop fear-mongering people, letting them think that the laws that you're putting in place. It's a cop on almost every block. It's a cop on almost every block. My car just got broken into. My car just got broke into. I swear to God, my car just got broke into. I swear to God, my car just got broke into. I have insurance. I'm okay with that. I have insurance. So am I gonna be like, oh, that person should go to jail? So am I gonna be like, oh, that person should go to jail? No, how can I? They broke into my car. No, how can I? What to help them so that they won't break into somebody else's car? To help them so that they won't break into somebody else's car. I want to know. I want to know who broke into my car. I want to know who broke into my car. Not to lock them up, but I need to know what they need as a resource. Not put them in the cage. My car's replaceable. People are not. My car's replaceable. And for people are not. DYRS is overpopulated. DYRS is I literally worked with the youth. I had a whole summer. I literally worked with the youth. I had a whole summer. 15 black girls, 13 to 17. 15 black girls, 13 to black girls. I intentionally took black girls who have been runaway. Because I wanted to know what was on their mind. I wanted to know what was on their mind. Not criminalize them. And I wanted to change them. And not one of my youth got in trouble this summer. And not one of my youth got in trouble. I don't have the money to do that all year round. But I don't have the money to do that all year round. You don't have the money like that. I don't have the money. I don't have the resources. I don't have the money. Invest in resources that actually can be prevented. Invest in resources that actually can be prevented. Had 100 summer youth programs. Trigger Project had 100 summer youth programs. Why can't we have that all year round? Why can't we have that all year round? We gotta have no problem. We gotta invest. We gotta be preventive. We gotta invest. We gotta into prevention and not into prevention. And so
thank you very much. Nene, thank you very much.
I want y'all to stop telling the people that the Lord, I want y'all to stop telling the people that the Lord will decrease crime because they will decrease. Detention is not prevention. Detention is not prevention.
Thank you very much. And my apologies for the time. My apologies for the time. We had thought you wanted to be with your colleague. We had thought you wanted to be with your colleague with Frankie Seaborn, Harriet's Wildest Dreams panel. But to get you both on this panel. People are busy and got things to do, so we try to. People are busy and got things to do, so we try to move these along in the panel. So thank you for your understanding. The panel. So thank you for your understanding there. I want to remind everybody that our clock is. I want to remind everybody that our clock is broken. So if I can ask you all to monitor your time as well, and I'll let you know when you're out of time. On the screen, but I have it here with us. Broken on the screen. Next we'll hear from Frankie Seaborn, Harriet's Wildest Dreams. Frankie Seaborn, Harriet's Wildest Dreams.
And I want to confirm that I have 5 minutes. Good morning. And I want to confirm that I have 5 minutes.
No, you'll have 3 minutes. No, you'll have 3 minutes.
I didn't have 3. She has 5. I didn't have 3.
That's right. We have public witnesses. We have public witnesses and those representing organizations will have 5 minutes if there are multiple people. Will have 5 minutes from the same organization. One person same organization. One person has 5 minutes.
5. Okay. We gonna rock it out. Okay. All right, y'all. We gonna rock it out. All right, y'all. My name is Frankie Seaborn. I'm the program manager. I'm the program organizer for the IDA. The lead organizer for the IDA. I'm a third generation Washingtonian.
Frankie Seaborn, if you're still here, we've lost you. If you're still here, we've lost you. So we'll come back to you next. So we'll come back to you next if you're able to rejoin. Next, we'll hear from Naida Hanau, Network for Victim Recovery. Naida Hanau, Network for Victim Recovery of DC.
Chairperson Pinto, if you prefer for me to stop, allow Frankie to continue to allow Frankie to
okay, thank you. And just a reminder, because we have a number of people from Network for Victim Recovery organization gets 5 minutes. One person from the organization gets 5 minutes. So we have you on for 5. So we have you on for 5. Thank you. Go ahead.
Yes.
Okay, great. Thank you. Go ahead.
Thank you, Chairperson Pinto, committee members and staff for considering my testimony today. My name is Naida Hanau today. My name is Naida Hanau, and I'm custody of DC's Network for Victim Recovery of DC. 2012, NVRDC has supported over 9,000 crime victims and survivors over 9,000 crime advocacy, legal, and therapeutic service. Advocacy, legal, as an organization that serves the unique needs of not also underserved gun violence victims, but also underserved gun violence homicides. NVRDC understands the council's urgency to address our proposals today for bills 25-345 are guided by experience supporting survivors. I'd like to begin with bill 25-345. Despite differences in philosophical approaches to crime prevention, statistically speaking, we know that a very small number of victims will see the person who harmed them, prosecutors will see the person who harmed them, even less will result in incarceration. For example, a person is sexually assaulted every 68 seconds in this country, yet only 25 out of one country, yet only 25 out of sexual assaults out of every incarceration. Sexual assault. This means that a bill that's heavily focused on this means that a bill that's heavily focused on survivors will not benefit many VC survivors who not want to or feel safe. Those who did not want to or feel safe in the first place. With the criminal legal system in the first place. It can be complex. Solutions to public safety can be complex, but are not impossible to achieve. Strangulation. For example, this bill seeks to make strangulation motivated by the high lethality associated with strangulation, as will likely be explained by other domestic violence providers today. However, the dangers posed by strangulation will not be single-handedly solved by making it a felony. What will make a difference are policies like ensuring safe, accessible, and confidential spaces for survivors, training agencies on identifying strangulation, and educating the public and necessary professions on the lethality risks associated with strangulation. There are many complex reasons survivors do not only changing a crime to a felony without any investment in holistic education campaigns and feels like another empty promise to survivors. Feels like another more about pretending with increased safety. It is more about pretending with increased safety without actually political win or to structurally address the political win or to structurally address the colleague Lindsay Silverberg will testify about colleague Lindsay Silverberg will testify about while getting more information of survivors about their HIV exposure is important. Without access to medication is important. Without access to medication window does not prevent HIV. Our proposed approach to get survivors free access to HIV prevention medication, access to HIV prevention medication for offenses like unlawful publication for offenses like statute of limitations will be in our written testimony. Limitations will be in our written testimony. Will testify about my colleague Christina Lyson will testify about the proposed changes to 14307, which impacts the disclosure of survivors' sensitive and confidential records to other provision within the bill. I want to highlight this is a provision within the bill providing accountability and protection, providing accountability and protection threat to privacy rights. Instead of direct NDRDC has opposed this type of change for over a decade. Opposed this type of change for over a decade. 348. Turning to Bill 25-348 issues that feel is much more responsive to the issues that identifying as directly impacting our clients. Identifying as directly. First, we strongly support the clarifying modifications made to mandatory reporting provisions made to mandatory reporting such as sexual assault and domestic violence counseling. Such as sexual assault and domestic violence counseling. This existing language is too broad and endangers the ability to use roles to provide safe and confidential spaces for survivors, thereby undermining the survivors, thereby undermining the very. I greatly appreciate the responsiveness of the council. Greatly appreciate the responsiveness of the council. NDRDC also supports the two provisions regarding medical forensic care. The first change, which amends the definition of medical forensic care, which amends the definition of medical forensic care, injuries, strangulation assessments, etc. Rightfully clarifies that the forensic evidence collection process is not limited to a sexual forensic is not limited to a sexual forensic exam. This change not only has an impact on survivors' understanding of their rights to access to survivors' understanding of their rights to eligibility care, but also affects their eligibility for expanding this definition. We are providing greater flexibility for situations where traditional exam for situations where traditional exam wanted or even necessary for the victimization experience. Minor feedback will be included in our written test. Minor feedback will be included in our written support the bill's proposal about a clearly established proposal about a need for clearly established forensic evidence process that is tied to survivors forensic evidence report that is tied to survivors who choose not to report with the recommendations by the Sovereign Independent Consultant and how the Sovereign Independent Consultant, for example, not involving strategy and the delivery of the not involving the DCSUSTAIN program managed and having the DCSUSTAIN program managed notifications that impacts affect everyone in our impacts, taking an oversimplified approach of punishing individuals who cause harm, of punishing service to the entire ecosystem, as a disservice to the sobering reality that the current response systems are limited, that the current responsibilities are limited in achieving true survivors, including the significant portion, survivors, including the significant portion, deserve to have policy changes that actually deserve to have policy changes that actually impact their safety, support, and their lives. Thank you.
Thank you so much. We have been rejoined by Frankie Seaborn. Hear us okay, please? Go ahead. Can you hear us okay, please?
I'm here. Can y'all hear me?
Yes, I can hear you.
Can y'all hear me? All right, bet.
Yes, I can hear you.
Yes, I can hear you. Had some connectivity issues. My name is Frankie Seaborn. I am the program manager. My name is Frankie Seaborn. I am the program manager and lead organizer. I am a third generation Washingtonian. I am a third generation Washingtonian, a mother of two children, I'm a harm survivor, and I'm a daughter of harm survivor, and I'm a daughter of formerly. I do this work because I am the work. I do this work because I am the work. Harry Slaughter's Dreams is a Black-led abolitionist defense hub, and we center defense hub, and we center all lives at risk for state-sanctioned violence. And our work is guided by our ancestors. And our work is guided by our specifically here. And I want to call to mind specifically here. Ida B. Wells is named after. Ida B. Wells is named after. Our pillar is named after a freedom fighter who embarked on a freedom fighter who embarked on an anti-lynching campaign against black bodies and brought to light the horrors against black bodies that still occur to present day. And just as Ida worked to shed light on lynchings in the South, to shed light on lynchings in the South, seeks to shed light on courtrooms and hold these judicial actors accountable. We have trained hundreds of DC residents. We have trained hundreds of DC residents over the last 2 years and have a base of court watchers. A robust base. Court support is a form of mutual aid. Court support is a form of mutual aid. Watch the court. It is imperative we know that injustice is right to happen. Because we know that injustice is right to happen. When no one is watching. When no one is injustice happens. No one is in empty courtrooms. Injustice happens. Just last week we watched a man be criminalized. Just last week we watched a man be criminalized for 18 months in jail. He was sentenced to 18 months in jail. The judge even admitted that what he needed stable housing, a place to sleep. But instead, what he got was jail. But instead, what he got was jail. This is not okay. We have to be more proactive and creative about solutions to safety, because we know solutions to safety, because we know that we can't incarcerate our way out of economic crisis. We can't incarcerate our way out of economic crisis. We can't incarcerate our way out of mental health crisis. We cannot incarcerate our way out of the real harm that happens. That's exacerbated by the pandemic and is a city of have and have not. Is a city of have and have not. We have the starkest wealth place in this country, and y'all still trying to figure out, well, why? And y'all still trying to figure out, why is violence happening? Why are these things occurring? Because you're not putting your money occurring because you're not putting your money to prevent the harm. You're putting your money, you're putting your resources, you're putting your money, you're putting your resources into things that are reactive. Councilwoman Pinto, you were wrong 2 months ago when you and this council passed emergency legislation to expand pretrial detention, and y'all are still wrong now. And y'all detention is a harmful practice. Pretrial detention is a harmful practice. To expand it, we need look no further. To expand it, we need look no further than when over the past 12 months. When over the past 12 months, 10 people have lost their lives. So when you talk about expanding pretrial, I want you to understand the real world implications. That when you hold implications, you increase their risk of dying in a cage. You increase their risk of dying in a cage. Being accused of a crime should not be a death sentence. Being accused of a crime should not be a death sentence. Each and every time someone is held. Each and every time someone is held in this city. Prior to being convicted. Don't get me wrong. We all deserve safety. Don't get me wrong. We all deserve safety. We all deserve safety and wellness. We all deserve safety and wellness. But the answer to that is never going to be. But the answer to that is never going to be. The answer to that is never going to be. The answer to that is never going to be the carceral system. The carceral system. And then in an effort to quote unquote stop violent crime, y'all are just pushing us back into y'all are just tough on crime error and just tough on crime error and just passing things that are not truly going to keep us safe. If you look at pretrial services data shows that 95% of people released are not rearrested. 95%.
I'm sorry to cut you off. Overtime, if I could ask you to summarize the overtime, if I could ask you to summarize
the DC Council needs to legislate based on facts, not feelings. Less than 2% of people who are rearrested for violent. Less than 2% of people are rearrested. Less than 2% of people are rearrested. So why expand pretrial detention? It doesn't work. That it's not. It doesn't work. But that it's not. The solutions, however, should be narrowly tailored. The solutions, however, should be narrowly tailored to address those who are actually committing harm. And finally, that we ask the council invest in long-term solutions, like long-term solutions, like universal basic income, and things of that nature to actually put money in the pockets, and not paying $600 a day and not paying $600 a day for you to be incarcerated. Take that money and put it into things that are actually and put it into things that are actually going to help our communities.
Thank you very much. Appreciate your testimony. Thank you very much. Next, we will hear from Lindsay Silverberg. Network for Victim Recovery of DC.
Good morning. My name is Lindsay Silverberg, and I'm testifying on behalf of NVRDC in my capacity as its deputy director. As part of our services, NVRDC ran the district's sexual assault crisis response services between 2012 and 2021. And now we share the responsibility with the DC. It's based on this experience that I share my testimony today. I want to thank the committee for recognizing the importance of providing survivors of sexual assault with as much information of sexual assault with as much information as possible to achieve self-determination. We are concerned with the bill's proposed goal of HIV testing defendants after they've been charged with sexual assault. While this may be a useful option for some, we're concerned about the promises on paper that will not increase access the vast majority of sexual assault survivors' lives. As mentioned, in order to ensure NPEP medication must begin within 72 hours of exposure. And while we strongly believe that the time needed to locate and detain a person, to have a judge evaluate a person, to have a judge evaluate, and then arrange for the defendant to actually be tested, NVRDC instead asks for the support in increasing survivors' access to this critical medication, using the infrastructure already in place through the district's response program, sexual assault. In addition to this being a faster response than what is proposed in this bill, it focuses the approach on the survivor rather than testing the person With that being said, there are still significant barriers for survivors wanting access to HIV prevention medication that this council can address. The financial burden can address. NVRDC has provided hospital advocacy to sexual assault and has witnessed firsthand the barriers survivors face when trying to obtain this medication. While the studies show that the potential side effects are self-limited and often mild, is one of the most significant barriers. This cost is not covered by physical evidence recovery kit or PERT kit, unlike other STI medications. And while some insurance companies cover part of the expenses, over the years we've seen amounts owed range anywhere from $7 to and while the Crime Victims Compensation Program survivors are obligated to first use their insurance coverage. And this mandate creates a lack of privacy and confidentiality of survivors, thereby creating a barrier towards achieving true autonomy over their healthcare decisions. If the problem this bill is trying to address is how to make sexual assault survivors, then the solution must center survivors. We fear that the bill's focus on the defendant and their HIV status detracts from a solution that can instead center survivors' experiences, options, and experiences of their own lives to truly make informed decisions about their healthcare. We're asking that the council discourage policies where district residents are dependent on others to get tested first instead of being able to take their health into their own hands. Thank you for the continued effort to address the rights of sexual assault survivors, and I'm happy to take any questions.
Thank you very much, Ms. Silverberg. Thank you very much, Next, Ms. Silverberg. We will hear from Kristen Eliason. We will hear from Network for Victim Recovery of DC. Network for Victim Recovery of DC. Properly? Am I pronouncing your name properly? Eliason. Thank you. Eliason.
That's all right.
Thank you.
Thank you. Thank you. Thank you. Thank you, members and staff for considering my testimony today. My name is Kristen Eliason, and my name is Kristen Eliason, and I'm in my capacity as NVRDC services. In my capacity, in addition to supporting over 9,000 crime victims and survivors in the district, organizations nationwide specializing in crime victims rights advocacy, and is the only nonprofit in the district that litigates these issues. For more than a decade, we have fought a critical battle unseen to most members of the public. A fight for survivors' rights to privacy of 7, which allows for the piercing of various professional privileges, personal confidential information, including confidential information, provided the justable example. This provision could allow sexual assault survivors and therapists to be disclosed. For years, this process would occur without any notification to the survivor that the records survivors were often not given the opportunity to survivors were often not given irrelevant information before the records were obtained by the court or possibly by one of the parties or possibly if district residents knew about this phenomenon, it has been difficult to see many survivors who caused them harm, use their personal and confidential information, like personal and confidential information, sexuality information, and reproductive sexuality information, and reproductive. These disclosures are especially traumatizing. These disclosures are especially traumatizing because most of us are under the impression that these records are amongst the most guarded information. The 14-day notice requirement brought by the 14-day notice requirement brought by the was a welcome change for Survivors Act, was a welcome change for survivors and NVRDC's understanding, and was in response to a strong collective vocalization of the crime victim while the proposed change to 14307 while the proposed change to 14 day victim notification requirement under quote exceptional circumstances under quote mirrors the federal and local court rules, mirrors the federal and local court rules, does not abrogate the essentially sends us back to where we were prior. It essentially sends us back to where we were prior to take a step back, and the district should not take a step back of consistency in survivors' rights. We have seen time and again how the principle we have seen time and again how the principle of become the exception that swallows the rule and become the exception that swallows the rule. We want to be clear that NVRDC is not advocating. We want to be clear that NVRDC is not advocating for these court proceedings to ignore the realities of court proceedings or what we are asking for is the maintenance of what we are asking for to ensure that victim notification is the default. Victim notification is the default and it is intended. Additionally, all too often arguments for this additionally all too often arguments for privacy rely on violating the constitutional privacy rely on amendment. However, that right is a trial amendment. However, that right is a trial right, not a pre-discovery. It is often those who hold power that ask for. It is often those who hold power that want victims to be treated equitably. We want victims to be treated equitably, and we are extremely concerned that subject to the discretion of parties who are not subject to the discretion of parties who are not tasked. As we know, even a prosecutor's duty is as we know, even a prosecutor's duty is to the public. After experiencing a victimization, the least after experiencing a victimization, provide them with the basic courtesy to provide knowing that they're most private and sensitive of knowing that they're most private and sensitive to be heard on any opposition to a and to be heard on any current 14307 is not perfect. The current 14307 is not court rules, but it is stronger than the current court rules exception that litigants do not use the Sixth Amendment as a pretrial discovery tool. The Sixth Amendment as a pretrial discovery tool. NVRDC asks the council to keep it this way. Thank you.
Thank you so much, Ms. Eliason. Thank you so much. I'll come back to you for some questions on that. I'll come back to you for some questions curious about that component. Curious about that component. Sandra Seegers-Crave.
Hello, good morning. Hello, good morning. Sandra Seegers, or SS, co-founder of Crave, or SS, co-founder of Crave. I live in Congress. I'm a warded resident. I live in Congress. I am in support of Bill 25. I am in support of Bill 25, the Accountability and Victim Protection, the Accountability and Victim Protection Amendment Act of 2023. In this amendment, you will find the council's proposing to eliminate or extend the limit statutes or limitations for certain serious crimes, such as attempts to commit murder or such as attempts to commit along with crimes that are committed in these crimes. These changes will help to improve accountability. These changes will help to improve accountability where victim comes forward years after the crime was committed, as often happens in sexual assault cases. All enhanced amendments regarding sexual abuse. All enhanced amendments regarding sexual abuse. Expediting cases involving the child victim or child victim or child witness should be performed. Make a distinction in every case. Create enhanced penalties for domestic violence crimes committed in the presence of the child. Committed in the presence of the child. It will serve the public well to create. It will serve the public well to create new court discretion rules to admit evidence of previous similar crimes and previous sexual abuse cases, crimes and child sexual abuse cases, where the court finds by clear and convincing evidence, where the court finds that the defendant committed evidence of the child and adult committed sexual abuse crime and adult sexual abuse cases or cases. The prosecutor must submit the prosecutor must submit case at least 15 days before trial, or at 15 days before trial, if the court allows later days. If the court allows to detain arrested sex abuse arrested sex abuse is a good measure, and I think with those cases, the trial should be put on the fast track. The trial should be put on the misdemeanor arrest warrant. To make misdemeanor arrest warrant is an additional protection for 12-year-old victims. Is an additional protection for 12-year-old victims. Any enhanced laws that severely punish offenders severely punish crimes against children and senior citizens also welcome. And senior citizens also welcome. Hence, declaration of assault against senior citizens, certain assault against senior citizens, to be mandatory for testing of offenders, to be mandatory for testing of offenders charged with sexual assault, blood sample, HIV by furnishing the presence of HIV tested for the presence of HIV. Amending the Anti-Sexual Abuse Act of 1994 to extend liability for certain sexual offenses, liability to contractors of organizations, to contractors that already include employees and volunteers, pretty much covers all entities. Pretty much covers all entities. When you add the contractors. Since DC is a small district, it is to introduce an amendment to introduce an amendment to afford for extradition of misdemeanor arrest warrants to be served at any place within jurisdiction of the United States, within jurisdiction of the United States. If a judicial officer of the District of Columbia finds that a good cause exists, the bill will make clear that GPS will make clear the possession of the pretrial service agency PSA can be admissible a defendant's guilt in a criminal case, or other judicial criminal proceeding, or other GPS records from PSA, GPS records from PSA on the scene indicate that a domestic violence incident or a domestic violence incident. This bill will prohibit anyone who has been convicted of stalking from being able to possess a firearm. This bill has included the creation of a standalone felony offense, which should apply to everyone, including law enforcement entities. However, strangulation does not always cause death. I would think if a person were to die from strangulation, it should be a separate count, and the murder should be a separate count. And the murder. This in my statement, but I have a couple more minutes. This in my statement, when people speak of black and brown people, when people speak of black and brown people, they fail to mention that black and brown people. They fail to mention that black and brown people commit vicious crimes. Those same people never say anything. Those same people never say anything, and they never say anything positive, and they never say anything positive to support law-abiding citizens. They are not realizing that the criminal law. They are not realizing that the criminal law getting criminals off the street is just that, and getting unsavory characters off the street. A criminal can very well be rehabilitated, not on the street where they can commit more crimes. Not on the street where they can commit Bill 25. So please pass Bill 25-345 as it is written. Thank you.
Thank you so much, Ms. Seegers. Thank you so much, Ms. Seegers. Appreciate it. Akosua Ali, NAACP. Akosua Ali, NAACP. Okay, let us know if you join. Okay, let us move on to Charles Hopkins, voice for a second chance. Move on to Charles Hopkins, voice for a second chance. All right. Michaela Deming, public witness. Michaela Deming, public witness.
Good morning. My name is Michaela Deming. Good morning. My name is Michaela Deming. I'm actually here testifying on violence. This morning, my apologies for any confusion about that. My apologies for any confusion about that. DCCADV is a federally recognized statewide coalition of domestic violence and includes domestic violence specific housing providers, counseling specific housing services, counseling legal services and services, specific organizations serving African, Latinx, Asian, African Islander, Latinx, Asian Pacific Islander, and survivors who are deaf and deafblind. And survivors who are deaf and deafblind. Intimate partner violence continues to be a significant public safety concern for DC residents. Public safety concern for DC residents. The dedicated service providers, work tirelessly to address the epidemic of domestic violence across all. We also know that the rates of domestic violence are higher than the rest of the nation. In DC are higher than 39% of women and 25.5% of women and 25.5% of men live in sexual violence, physical violence, stalking, sexual violence, physical violence, stalking, perpetrated by an intimate partner. We're grateful for the opportunity to speak today on the importance of addressing safety in DC and how these discussions and policy decisions impact domestic violence survivors, impact domestic violence survivors. I'm going to give some top line. I'm going to give some top line. I have a lot more in my written testimony. Data here, but I have a lot more in my written testimony, and then I want to get to. So in brief. We do support the expansion of the, we do support the expansion of the strangulation offense. We know a person who is strangled by their partner is 10. A person who is strangled by their partner is higher risk of being killed by that same times higher risk of being killed by that same. We encourage the council and the mayor's administration. We encourage together with strangulation and domestic violence together with strangulation to prevent and address the complexities of the form of highly lethal violence, specific form of highly lethal violence risk. That addresses. I know that someone else mentioned that, and I know that someone else mentioned that needs to include education. The folks who are responding to scenes, the folks that are responding to scenes, have better information about how to. Similarly, we support the firearms. Similarly, we support the firearms prohibition expansions. Reality that the presence of a firearm, reality that the presence of a firearm in a domestic violence situation makes that situation 5 times more likely to be lethal. Also want to say that we do have pretty significant concerns about the proposal to increase domestic violence cases where children are in domestic violence cases where because of the disparate application of those laws and the reality of those survivors and the reality was already mentioned survivors are arrested for domestic survivors are arrested for responsive violence for trying to protect responsive violence for trying to protect themselves. And those folks are more likely to be and those folks are more likely to be black and brown families that are more likely to be black and brown families children are likely that are being impacted and those children are likely to be removed. Switching over to Bill 348 for just a moment, Bill 348 for just a moment, we greatly clarification of the mandatory reporting clarification of the mandatory reporting provisions about who what clarification about reported and preserving those safe reported and preserving those safe and confidential spaces. I'd like to take some time today to talk about a I'd like to take some time today about how these laws might play out these laws might play out. So let's say there's a domestic violence incident. So let's say there's a domestic partner strangles his female partner. The male partner strangles oxygen. The female partner starts swinging for oxygen. The female partner starts swinging in her hands and fists, lands a blow. When the police arrives, there face and scratching on bruising to the male partner's face and scratching. No marks are immediately visible on the female. No marks are immediately visible on the female. Very common. Face or arm. After hearing from both partners. After hearing from both partners, because law enforcement arrests the female partner on the male partner. Again, this is very common on the male partner. Again, this is very common in strangulation. Let's say children are present. The female partner is now facing increased penalties. The female partner is now facing increased penalties for on top of that, she has not received information. On top of that, lethality of strangulation, medical care, lethality of strangulation, medical care, and to monitor swelling to prevent her death, and to monitor the swelling to prevent her death. The additional penalty is contemplated in this bill. The additional penalty is contemplated in this bill will apply not the male partner whose violence partner, not the male partner whose violence poses the much greater danger to the female partner, the much greater danger to the female partner. And taking a step back for a moment to the decision, taking a step back for a moment. Partners have to make during and immediate partners have to make during and call on following the incident, whether or not to call on. Abusers use information and threats. Abusers use information and threats, including telling their partner no one will believe them, including telling their partner that the victim is the one who's going to be arrested, or that the victim is the one who's going to be arrested if the police are called, and that the children will be taken away. The female partner in this situation is now weighing all of that when deciding whether or not to call law enforcement, or not to call law enforcement or to cooperate, knowing that she's at a much greater risk of having knowing that she's at a much greater risk of having if the female partner is black, LGBT, if the female partner is black, or has an additional or other marginalized identity, has an additional or other marginalized identity, the chances that she will be arrested. The same is true about the risk for the children. The same is true about the risk for the child presence enhancement does not deter child presence enhancement does not deter, and it does not give survivors more options. And it does not give survivors more. I'd like to note also that this bill is titled also that this bill is titled in yet it does not include funding for what keeps yet it does not include funding for what keeps domestic violence direct funding assistance, more funding for direct funding assistance. Domestic violence intervention programming for domestic violence intervention programming for language doing harm. Counseling. It also doesn't include funding to prevent. It also doesn't include funding to prevent people from being harmed. So we support the strangulation provisions. So we support the strangulation provisions. We know that too many victims are charged with crimes related to many victims are charged with crimes related that would make adding the child enhancement provision that would make adding the child enhancement so we do not support that something that we could support. So we do any bill designed to support the safety of victims. Any bill designed does not include robust funding crime prevention. Not include robust funding missing critical component services of supporting victims of crime.
Ms. Deming.
Supporting victims of crime.
Yes. Sorry, you're over time. If I could ask you to wrap up. Sorry, you're over time. If I could ask you to wrap up.
I forgot to set my own timer. Absolutely, I'm so sorry. I forgot to set my own timer. Victims and residents of the city deserve both things. Thank you so much for the opportunity to testify. Thank you so much for the opportunity to testify. There will be a lot more statistics in the written testimony.
Thank you very much, and thank you for clarifying. Thank you very much, and thank you for here on behalf of your organization today. You're here on behalf this of brings us to the end of this. This brings us to the end of this panel. So I can now jump into questions. Now we'll do another 5-minute round. And I'll start with you, actually, Ms. Deming. I'm very curious, actually, Ms. Deming. I'm very curious as you talk about one as it relates to strangulation. One as it relates to strangulation. From your experience, are you concerned with any victims
nervousness of calling law enforcement, given strangulation as a standalone felony offense, as a standalone felony offense, could that have any backlash effect on people not against their partner, law enforcement against their partner? The example that you highlighted around children is of course a very concerning one. Is of course a very concerning one. The victim is the one when protecting themselves. Is the one protecting themselves. Have you seen other cases where having enhanced protections, having enhanced make sure that it's taken even more seriously? Make sure that it's taken even more seriously when children are around. Those types of violent situations from arising. Those types of violent situations from arising in a family context.
That's a big question. Let me see if I can answer all the pieces of that. Let me see if I can answer all the pieces of that. And I want to start by saying that my bigger concern around, and I believe one of my colleagues mentioned this, and I believe is the lack of education about the severity, is the lack of education about the severity of strangulation and what it looks like. Like in my example, might not know what they're looking at. In my example, might not know what they're looking at. Might not understand. But also that the victim themselves that a non-fatal strangulation can become fatal later on. Can become fatal greatly later on. Their risk of homicide increases their risk even from a separate incident later on. Even from a separate incident later on. Just how dangerous the situation. And so there are bills in other states. And so there are bills in other states that have been proposed something that law enforcement is supposed to read, something that law enforcement to the survivor on the provide to the strangulation, so they can make a better strangulation decision. So they can make a better informed decision there. The second part of your question around children. The second part of your question around children. I'm not concerned about. I'm not. The situation being taken, the situation as seriously because children are present. As seriously, we know that domestic violence impacts children. We know that domestic violence impacts children. We throughout their entire lifespan. We also know that separating that child from a safe parent also can have traumatic effects on that child forever. And so, as we think about how do we respond to these situations, we are committed to making sure that survivors have as many options as possible to get and stay safe, have safe housing, have safe resources. I think someone else mentioned earlier access to mental health treatment for those youth, so that we can build their resiliency factors and keep them with a safe parent. And so I think focusing on that is actually more designed, more follows the research better about what we know helps children than the possibility that one or both parents are going to get locked up for a longer period of time, thereby depriving that child of access to what could be a safe parent for them.
Interesting. Okay, thank you so much. That's helpful perspective. And I want to ask some of our other panelists, I know Ms. Silverberg, you talked about the concerns of the HIV provision and the issues around the cost of PEP. Conversations that my team and I have had really have highlighted to us the importance of the severe side effects that drug can have. And so making sure that we're not encouraging people to take a drug that they don't need to take was part of our considerations here. And so curious if you have a viewpoint on how that should be balanced against the cost concerns. And just for sake of time, I'll ask this together and you could both answer. For Ms. Eliason, is there a middle ground that you can contemplate that take into account the privacy concerns for survivors and for courts to obtain this information proactively?
Thank you so much for the question. I will say I'm not a medical professional, so this is just based on my experience being an advocate in the hospital and working with survivors for the last decade. I would say that the vast majority of the time, folks are not experiencing severe reactions or even like significant, what I would maybe consider significant reactions to NPEP. And so there are medications like Zofran and other things that can be prescribed to help, mitigate some of the impacts if someone does have some side effects. So in my opinion, obviously always the survivor's choice, but I think it's wanting to give them and create a faster and potentially a way to take some control back in their healthcare decisions in terms of getting access to the HIV medication.
Councilmember Pinto, I think it's a middle ground is a hard place for, I think, our organization to find outside of the current statute, because for so long there was no notification, there was no statutory notification requirement. It was founded in our case law, and that requirement was routinely skirted. And so frequently victims were finding out that their records were already being held in chambers or had already been turned over to defense. And so we strongly feel that providing victims with notice, 14 days is still not a lot of time. During that time, a crime victim gets that notice, has to figure out what the heck the notice is for. Often, even our organization, when we're representing a victim and are provided with notice, the motion for the subpoena itself, we don't actually get served with it. So we have to go back to the court and essentially ask to receive the actual motion that the defense attorney, usually the defense attorney, rarely the prosecution, but sometimes the prosecution has written as justification for why they should have access to our client's personal and confidential information. Most often that access being a piercing of physician-patient, therapist-patient privileges. And so for a crime victim to have to get that notification, figure out what that notification is. If it's an ex parte request from the defense, which usually it is, that notification also accompanies an order that the crime victim is not allowed to talk to the prosecutor, which is a violation of the crime victim's right to confer with the prosecution under both the Crime Victims' Rights Act and the DC Code. It is a frequent violation of a crime victim's right to confer, but that's usually right who a crime victim would go to if they're served with something in a criminal case that they don't understand. So that resource where they go to a prosecutor and say, I have this, I don't know what it is, and the prosecutor could say, I can't give you advice, but here are some resources. That's already cut off. So now that crime victim has, under the current statute, 14 days to understand what they've been served with, to try and find an attorney. And NVRDC, as far as we know, is the only organization located in the district that provides that representation for free. And the folks who we are aware of that got representation where they paid an attorney, that attorney did not specialize in crime victims' rights. So they're focused on that specific privacy issue, but aren't aware of all of the other rights that would impact a crime victim during that process. And so then they have 14 days to obtain whatever records are being sought by the moving party, review them, and then try and craft arguments to prohibit all or some of their records from being turned over. So while I would love it to be longer than 14 days, I think 14 days is really reasonable. I understand that perhaps opponents of our position might say 5 days would be more reasonable, or let's put the exigent circumstances or exceptional circumstances back in there. But what we know from those exceptional circumstances being in there is that crime victims were frequently not being served with the subpoena. And if folks were in any other type of litigation where a subpoena to pierce the privilege that they have with a professional was being issued, a civil case, what have you, and they weren't being provided with notice, people would be outraged. And so,
Ms. Eliza, sorry, we're going to have to move on. I'm very over time, but thank you very much. That is very helpful context, and we'll definitely continue having conversations with you and the other panelists as we move forward on this legislation to make sure we're getting that balance right.
Thank you.
Now I'd like to turn to my colleague, Councilmember Allen, for a 5-minute round.
Thank you very much, Chair Pinto, and thanks to everybody on this panel testifying as well. I'll just try to get through a couple of quick questions. To Ms. Silverberg, I wanted to thank you for raising the issue about the gap in services for survivors around coverage of HIV prevention medication. With my office, I'm looking forward to working with you to move that legislation forward. I think it's about giving a survivor the choice and not letting the cost of the drug make that choice for them. So I think that that's a really important issue, and I appreciate you raising this so that we can start to delve into this. I was going to first ask a little bit about Bill 25348, and so I'm not sure who I should direct this to, if it maybe is to Ms. Hanau, maybe Ms. Dimming, Ms. Silverberg. I'm going to let you guys decide who I should help answer this. But just want to ask if you could talk a little bit more about why victims who initially don't want to report may come forward later. Is it common enough to justify preserving evidence, and preserving evidence for more than, as we heard with the forensic nurses, the ability to hold that for 2 to 3 years? How critical is the perk to a successful prosecution should that victim and survivor years later decide to want to move forward? because obviously we've eliminated the statute of limitations for first and second degree sex abuse. So would love to turn that to you. Maybe Ms. Hanau, I'll kind of turn to you first, but if any of your colleagues want to jump in, please feel free.
Thank you, Councilmember Allen. Really appreciate it and appreciate your leadership with eliminating the statute of limitations for those sexual abuse offenses. But as you were asking, actually what we see in a lot of statistics, although even these may be a little skewed through underreporting, but we saw that the average age of child sexual abuse disclosures were actually when folks were around their 40s. So it could be decades even after child sexual abuse occurred. But we see that similarly, a lot of delays in reporting, even with folks that experience sexual abuse as an adult. And so for this reason, it is so important to be able to give that time for folks to process, perhaps to access medical or mental health support, to be able to get their lives, if you will, back in order and to get to a place of feeling safer, to be able to then even contemplate something as intimidating and confusing as a criminal legal system and whether that feels right to them or to find alternatives to that. There's so many decisions that have to be made for a survivor that, again, like having the pressure of having to report immediately can be overwhelming or completely dissuade folks to do that until decades after their assault. But so for that reason, it's helpful to have the statute of limitations be what it is now in the district, being that it doesn't exist. But also that preservation of evidence is helpful because you're able to tell a survivor with confidence, yes, you can delay this process until you're ready, but the evidence is there should you want it to still be there. And that can be such a difference for folks, especially in the media. We hear a lot about these cold cases that if you do wait decades until after the incident actually occurred, it is very difficult to go back and find witnesses and to find other evidence to corroborate everything that occurred. Of course, that is still possible, but it is definitely challenging and something that survivors have to weigh in making all of these decisions. But to be able to tell them, like, again, yes, if you choose to delay, the district has your back. We have processes in place to store this evidence safely, to notify you as to the status updates of that kit and anything else. That is us showing our actions that we're supportive of survivors doing this and not just saying generally, yes, go ahead and wait, but not having infrastructure in place to support them in making that decision. I'll allow anyone else to jump in if they want to.
I think you explained, you answered that incredibly well and spoke about how crucial that was, so I appreciate it. Ms. Dimming, if I can just follow one kind of thread that you had talked about in your testimony with my remaining time here. I wanted to ask if you could just elaborate a little bit more. You know, I think let's be very, very clear, the intention of having an increased penalty when children are present is coming from a place of protecting that child. I do believe that's the intent behind it. But you're highlighting things you think we should be thinking about and concerns around the way that we see the system playing out that may have an unintended consequence. And just with my remaining time, I want to make sure you had a chance to kind of help us think that through. Because again, I think the intent is absolutely around trying to help protect that child, but wanted to just see if you want to add anything more about what the experience is and how we kind of counter and how do we help balance that if the goal and intent is to protect the interest of that child.
I appreciate that. Thank you for directing the question back. So I think I liken this really to, and wholeheartedly agree that the intention here is really about protecting kids. I really just wanted to help expand the picture a little bit and share some of the data that we have, and there's much more in the written testimony around what we know about decision-making for, let's call it the adult survivor, around involving law enforcement and even help-seeking behavior when there's something related to their children being removed. So a call to child welfare, a mandatory report to law enforcement, and I would put this increased penalty in that same bucket. And what we know about survivor behavior is that they're less likely to seek out help if they know that there's going to be a report to child welfare. They're less likely to share everything that's going on so that they can get all the support that they need if they know there's going to be some sort of a report, some sort of an impact on their ability to care for their children. And so knowing all of that research, knowing that, again, we've got a really great disparity in how Black and brown children are treated in the child welfare system and by mandatory reporters, and I know some new laws have been passed about getting some more training around that. But all of that goes into decision-making of adult survivors that is influenced by their abusers around whether or not to involve law enforcement, about whether or not to involve any help seeker support services. And so when I think about all of the times that we have survivors, adult survivors who are charged with crimes, who are arrested, who are picked up on something related to the domestic violence, which happens at higher rates for Black and Brown communities, for LGBTQIA survivors in relationships, those folks are the ones most likely to have this enhancement and are most likely to be even more affected with this child enhancement already, and more likely to be affected by mandatory reporting and child welfare responses.
Yeah. Thank you.
So all of that wrapped together is the source of the concern related to that. There are a lot of things that we know do help children who are exposed to domestic violence, and I don't see those provisions in this bill.
Okay. I appreciate that, Ms. Deming. I know I'm over time, so thank you very much for helping expand on that. Thank you, Chair Pinto.
Thank you.
Thank you very much, Councilor Allen. Thank you to all of the witnesses on this panel. Really appreciate it, and we will be following up as we move forward on these bills. Next, I will call our next panel. We'll start with Elizabeth Olds, Savra Independent Expert Consultant, Natalia Otero from DC Safe, Mickey Charles, Public Witness, Camille Gales, Public Witness, Rakita Steele, Public Witness, Elizabeth Tang, Public Witness, and Melody Webb, Mothers Outreach Network. Ms. Olds, whenever you're ready, please go ahead.
Thank you. Good afternoon. My name is Elizabeth Olds, and I'm testifying in my capacity as the SABRA Independent Expert Consultant contracted with the district to implement SABRA 2019, the Sexual Assault Victims' Rights Amendment Act, and to evaluate sexual assault investigations and the overall system of care related to that law. I'd like to express my strong support for Bills 25-345 and 24-348, and thank Councilmember Pinto and Councilmember Allen for authoring them, and to the committee for moving these important bills forward. Although there are many excellent parts of both bills to choose from, I'd like to highlight a few provisions. My written testimony will contain a more thorough discussion of each. Progressive sentencing for misdemeanor sexual assault crimes and a process to make misdemeanor warrants extraditable work together and are essential to the district's ability to stop sexual assault offenders. In my evaluations of MPD's investigations in 2015 and 2018, I was appalled to read cases and hear recordings of interviews with repeat offenders where they described their carefully planned process for repeatedly assaulting people, typically women, such that it would only be a misdemeanor in a jurisdiction where they knew there was no meaningful penalty. Several stating that they could easily do one night in jail, which they anticipated as they knew that would be the extent of it, and where they could and do simply hop across the district line to Maryland to avoid arrest or the execution of a misdemeanor warrant. Offenders in this category who would be subject to progressive sentencing often have a mental health issue that may be driving their behavior, but the clear premeditation they display in committing these crimes in a serial fashion, it means they need to be restrained in a more meaningful way by the criminal justice system than the current law allows. Survivors of these crimes in particular also indicate how distressing it is to find out how low the penalty actually is. In addition to other provisions related to sexual assault, I strongly support extending or removing the statute of limitations on offenses that are often included in sexual assault cases. This change is essential to ensuring that those who report long after the fact or find their case solved many years later by a cold case unit can receive the justice they're due. Specifically, the sexual assault itself may be harder to prove many years later or too difficult to succeed in court for a host of reasons, including the biases that juries and judges sometimes have about sexual assault, or the offense was far more expansive than the sexual assault itself. Turning to the Ensuring Safe Forensic Evidence Handling for Sexual Assault Survivors Amendment Act of 2023, this bill addresses a significant gap, as has been previously described by several people today, in the system of care for survivors who do not wish to engage with law enforcement or simply want more time to determine their next steps before they engage the criminal justice system. As Aaron Pollitt with DCF&E has described, each year approximately 200 to 250 survivors seek medical forensic care and choose to wait to report to police or ultimately do not do so at all after carefully considering their options. And that's the key part, allowing them to carefully consider those options. Those kits need to be stored safely and for as long as possible to allow them to make those determinations when they feel ready to proceed. Despite concerns about the Department of Forensic Sciences as a whole in recent years, DFS's Forensic Biology Unit is a high-functioning unit within DFS that has appropriately and accurately tracked and tested the approximately 250 evidence kits submitted that are related to law enforcement reports for testing each year since 2014. Therefore, I support storing these kits at DFS, as well as the proposed audit of those kits to ensure transparency and quality assurance. Critically, this is a non-law enforcement-based solution that ensures safe and efficient handling and tracking of this important evidence. I also strongly support this legislation's more expansive definition of medical forensic care. Currently, the right to medical forensic care as articulated in SAVRA is limited to the PERC itself, meaning bare evidence collection using the collection box, rather than access to medical forensic care with all that it entails. I would suggest that we ensure that the right described in SAVRA and DC Code Section 23-1908 be made consistent with this new definition. Finally, I also want to say that I support DCF&E and NVRDC's proposal regarding payment for HIV prophylaxis in addition to the HIV testing provisions in Bill 25345. As I said previously, I'll be submitting additional written testimony for the record before it closes on October 2nd, and I'm happy to answer any questions that you might have. Thank you.
Thank you so much, Ms. Olds. Really appreciate that. I'll have some questions for you when we finish this panel. Next, we'll hear from Natalia Otero from DC Safe. All right, Mickey Charles, public witness.
Hi there, I'm here on behalf of Mickey Charles. My name is Kayla Friedland. I am a Ward 1 resident, and I am here to oppose the Accountability and Victim Protection Amendment Act of 2023. Oh, sorry, didn't start my video. Hello, my name is Kayla Friedland, and I'm here to oppose the Accountability and Victim Act Protection. I want to really name for the council that resources change conditions, and this has been proven time and time again. If one more cop, if one more criminalization would have gotten us closer to these solutions, then we would have seen it already. And so I have done a lot of work with the Georgetown Black Survivors Coalition. I was the one who founded it, as well as continued its work, particularly uplifting Black, femme, and women survivors of sexual violence and sexual harm. And the consistent narrative that pops up around it is the lack of willingness to be involved with systems, right? And that was only talking about the Title IX system, not even talking about MPD or any other kinds of policing agencies. And so moving on further into those, I've also had a lot of experience interning with the Collective Action for Safe Spaces, working on reducing crime and interpersonal and sexual violence. And what we've really found is that really the people who need that kind of protection are not necessarily the average people walking around, but the people who would already be criminalized if caught within these situations, right? So if we're looking for survivor safety, if we're looking for survivor wellness, that means decriminalizing sex work, that means decriminalizing drugs, so that those folks who are already at risk of criminalization don't get further bogged down by all of these different inner workings in the system. I also want to name that pretrial detention is not prevention. I do mutual aid around the city, and so I'm pretty on the ground with the work. I have little children who I take care of every week at our mutual aid distribution. Their father was held in CCB for pretrial detention, and within a few days, his body was found. And so those little girls are now growing up without a father. And I see them weekly, and I see their faces, and I know their reality, right? And so when we're talking about these things and we're talking about these numbers, I just want to emphasize that these are real people. These aren't just deaths at CCB. These are people who have families, right? And we are innocent until proven guilty, right? So that means that us being caught up in the system should not be a death sentence. That should not mean that we have the ability to never walk out again when we haven't even been convicted of anything whatsoever. And so I really implore the committee to take some innovative stances, some proactive stances instead of more reactive ones. Thank you.
Thank you so much. And thank you for sharing that heartbreaking story. We will now hear from Camille Galles, public witness.
Hello, my name is Camille Galles, and I am a small business owner, and I've been living in Ward 1 for over a year. I'm testifying today because I strongly believe that expanding pretrial detention and expanding criminal penalties does not make our community safer. The Accountability and Victim Protection Amendment Act will only further increase the violence in our communities. If we actually want to address community harm, we should focus resources on caring for and supporting the survivors of sexual assault. Detaining our loved ones, as I said, just adds more violence. As others have said, we know that the DC jail is an extremely dangerous and harmful place. Last year, 8 loved ones died in DC jail custody, and at least 2 loved ones have died this year. So we need to invest in the people of the DC community, not just in more ways to punish them. I think there are so many ideas that we can try instead, like universal basic income, investing in unarmed violence interrupters, and supporting the people who have been harmed. Pretrial detention does not work. It increases our loved ones' chances of being arrested, and I have seen firsthand how it ruins lives. For the past year, I've been a volunteer with Court Watch DC. This organization observes DC arraignment hearings to hold judicial actors accountable and to provide support and mutual aid to our loved ones with participatory defense resources. So over the past year, I have watched judges decide to hold dozens of loved ones pretrial, many of them who are sole caregivers for their children or who have full-time jobs. So, when our loved ones are held pretrial, they can't care for their families, they can't earn a living, and they can't contribute to safer communities. The expansion of the criminal legal system does not make me feel safer as a DC resident and business owner. It just makes it easier for the police to surveil and target already criminalized loved ones. A better strategy for victim protection would be to share more resources with survivors. I know that we can build a safer community here in DC, and that's really important to me. To do that, though, we need to address the root causes of violence, like the lack of resources and the lack of affordable housing in our communities, instead of expanding pretrial detention. Council members, I urge you to reject these carceral solutions and to instead invest in new solutions that allocate resources to our community members instead. Thank you.
Thank you so much. Next, we'll hear from Rakita Steele, public witness.
Good afternoon. My name is Rakita Steele. I'm a native Washingtonian and a mom of 3 under 4 years old. I'm a formerly committed DYRS youth, and I also work with Harriet's Father's Dreams as a volunteer. Recently, I was arrested on a domestic violence case where I was arrested after going through a health crisis and a mental health crisis, not having help for my children while I was going through my health crisis. Instead of helping me, the police chose to arrest me. That caused more trauma after I just had a baby 7 months prior and also had a 1-year-old and a child that was in school. Instead of ordering individuals to seek mental health treatment or drug treatments, we are ordering people to sit in jail and keep youth detained because you do not know why we act the way we act, instead of someone to trying to find out what is going on in our community. Then they become institutionalized because you have no choice to. Plus, down the line, they're released with no therapy, no resources, but a probation officer looking for the next reason to send you back to jail. Then you have people who are going through grief and loss because people cannot afford to bury their loved ones and will do anything for their families. My brother, Delano Martin, was killed by Park Police March 18th. And because it was an officer involved shooting, and they shot him 6 times in his back. Washington, D.C. would not provide my family with any funds to bury my brother. That brought anger to my family also, who loved him, and we was already struggling to make ends meet. We cannot bring the National Guard into police children, then there will be even more police killings. I have a friend who was also killed on Minnesota Avenue the end of last year, and she turned to using drugs, lost her mind, and started committing crimes. Till this day, because she's been arrested, she do not remember doing any of them crimes and was just sentenced to another 8 months in jail, away from her 2 kids who are under 2, with no other resources, no mental health treatment, and they acknowledged that she had mental health. She also had no prior criminal record. So is it right to keep giving the jails money when your community needs better resources and jobs and people that really wants to help the community, not to have degrees? Thank you.
Thank you so much. Elizabeth Tang, public witness.
Hi, sorry, I'm trying to figure out how to turn on my video.
Should be an option at the bottom left of the Zoom.
I only see a button that says mute or unmute. I don't see a video button.
Okay, well, I'm sorry about that. You're welcome to proceed with just your voice if you'd like, or we can move on to the next witness and someone from my team can call you and try to walk through it if you'd like to turn your video on and we can come back to you.
I'm happy to just testify, that's fine.
Okay, go ahead.
All right, thanks. Chair Pinto and committee members, my name is Elizabeth Tang and I live in Ward 1. I'm testifying today to oppose the council's recent crime bills, including Bill 345 and Chair Pinto's new Secure DC plan announced this morning, which expand criminalization under the guise of public safety. First and foremost, council must not expand pretrial detention. Let's look at the facts. Pretrial detention does not actually work, quote unquote. It does not ensure that a person will appear for trial, but it does increase your chances of being rearrested or getting a longer sentence. Detention is also not necessary to prevent violence. In DC last year, only 2% of people who were released pretrial were then rearrested for a violent crime. And pretrial detention ruins lives, as others have said. It can make you fall behind in school or lose your job, your health insurance, housing, and even custody of your children. Unfortunately, Chair Pinto expanded pretrial detention this summer for both children and adults. Right now, adults can be held pretrial for any so-called crime of violence, even if it is not actually violent. Let's say you are illegally arrested at a protest, which we know happens a lot in DC, and let's say you wriggle your hands while being handcuffed. Or let's say you don't have enough money for food or rent and you pickpocket somebody on the street to survive. These are considered crimes of violence in DC, and so under the emergency bill, you will be detained pretrial. Is that public safety? The mayor's crime bill, Safer Stronger, is no better. Let's say a kid goes into an empty house through an open window with the intent to steal something, but then feels bad and doesn't take anything. Let's say a kid takes an empty car with the keys left inside it for a joyride. Let's say a teenager is pulled over by a cop while driving. They panic and try to drive away because they're afraid of being hurt or killed. Under the mayor's proposal, all of these children will be detained pre-trial. Is that public safety? There is more. All of these crime bills, including Bill 345, would increase the surveillance state, create new crimes, and would keep people locked up longer, even though the data is clear that longer sentences are not a deterrent. Now, parts of these bills do target domestic violence, but they don't actually do anything to prevent DV or support survivors. I am a survivor of multiple sexual assaults, and I'm an advocate for survivors of sexual assault and domestic violence in my day job, and I know that what we need is not this. We want more resources for victims, regardless of whether they report to police, because many victims do not want to send their intimate partners to prison or their family members. They know that involving cops will only escalate the abuse, or they know the cops could arrest them instead. What survivors need is housing, childcare, and other financial and material supports to leave an abusive situation safely. We also need more prevention education, especially in our schools. Research shows students who learn about consent and healthy relationships in K-12 are less likely to be a victim or an abuser or assailant in college. That is powerful. I have done many workshops for students in DC's public and private schools about these topics, and many students and even staff members are unable to identify common behaviors as sexual assault or dating violence. Relevant to this bill's strangulation provision, one DCPS administrator I spoke to said that they were surprised to learn that choking during sex requires consent. We need this prevention education for everyone. I wrote a report about non-punitive, victim-centered policies to address gender-based violence that will be in my written testimony, and that includes removing police from schools. Let me end by saying this. 2 years ago, Council, you all funded a report by the Police Reform Commission, which found, quote, violence is most pervasive where Black and brown residents have the least access to wealth. So listen to your own report. Do not pass these crime bills and address the root causes of violence instead. Invest in community resources and invest in actual prevention that will work. Thank you.
Thank you very much. Next and last on this panel, we will hear from Melody Webb from Mothers Outreach Network.
Chair Pinto and committee members, thank you for the opportunity to testify today. My name is Melody Webb. I'm founder and executive director of Mothers Outreach Network and DC Guaranteed Income Coalition, a mother, a DC native, and lifelong resident. Mothers Outreach focuses on keeping marginalized Black families together through supporting impacted DC Black moms to transform government income and child welfare policies with legal and policy advocacy and community organizing. Today, as you consider this bill, I ask that you support funding for evidence-based poverty reduction programming as an intervention for criminal legal involvement through funding guaranteed income programs for the families at the margin who are highest risk for involvement in criminal activity through passage of the District Child Tax Credit, Bill B250190, and or through funding guaranteed income pilot programs. Our mission is to achieve a simple solution to poverty, as Dr. King called it, a permanent guaranteed income that provides unconditional, regular payments, no work or other strings attached, to lift the 16% of our DC neighbors living below the federal poverty line above it. We know from studies that our neighbors more prone to gun violence are those who have been caught up in and failed by multiple public systems. Poverty has consequences that can include criminal involvement, along with family destabilization and family separation. Thus, we support guaranteed income approaches to crime that I will discuss momentarily. As background, our organization has deployed multiple guaranteed income strategies. First, we're nearing the 6-month mark of our own private philanthropy-funded guaranteed income cash initiative for moms whose children are CFSA involved. We provide funding for 3 years at $500 a month to a handful of families currently, and are funded to grow to 25 by the end of this year. Also, our 3-year-old coalition consists of DC impacted residents, workers, and allies. And in 2021, with Councilmember McDuffie, we pushed for an anti-poverty racial justice effort that resulted in the passage of a $1.5 million program for guaranteed income funded, renewed for 2023, and funding the Strong Families, Strong Futures program, a guaranteed income pilot for new and expectant mothers in DC. That was historic and should be followed by new measures to address the determinants of crime. We urge you to pursue 2 primary policy paths to guaranteed income for all living below the poverty line. Path 1, a route with a new set of guaranteed income pilots, growing the current Strong Families program that focused on families that are known to the city and others as being troubled. And path 2 is a faster, broader, and direct route, recently introduced legislation, the District Child Tax Credit, and Companion Bill Financial Support for Families with Children Act. We urge support for moral and effective economic policies targeted to persons, perhaps the 100 or more specifically known to be involved or at risk of involvement in the city. It's time for us to provide a guaranteed income to such families as a preventative and intervention measure to address criminal activities. In this, we joined the National Institute for Criminal Justice Reform in recommending a guaranteed income program, whether it's for 200 people, for $750 a month, or larger. Rather than quick soundbite ready policy fixes with dubious results like a youth curfew, instead let's invest in people at risk with proven poverty intervention and proven sustainable prevention, evidence-based strategies. And guaranteed income is an evidence-based strategy. After more than 100 pilots across the country have demonstrated that families experience less stress, food and housing insecurity, let's act. We know that, as reported by the Urban Institute, families participating in DC's basic guaranteed income pilot Thrive, as one of the early pilots around the country, experienced less instability as a result of participating in the pilot program. As an attorney who has represented parents and families to navigate the consequences of poverty-driven involvement in the city's child welfare system, we've seen the failure of our systems to address poverty and its consequences. We see the failure to distribute CFSA's Flex Cash Fund and failure to provide youth and family unification program vouchers to families, then laying blame at the feet of cash-strapped parents. We can do better in the capital of the wealthiest nation in human history. Washington, D.C. is on the cusp of creating a guaranteed income program for all. We have a number of amazing programs that should be expanded. So we ask you to expand the Strong Families pilot for new and expectant mothers to include a broader variety of families, whether it's $20 million of funding, with some of that going to pilot payments and others to help people mitigate the effects of lost benefits. We request funding for the two bills, as I also mentioned, and I want to just quickly point to, there are a number of models for guaranteed income pilots to address poverty as a determinant of criminal legal system involvement. I'm almost done. And those models are Just Income GNV in Gainesville, Florida, designed and administered by formerly incarcerated people for 115 justice impacted people to receive $1,000 a month and $600 thereafter the first month. Community Love Fund, which is a pilot program that provides funding for women. And finally, here locally, Arlington's Guaranteed Income Pilot provides $500 a month for 18 months to 200 people. And several of those people are individuals who recently are incarcerated. DC is on the cusp of creating a guaranteed income for all, and
Ms.
this
Webb
should be looking to help do that. Thank you so much.
Thank you very much. Appreciate those ideas. So that completes the witnesses on this panel. I do have a couple of questions for some folks. So I want to start with you, Ms. Olds, and you talked about this very concerning information that you've been hearing, and I want to clarify for the record, when you say folks know that they can commit these crimes in DC and not face much consequences, is that information coming directly from defendants themselves, or where have you heard that mentality be articulated?
Sure. So for both of the evaluations the formal evaluations that I've done so far of the sexual assault unit's investigations, I've been able to listen to both survivor and suspect interviews. And in suspect interviews related to serial misdemeanor offenses, there was a particular subset both times that made it very clear to the detective that was interviewing them that it's statements from multiple suspects that, you know, for example, one said he lived in Maryland with his mom. He would go home every night after being in the city, effectively committing misdemeanor sexual assault day after day, and that he knew that was specifically, number one, he needed to go across the Maryland line, and number two, that the penalties were such that it was not a problem. And that's just one as part of this pattern, but it was directly from them.
Okay, thank you so much for sharing that. And is that kind of to your earlier point of the interrelatedness of the extraditable offenses coupled with the progressive sentencing being able to target that behavior?
That's correct. The two go hand in hand, given the geography of the district. It makes it very easy for people who are this aware of what the legal limits are and are able to either, as some have said, you know, I can do one night in DC jail, that's, you know, or one night in C10 and be released the next day. That's not a problem for me necessarily. And coupled with the idea of leaving the jurisdiction as another way to evade accountability.
Thank you very much for that. That's very helpful perspective. Kayla, I want to ask you if you're still here. Thank you for your testimony, and I'm very concerned about the troubling incidents that you cited and the deaths that have happened at the DC jail and the real human cost and the families affected by those incidents. You talked about other interventions that may be more effective, and you mentioned, with sex work or decriminalization of drugs. Can you articulate a little bit what you think would be most effective there as better preventative tools?
Sorry, can I clarify your question first? Preventative tools with regards to trying to limit the like the rates of sexual assault in the city, more particularly?
Right. So my apologies. As it relates to this specific bill that we're talking about today, which doesn't talk about pretrial, when we think about legal protections for victims and for sexual assault survivors, I was hearing your testimony to talk about other interventions that may be more effective. And so I was wondering if you could articulate what you think those would look like.
Yeah, absolutely. So for the first part that I brought up, decrim sex work, it's a bill that's been proposed countless times to this council, and I'm sure will continue to be proposed, but basically sex work is work. And so when we understand that people who are sex workers, particularly in the city who are already criminalized, do get harmed, that they are often the ones who actually get arrested, right? And this is proven by stats. We know this based off of any sex workers you can run into, meet in the city. Their likelihood of coming up against violence, whether straight from police, right? Police assaulting them, or it's based off of their interactions with people who want their services. We know that sex workers are at some of the highest risks of sexual harm, and that is additionally compounded upon by the fact that oftentimes these workers are of Black or brown descent, right? And so there is that whole portion, right? And if we understand that sex workers will always be more at risk, particularly because they already are, quote unquote, doing an illegal act, right? If you're committing a crime, then you are just as at risk as whoever is harming you, right? And the same goes for those who are convicted of drug crimes, right? And so, for example, my best friend, she died by overdose. And so she did not get the help that she needed, particularly because the people around her were terrified of the repercussions in which if they went to the police, right? Because all of a sudden, your crime is more important, and right, crime in itself is something we define, but your crime is more important than the harm that's actively being caused to you. And so with both of these bills, right, these are bills that are actively being proposed to you guys. So those bills, decrim sex work and decrim poverty, need to be passed in order to start creating even those baselines of safety where we're seeing every human as full humans, and particularly not disadvantaging people based off of their socioeconomic status or their dependencies.
Okay, thank you very much. Thank you for sharing those ideas, and thank you to all on this panel. And I appreciate, sorry we didn't have time to get into it, but the other ideas around increasing education and awareness at our schools and in other spaces around sexual assault, which I think is going to be an important part of this puzzle, and the ideas about the need to have income stability for our residents, and recognizing the intersection of those issues with crime is, of course, very important to our larger goals as a city, in addition to the bills that we're contemplating today. I will turn to Councilmember Allen for a 5-minute round.
Thank you very much. I'm going to try to focus my questions on Elizabeth Olds, if I may. Ms. Olds, appreciate your testimony. I'm going to focus in on our bill related to the storage of our kits. Are there any national best practices for PERC storage, and specifically for anonymous kits, specifically that you want to highlight or you believe that we should be taking a close look at?
Yes. The main guideline is one that this bill meets, which is it should not, as I think Aaron Pollitt mentioned this, it should not be with a private hospital or private SANE program, partly because of capacity issues, but also because of potential chain of evidence issues. There's guidance that was issued by DOJ in 2017 that I'm happy to forward as well. But the specific piece of it was that it needs to be stored in a climate-controlled, appropriately tracked, non-law enforcement based, ideally non-law enforcement based facility. There are states that do store non-report kits with law enforcement, Texas being one of them, but that goes against national best practices.
Got it. That's helpful. And right, because under this bill as proposed with DFS would be in charge of that storage, that would be both meet what you're talking about in terms of long-term storage, climate controlled, but also control of chain of custody from the standpoint of being able to, should that be the route that happens later on, having that chain of custody from a prosecutorial standpoint, correct?
Yes.
Okay.
It would.
One of the
in a very direct way.
Yeah, thank you. One of the questions I'd asked kind of in an earlier panel was around, is there ever a time in which a PERC kit is destroyed, an anonymous PERC kit? And from your opinion, should DFS, while we would put in place a very lengthy time limit, exclusive of that time expiring, is there ever a reason that you can think of where DFS should be able to destroy the PERC? Like, for example, if the victim wishes for it to be destroyed, is that something that should be allowed?
Yes, I think if the victim, it effectively is, because they have not taken the step to report to law enforcement, it's not evidence in a case yet, it is effectively something that's in their control. They should be able to request that it be destroyed, much like DCF&E is informally doing currently, reaching out at various points and saying, do you want this to be destroyed? Barring the survivor saying, I want my kid destroyed, I don't want to even contemplate this existing anymore, there shouldn't be a decision taken by DFS to destroy it prior to whatever time limit is provided. Got it. Okay. The legislation also expands your duties to include auditing the storage of anonymous kits. Just want to get any thoughts you have around that. What should the independent expert consultant be auditing for, in your opinion? Any comments you have regarding that recommendation? Sure. I've done 2 different audits of DFS and OCME in the past in terms of kits and specimens that are part of reported cases. And the main tracking pieces to be looked at are a process track from the point of the kit being taken at DCF&E all the way through it arriving at DFS, making sure every kit arrives, making sure there's a solid tracking system that doesn't have any inadvertent gaps, and then making sure that wherever they are stored is physically sufficient. Because I think that can be one of the risk factors that storing it at DFS will solve. And so it really is a matter of following the kits all the way through and making sure that there's a way for that to continue after the audit as well.
Okay, great, thank you. And last question, how does MPD currently preserve PERCs for reported cases, and are there any parallel or elements that you feel need to be mirrored for DFS or vice versa? Any changes you think that should be made for the reported case and the preservation of those?
MPD is moving kits from DFS to from DCF&E to DFS, and then after testing, those kits are then sent to MPD's evidence warehouse for storage. They are stored like all other MPD evidence according to their evidence storage general order. And I think the main thing that should be mirrored is storing these by the barcode or by a barcode to make absolutely sure that tracking is almost infallible. And so I think MPD's evidence warehouse tracks these sufficiently. And I think with the kits already have a barcode on them. And so that will be a way to make it easy, I think, for DFS to implement a tracking and storage system along with the PERC database that already exists.
Got it. Okay, excellent. Thank you very much. I'm out of time, so thank you very much. Thank you, Madam Chair.
Thank you very much, Councilmember Allen. And thank you to all of the witnesses on this panel. We are now going to move to our final public witness panel for today. We'll hear from Masuma Hussein, DC Volunteer Lawyers Project, Arthur Tameldon, Public Witness, Laura Warby, Public Witness, Alex B., Public Witness, Benjamin Brooks, Whitman Walker Institute, Charles Hopkins, Voice for Second Chance, and Kiana Johnson, Public Witness. Masuma, when you're ready, please go ahead.
Good afternoon. Thank you to the committee for the opportunity to provide testimony today in support of amending the criminalization of the Non-Consensual Pornography Act of 2014. The proposed amendments are found in Title 14 of the Accountability and Victim Protection Amendment Act of 2023. My name is Masuma Hussein, and I'm a supervising attorney at the DC Volunteer Lawyers Project. DCVLP is a nonprofit organization that was established in 2008 to provide direct legal and advocacy assistance to low-income survivors of domestic violence. Non-consensual pornography includes the distribution of a private sexual image to cause harm to the person depicted. As this committee well knows, non-consensual pornography is a form of domestic and gender-based violence that is used by abusers as a weapon to shame, embarrass, degrade, control, and punish. The impact on survivors can be devastating. This committee passed the original act in 2014 because legal remedies at the time were inadequate to protect survivors of non-consensual pornography or to deter perpetrators. The act provides that it is unlawful for a person to knowingly disclose one or more sexual images of another person when, 1, the person depicted did not consent to the disclosure, 2, there was an agreement or understanding between the person depicted and the person disclosing that the image would not be disclosed, and 3, the person disclosed the image with the intent to harm the person depicted or to receive financial gain. The amendment being considered by council today relates to the agreement or understanding requirement. The agreement or understanding requirement is unnecessarily restrictive and has led survivors to being denied access to civil protection orders. This is because it is often difficult to prove that an agreement or understanding between the parties existed. In fact, some survivors may not even be aware that an abuser has access to compromising or sexually explicit images until after the abuser discloses those images, causing survivors extreme emotional distress and trauma. Essentially, the current statute provides abusers a loophole and excludes many survivors who otherwise would have been entitled to relief. DCVLP worked with one such survivor. Ms. Doe came to DCVLP seeking representation for a civil protection order case. The opposing party in the CPO matter was concurrently charged with unlawful disclosure for posting flyers on buildings and bus stops that included sexually explicit pictures of Ms. Doe with accompanying language stating that Ms. Doe had herpes and people should get tested. Understandably, when Ms. Doe encountered these flyers in person, she was distressed and humiliated. However, critically at the time, Ms. Doe did not know how or when the abuser obtained the sexually explicit pictures, since she had not shared those pictures with him. Therefore, no agreement or understanding between the parties ever existed. The judge presiding over the criminal matter raised this very point and then indicated that she would have found Ms. Doe's abuser liable for unlawful disclosure if the statute had been written differently, but could not. The proposed amendment this council is considering today would require that the person disclosing the sexual image knew or consciously disregarded a substantial risk that the person did not consent to the disclosure. The change will close a loophole that has hampered prosecution of these cases and put the focus on the defendant's mental state and lack of consent in the distribution of the image. According to a 2022 Congressional Research Service analysis, the majority of states make dissemination of non-consensual pornography a criminal offense if the defendant acted with some level of knowledge, either actual or imputed through recklessness or negligence, that the depicted person had not consented to the disclosure. This includes Maryland and Virginia. The unlawful disclosure statutes of both states cite the abuser's mental state, that the person disclosing the images knew or did so with reckless disregard, or knew or had reason to know. The proposed amendment is also aligned with the standard endorsed by the Uniform Law Commission. One of the elements is that the person disclosing the image knew or acted with reckless disregard for whether the depicted person consented to the disclosure. CVLP supports the proposed amendments to the unlawful disclosure statute, which will replace the agreement or understanding requirement with a less restrictive knew or consciously disregarded a substantial risk that the person did not consent to the disclosure. CVLP is grateful for the opportunity to provide testimony, and we welcome further questions.
Thank you very much. Next, we will hear from Arthur Timeldon, public witness. I can't hear you. It looks like you're off mute, though. Try again. Mr. Timeldon, maybe I can ask if you can exit and come back on, and we'll go to the next witness. We'll come back to you next. Okay, thank you. Laura Warby, public witness.
Good afternoon. Thank you for the opportunity to be here. My name is Laura Warby. I live in Ward 5, and I'm a family nurse practitioner currently working with in DC as a forensic nurse examiner caring for survivors of sexual assault and intimate partner violence. Although I work with DCF&E, I'm here as an individual. Our goal as forensic nurses is to provide trauma-informed care with a priority on safety and reducing harms, respecting the victim survivor's autonomy to determine the care that they wish to receive. As you've heard from my colleague, we offer forensic medical history, physical exam, documentation of injuries, coordination of treatment, medications to prevent pregnancy and sexually transmitted infections, and the physical evidence collection if the patient desires. And we work closely with our advocacy partners to provide safety planning and ongoing emotional and legal support. I strongly support the elimination of the statutes of limitation for reporting sexual offenses and the provisions that would implement the system for receiving and storage of the physical evidence recovery kits that we've discussed at length. So I won't go through all of that, but I will say in my experience, many patients need weeks, months, or even years to make that decision. And the question has come up, what holds people back and what might change their mind? And I think a lot it's so many decisions to make. We have a timeline of 5 days in which we can collect that evidence, and people just need time to think about what makes most sense for them. And I think over time, we have cultural changes. We have, like with the abuse in Catholic institutions, where as more people come forward and people begin to see that their experiences are taken seriously, that they may want to come forward. And what we're doing is preserving that opportunity as time goes on for people to figure out what's going to be most healing for them. Quickly, I do have 2 recommendations regarding the non-fatal strangulation. I'm happy to see that recognized as the extreme threat that it is, but the language in this piece of legislation confuses strangulation and suffocation and would be strengthened by using the language that's in the Safer, Stronger Amendment Act of 2023, which includes specific references to the kind of history and physical exam findings collected by forensic nurses, which would be relied upon in prosecution under the provision. Also, I do not support the HIV testing of individuals for similar reasons to what others have mentioned, including the very short time frame that we have to offer people the medication, and the status of the assailant is only one of several factors that we use as we follow a CDC guideline for helping with risk assessment as patients navigate that decision. And really, most people do not have severe side effects from this medication, and the best way the district can help is with solving the cost problem for people to make that an option. Thank you for the opportunity to testify.
Thank you very much. Appreciate that. All right, let's try going back to Arthur Tabelden. Are you with us? Okay, we'll come back to you. Alex B., public witness.
Yes, as we turn the so-called crime problem over in our minds, we have to ask also a problem for whom? Because maybe the system is really operating just as it was designed. The school to prison pipeline, starting in the DC schools, which are almost all Black, 60 to 70 years after supposed desegregation. And now we think of DC as having a progressive system with no cash bail, but really we have this misleadership class with prosecutors who are trying to add back pretrial detentions and make up new crimes. Haven't we learned from the Willie Horton ad with Bush and the Clinton-Biden crime bill in the 90s? Maybe like murder, politicians trying to win votes off of crime fears and tough on crime and locking up Black men is just an evergreen thing. We have a Nepo baby in here from Greenwich, Connecticut, chairing a $2 billion budget oversight as a wealthy white woman trying to lock up more Black men and apparently, admittedly, doing bidding for her former prosecutor office employer by writing or introducing their bills for them like a new strangulation crime. This is ridiculous. Getting more young and women elected is great, but not when they're doing harm to Black people. But like Southeast, then how can you have people on the top? The Brooke Pintos, lawyers, judges, the Northwest, there wouldn't be any proceedings for the courts without this permanent lower class. So again, I ask, isn't the system white supremacy operating just as it is designed, while the council members and the committee staffer are here making $160,000, $170,000 putting these ridiculous bills? And then there's a summer recess and you come back with this here. Now, one recent sentencing in front of Judge O'Keefe hit me, and Free Minds Book Club was observing on that one because the public defender went through a PowerPoint and showed a radius where there were this many shootings and homicides in a circle around this boy's home growing up. He lost X number of friends and relatives to gun violence, hearing gunshots at home. Just statistically, the numbers, violence of what he was exposed to, not through fault of his own, but by virtue of where he was born in DC. And many of us are lucky enough not to be in this situation. I grew up on Long Island, or Miss Pinto didn't choose to be a new crimes and penalties to make it harder for people who do not have this white privilege, because sometimes people just do what they know, what they see. The only strangling I've seen, luckily, is on The Simpsons. I don't believe someone about to choke someone will say, no, the sentence for this crime is increased. Let me just cool off and count to 10. You're probably going to add more choking down the road by increasing the time in jail, making their job possibilities in life worse. Many chokings aren't even being reported to the police because cops keep killing Black people. You need to look more at an 8-hour hearing on that. That's more of what needs to be done. And how about the CJCC idea for $750 a month income to some low-income Black families? This is the kind of thing that we need for our solutions, instead of making this into a political issue like the border, where people still come over the border. People are still going to commit murders anyway. What would Harriet Tubman do? All power to the people. Thank you.
Thank you. Benjamin Brooks, Whitman Walker Institute.
Good afternoon, honorable council members, Chair Pinto, and assembly guests. My name is Benjamin Brooks. I use he, him pronouns. I'm the Associate Director of Policy and Education at Whitman Walker Institute. Many of you know Whitman Walker as the district's trusted community partner in the fight against HIV and as a safe and affirming environment for the LGBTQ+ community to receive much needed health care. Whitman Walker has been a nationally recognized leader in HIV treatment and prevention for 4 decades. Last year, in 2022, we provided health care to 3,147 people living with HIV. We serve about 22% of the district's reported HIV positive population, many of whom are low income or members of otherwise underserved populations. In 2022, 83% of our patients living with HIV were virally suppressed, which is a success rate much higher than the national NDC averages for people living with HIV. In 2022, we provided rapid HIV tests to 7,569 individuals. Additionally, Our clinicians and lawyers are partners with the DC government in victims services, partnering with the Office of Victim Services and Justice Grants in delivering mental health care and legal services to victims and witnesses of violence. We are grateful to continue to partner with the Council in supporting the health and rights of district residents, including today at our grand opening of the new Max Robinson Center in St. Elizabeth's East campus. I'm here to testify on Bill 250345, the Accountability and Victim Protection Amendment Act. As written, Whitman Walker opposes the bill. It's good to see Mr. Melvin's audio appears to be working. We are concerned that the bill's amendments to Title IV, access to HIV information for crime victims, does not follow the latest evidence of HIV testing, treatment, or prevention, while proposing to substantially erode the due process rights of people in the district charged with sexual assault. From our expertise in HIV prevention, I want to make clear that the proposed amendment to allow a prosecutor or victim to request a court-ordered HIV test is unlikely to help victims of sexual assault make informed decision about their healthcare needs. The precatory text to the amendment says that it will allow for testing of victims charged with sexual assault for HIV at the time they are charged, in order to provide victims with information about their attacker's HIV status at an early stage so they can make informed healthcare decisions. This is, of course, a primary reference to PEP, or post-exposure prophylaxis for HIV. The standard of care for victims of sexual assault is treatment with antibiotics for chlamydia, gonorrhea, and trichomoniasis, as well as providing emergency contraception. Post-exposure prophylaxis is also routinely started, but as others have noted, needs to be started within 72 hours. While most of this list is managed with a single treatment, PEP is a 28-day course of medication to prevent HIV. One apparent issue with the proposed amendment is that the accused charged defendant might have recently acquired HIV, in which case the virus may be in the window period before the HIV antibodies are able to produce sufficient numbers for an accurate test result. Please note that generally the risk of a false negative of the latest HIV tests are very low, but in particular, if someone is recently affected, the false negative rate can be as high as 8% after 4 weeks. To ensure then that a victim would not need to take PEP requires 2 tests of the charged defendant 4 weeks apart, which of course is the length of time the person needs to be on PEP in order for it to be effective. It seems clear from this very simple math that the proposed amendment clearly cannot provide the information necessary to the victim of sexual assault to make an informed decision within the time frame necessary to prevent HIV transmission. The clause in this bill does not add surety to a victim's status as to PrEP. On the contrary, the proposed amendment suggests that the victim would want to make a healthcare decision based on testing their accused perpetrator, something which we doubt very much. It is important to note that PEP is an extremely effective HIV prevention modality. The risk of HIV acquisition after a single exposure does vary considerably across multiple factors, ranging from 0.5% to 3.38%. This is very low risk, but PrEP reduces that risk by 99% to essentially zero. Whitman Walker's own chief medical officer, Sarah Henn, reports that they have never in all their years of practice linked a case of HIV to failed PrEP. Compared to the high effectiveness of PrEP with the considerable uncertainty in the proposed approach, we seriously doubt that this process would be of use to victims. It seems likely to subject alleged perpetrators to violations of their bodily autonomy without due process protections. It's my pleasure to present testimony to this council, and I welcome questions from the committee. Thank you so much.
Thank you very much. Next, we will hear from Charles Hopkins, Voice for a Second Chance.
Thank you, Chairperson Pinto, for this opportunity to testify on Bill 225-345, the Accountability and Victim Protection Amendment Act of 2023. I'm taking exception with the aspect of the bill that would eliminate and extend the length of the statute of limitation for serious crimes. By eliminating the length of statute of limitation would mean that individuals who committed serious crimes as children, and in DC in particular, this means juveniles, would be charged at any time in their lives. I can tell you that as a returning citizen, I and many others have spent the majority of our lives in prison. Many that I now work with were voiced for a second chance, committed serious crimes while they was juveniles, and are now parents and responsible parents, neighbors, citizens in this city, because they've been given the opportunity to heal. When you look at this aspect of their lives, it would be traumatic for you to come back and say, after a person been out 15, 20 years, say, oh, you committed a crime when you was a juvenile, and therefore you will be charged with it. This would, in fact, impact on the community and this person's life dramatically, right? We also recognize that we don't really appreciate how much trauma many youth carry in the city. And this is something that we don't look at as far as the traumatic experiences that a lot of children go through. I think Alex B just testified about a study that was done where they showed the person living in an environment that was traumatic. So the foregoing conclusion is that you live in this traumatic environment, and no opportunities that you're going to suffer and you're going to respond appropriately. We have not committed a significant amount of quality treatment for individuals who are detained or committed to institutions because they are entitled to healing. Just like we don't look at people that are committed to their whole life has been institutionalized, from foster care, juvenile institutions, graduate from juvenile institution to adult institution, from adult institution to adult institution to adult institution, then come out. When they finally get their lives together, they look up, they confronted with being sentenced for a crime or being indicted for a crime committed while they was a juvenile. Many still will come back to the city, and without the systemic and comprehensive approach to reentry here, it is easy to point the finger to those who have been incarcerated and return to to close a blind eye on the traumatization they are subjected to while incarcerated or even upon release. And this is something that we don't really take into account, and this bill doesn't take into account these factors that should really be looked at when you're talking about extending or eliminating the statute of limitation. You really need to look at the impact that it's going to have on people that are trying to do right, or people that have been traumatized and haven't had the ability to be healed. You really need to look at the impact that this is going to have on them. This will be like something hanging over their head that at any minute they can be locked up, or at any minute they on paper they could be looked at and say, oh, well, you committed a crime while you was a juvenile. Now you can go, now we got to send you back because the prosecutor decided they want to prosecute this crime because this is something that we want to do now because it's politically expedient to do these things. We also recognize, once again, we are not focusing on the genuine needs of Black youth who admittedly have been committed crimes, and ensure that they are seen as victims themselves and with unmet needs, emotionally, economic, education. Instead of looking at every juvenile as a threat, instead of trying to find a panacea for what we're confronted with today by throwing the baby out with the bathwater, let's look at the social and economic and political conditions that go into creating these type of individuals, that go into creating a marginalized community, that go into making people feel a sense of hopelessness, and don't punish them for after they decide to do the right thing. Don't come back and say, oh, well, the statute of limitations is not out over on that crime. And we need to get up our statistics on who's going to get locked up, and we need to pay the bill on who get locked up. Let's not do that. Let's have a sense of humanity. Thank you very much for this opportunity.
Thank you very much, Mr. Hopkins, for sharing that. Appreciate it. Let's see if Arthur Tameldon, can we hear you now?
I think so.
Okay, great. And do you prefer Tony?
Whatever. Yeah, Tony's fine. I do prefer that. Okay, I'm going to be testifying today on 25-343, the security camera incentives. And I am testifying as both the executive director of CHAMPS, which is the Capitol Hill Association of Merchant Professionals, with over 300 members, and also as a business owner. I do strongly support expanding the security camera incentives. And I would like to thank Charles Allen for continuing to work on this. I'm really not a huge fan of going over the crime that has been happening. I think we drag ourselves down continuously talking about it. But having said that, there was a string of break-ins on 8th Street. They broke into 5 places. And the individual who was responsible was caught primarily using the video from the establishments that were involved. Of course, he was quickly released, which is a different conversation. But after he was released, he broke into 3 more places, one of which was mine. And again, he was caught using the video cameras. Full disclosure, I don't actually have cameras in my business. Post-pandemic, it's just something that I can't afford. I also can't afford the $8,000 to rebuild my roll gate that was broken. So the retail businesses on the Hill are also increasingly running on tighter margins. The grant now supports 2 cameras, and I think we need more alarm systems within the buildings. We need better recording systems for the cameras, and getting that increased funding would help a lot. That's all I've got. If you have any questions, please feel free. Thank you for your time.
Thank you very much for being here, and I'm sorry that happened to you. Hopefully we can get these expanded. All right, Quiana Johnson, public witness. Okay, and Natalia Otero from DC Safe.
Hi, thank you, Chairperson Pinto, members of the committee. I apologize for not being able to be on camera today. My name is Natalia Otero, and I am the co-founder and executive director of DC Safe. DC Safe is the only 24/7 crisis intervention agency for domestic violence in the District of Columbia. Last year, we served a record number of 11,657 clients and families, representing around a 60% increase in clients since before the pandemic. DC Safe strongly supports the Accountability and Victims Protection Amendment Act of 2023. Its provisions are very consistent with the work of the High-Risk Domestic Violence Initiative and the Domestic Violence Intervention Project, and would increase the safety of survivors in high-risk domestic violence cases. The survivors we serve who are at highest risk for homicide and serious reassault at the hands of an intimate partner are all too often victims of strangulation, an act that can be deadly up to 11 days later without warning. They may be living with physical and mental health issues that their offender exploits to retain control in the relationship, or that make it difficult for survivors to leave the relationship. Therefore, DC Safe strongly supports including strangulation in the definition of serious bodily injury, while recognizing that the implementation of the change may require training and coordination to fully make its effects felt in individual cases. Additionally, we strongly support enhancing penalties for violence committed against vulnerable adults, as well as a provision that removes firearms from those who commit stalking offenses, as well as a provision that allows judges to make misdemeanor warrants extraditable. For similar reasons, we support the clarification regarding the use of GPS data that is often essential to keeping high-risk survivors safe. These are all critical changes for the high-risk survivors that we serve. DC Safe has long advocated for a holistic approach to domestic violence crimes that considers lethality risk and the pattern of violence instead of the incidental approach currently required by the criminal justice system. Many of the cases addressed through the Lethality Assessment Project and the Domestic Violence Intervention Program with MPD involve repeat offenders who repeatedly cycle through the criminal justice system and are released within 24 hours after committing significant harm, on top of a long history of violence against one person or even multiple previous intimate partner violence. Survivors and advocates must plan for this fact when creating a safety plan. DC Safe fully supports efforts to create restorative justice options for survivors. However, we also believe that the criminal justice process should work effectively and efficiently, with as many options to address different types and levels of violence and put the onus on the justice system rather than on the victim. We are concerned about the provision that would modify DC Code 14307D, removing the requirement that a survivor be given notice and 14 days to respond when their confidential records are being sought in extenuating circumstances. The term extenuating circumstances is not defined, and we believe that this will threaten the confidentiality that has been so beneficial to survivors, allowing them to speak with us freely and fully to get the help that they need. This legislation overall attempts to tailor the criminal justice system response to the lived circumstances of violent crime, particularly domestic violence crimes, mirrors the efforts and approaches of DC SAFE and the district's high-risk domestic violence initiative. We look forward to working with the mayor and the district partners within this approach, particularly with the updated city administrator's order for the HRDBI. Thank you so much for your time and attention today.
Thank you very much, Ms. Otero. That concludes our public witnesses for this panel. We're going to do a 5-minute round. I want to start with those of you who testified about the HIV prevention component and the testing. And the piece, and Ms. Warby, you talked about this, of not having the information in time when the victim needs to really be taking this medication. There are some other jurisdictions that do this testing right away so that they can have access to the information to start for testing. Is that something that you're advocating for, or you just don't think that this testing at all is a needed change or an appropriate change?
I think a couple of things. First, I share the ethical discomfort expressed by my colleague from Whitman Walker about the bodily autonomy of the person charged but not convicted, and the likelihood that that person would be found, the order put in, the whole chain of the process that would bring them to the point of being tested, I think is very unlikely to be accomplished within the 72-hour requirement for initiating the medication. And as I said in my testimony, really, we walk people through a CDC recommended kind of assessment tool, and that depends on the type of contact, the timing since they were assaulted, any other medical conditions that they might have that might be an issue with the medication, kind of where their greatest fear is and what would create the greatest harm reduction for them in helping them navigate that decision, and to whatever logistical side that would go on to make that test result occur and be available, I don't think is really going to add to the patient's autonomy and their sense of control that they gain from having access to this medication. On the other side, the biggest barrier is navigating getting the cost covered. And so I think if the district really wants to help from a victim's point of view and a harm reduction point of view to make a bigger impact, then that is where the impact really would be strongest. And you know, there is also, as the Whitman Walker person mentioned, the very small chance of that assailant being in the window period where you would get a false negative and a person might decline the PEP treatment when it really would be warranted, because that's when it is most infectious.
Got it. Okay, thank you so much. And Mr. Brooks, do you have anything to add to that, either about the testing? I know you mentioned the false negative component, and we've heard some contrary testimony to this today, but I have heard concerns in the past about the intensity and the difficulty of taking the treatment, which is why this was brought to us as a need. Can you speak to that understanding on, and if really the balance weighs in favor of privacy over protecting the invasiveness and intensity of the treatment?
I think in terms of protecting the bodily autonomy of the victim of sexual assault, the weight is entirely in taking the medication. The CDC describes the side effects of PEP as mild. They are often sort of mild nausea that dissipates after 1 week of being on the medication. That's my experience as well with taking the closely related medication PrEP. So in this case, there doesn't appear to be any benefit to the victim for receiving the information about their alleged perpetrators HIV status. So I'm not sure that there's any balancing to be done at all. PEP is considered to be very mild and extremely effective. So I hope that this helps answer your question.
Thank you so much. Yes, no, it helps a lot. And that seems to be kind of consistently some of what we've heard today about this provision. So I really appreciate that. Ms. Otero, I want to ask you about the strangulation offense. And based on your experience in working with survivors, what would some of the coordination look like to make sure that there's sufficient training and education about this component? Because of course we want to be careful about not having unintended consequences of a survivor not wanting to come forward with this. And so can you speak to kind of how to best coordinate that education and training for the strangulation offense particularly?
Yeah, sure. I think the most important thing is to try and balance the two things, right? Being able to actually implement this, but also not putting too much onus on survivors. If we think about a case from the beginning to end, typically our cases are coming through on a critical basis. So we're being called from the scene of a domestic. So in this particular situation, what we would have to think about is what is happening on the ground when an officer is actually at a scene and there is a survivor saying that there was strangulation. What does that look like? So I think there would have to be training on a basic level, like how reports are taken, how survivors may be communicating this to the officers, and then what an officer has to follow up with. And I think that would require a lot of, it would actually require a retrain of every individual officer, either through the academy or through roll call trainings, teletypes, things like that. So I think that's like the first step. I think additionally, being able to change internal protocols and policies for MPD would require amendment of a general order. Perhaps it might require some time to actually get that out. So there's a lot of moving parts in terms of just when a survivor is disclosing. So that's number one. I think it would require many, many hours and a lot of resources to make sure that every officer understands how to implement this. I think the next step in that would be how the survivor actually then ends up going through the process, because after a report is taken and there's detectives that are involved in following up, as well as court cases, judges, we would have to really think about how to best support the U.S. Attorney's Office as well. But I think along with the training and education, one thing I would say that we probably shouldn't forget about is accountability. Because as we change anything, somebody has to be paying attention to how these cases are being handled and making the necessary tweaks to the trainings and to the support for survivors so that we're actually working in tandem. So it's a big lift.
Yeah. Okay. Well, thank you very much. Look forward to continuing our conversation about that provision. I will now turn to my colleague, Councilmember Allen, for a 5-minute round.
Thank you very much, Chair Pinto. Thanks to everybody for their testimony. I think just in the interest of time, I'm just going to focus for a moment with Tony, Mr. Timeldon, not Arthur. Wanted to ask you a couple of questions around the legislation expanding the private security camera program. In your testimony, you talked about as running a business, and actually I think you run a couple of businesses, as well as on top of that, help lead CHAMPS, which is the local chamber of commerce. One of the things I took away from you was already operating on small margins, really busy trying to run a small business all day long, and so need the district to create as much help as possible to be able to put in a system like this. Did I catch that right? I mean, I think it's also one of the reasons why I think on the individual homeowner side it works so well and we see such uptake is that we make it really easy. I have people all the time that, of course, love to talk to me about when government's not working the way they needed to. With this program, people talk to me about how it is working. It's very easy. It's fairly quick. The documentation you need is very easy. And then that rebate check comes in the mail pretty fast. what are the types of things that the district should think about to make it as easy as possible from an administrative standpoint for a business owner that's probably very busy being a business?
Well, yeah, administratively, it is pretty easy. But for me, that's part of it, but it's also the expense. There's an additional expense for recording what happens. I mean, you saw it took me half an hour to figure out how to turn the volume on my testimony here on. So it's not like I can just run out and then put in a camera and save some money on the installation. So there's installation costs. You know, again, I think of all the grants that I have been involved with, going through this one has been the easiest and the most prompt response. So, let's see, there's my phone again.
I said you were
to
busy.
me, it's the financial part that really is the bigger incentive.
Got it.
When the pub got broken into, the window was $1,000. They stole $200 out of the cash register. One of the other places that got broken into, they stole all of the liquor. So I mean, the expense, you know, it's just too tight right now for us to cover that expense, and insurance isn't going to cover your liquor that's stolen. So it is, you know, it's prohibitively expensive, and if we can get any help on it, I think that one of the programs I looked at, it's $90 a month for full video recording overnight.
Got it. Okay. You know, and talking about the experience we saw, you know, this bill was introduced after a string of burglaries along the H Street corridor, and I know H Street's not unique here in experiencing this, but meeting with a lot of the businesses really helped crystallize why this was so important and why we could expand in this way for a lot of the reasons you talked about. But I think one of the things that also we should think about from an effectiveness is that we had a number of businesses that experienced a burglary that did not have cameras, did not have glass break sensors, but for those that did and that experienced a burglary, it was invaluable to provide that evidence to MPD, who was able to ultimately make an arrest. And I think when we see a relatively small number of people that are committing all these robberies over and over again, that's a really crucial part. I'm not going to name the businesses around this, but I know of one that was broken into twice without any camera system, an alert system. They then installed one, and I don't believe they've had that happen again. We had another where, at least what MPD told me, is the individual would break the glass, go walk across the street, wait to see if he heard sirens come in to see if there was an alarm that was tripped, and when it wasn't, headed right back inside, and did that several times. So having the glass break sensors or having an interior camera really does make a difference in terms of both some deterrence and certainly, if it does take place, an invaluable tool for MPD to help identify the individual. And does that echo kind of what you've seen along the H Street corridor and in talking with other businesses?
Yeah, that first chain of break-ins, it took a while to solve it, I guess is the word. But once everybody got on board with the cameras, it went pretty quickly. And like I said, he was released, and then he broke into the 3 places, including mine, and was quickly caught. And I think that there was a liquor store Friday that was robbed, and they had him by Saturday morning using the video. So, you know, I think that it is a pretty helpful security system, security addition, I think.
Yeah, and we've seen that it has effect when used the right way. I appreciate it. Thank you very much for your testimony and amount of time. So thank you, Madam Chair.
Thank you.
Thank you very much, Councilmember Allen, and to all those on this panel. And it reminds me of when I was working in a frozen yogurt shop, and I left at about 1:15 a.m. and somebody broke in at around 1:30, and they knew exactly where I'd left the key to the cash register, which means they were kind of following along. And I wish we had cameras then, and so hopefully this can help. Okay, thank you all so much to our public witnesses today. Really appreciate your testimony, and want to note I heard many folks talk about the broader needed interventions for our city, and I appreciate those concerns as we all continue to fight for some of those really important things to benefit all of our residents, and we'll continue working towards that.
We are going to now turn to our government witnesses. We have Lindsay Apaya, Deputy Mayor for Public Safety and Justice, Janu Park, Executive Director for the Criminal Code Reform Commission, Elena Suttenberg, Special Counsel for Policy and Legislative Affairs from the United States Attorney's Office for the District of Columbia, Katerina Seminova, Special Counsel to the Director for Policy, Public Defender Service for the District of Columbia, and Janice Bechtel, Chief of the Domestic Violence and Special Victims Section of the Office of the Attorney General for the District of Columbia. If you could just hold one moment, we're going to divide our government witnesses into two panels today. Thank you. So on the first panel, we'll have Deputy Mayor Apia and Director Park, and then we'll then take the remaining witnesses on the second panel. So with that, I invite Deputy Mayor Apia and Director Park to the table. As you know, it is the tradition of this committee to swear in all government witnesses. So if I could ask you to raise your right hand. Do you swear or affirm under penalty of law that the testimony you are about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth? Thank you both very much. I'd now like to invite each of you to make any opening statement you may have. Deputy Mayor, please go ahead.
Thank you so much. Good afternoon, Chairperson Pinto, members and staff, Councilmember Allen, of the Committee on the Judiciary and Public Safety. I'm Lindsay Apia, Deputy Mayor for Public Safety and Justice. I'm here to present the executive testimony in support of B250345, the Accountability and Victim Protection Amendment Act of 2023. I'd note that the Office of Victim Services and Justice Grants will be submitting written testimony with the executive position for B25-343 and B25-167, and the Department of Forensic Sciences will be submitting testimony on B25-348, but I'm happy to answer any questions you may have about any of those bills. I'd like to thank Chairperson Pinto for her leadership of the committee over the past 9.5 months and willingness to work together to find solutions. We stand with you to partner on advancing policies that increase and enhance safety across the district. We cannot lose sight of our responsibility in reducing crime and must prioritize the protection of victims of crimes, especially our most vulnerable citizens, including our children and seniors. We also acknowledge your 11 council colleagues who voted in support of the Prioritizing Public Safety Emergency Amendment Act, which is helping us to fulfill our responsibility of creating safe communities across our city. On May 16, 2023, Mayor Bowser introduced the Safer, Stronger Amendment Act of 2023. This common sense legislation provides more tools to ensure that those who commit harm to community are held appropriately accountable, provides more access to critical data that will allow us to understand and adjust our interventions across the public safety and justice ecosystem, and more flexibility for successful programs that allow our residents to partner with us in reducing crime by solving and closing cases. As I shared in my testimony in June on the Safer, Stronger Amendment Act, while we're a city that often leads the nation in instituting forward-thinking reforms, we must never lose sight that we're first and foremost a local city. Our solutions must be tailored to the specific realities that we face, and that we are always mindful of victims in our criminal justice considerations. Specifically regarding today's hearing, the Safer, Stronger Amendment Act proposed several provisions that we believe the Accountability and Victim Protection Amendment Act of 2023 builds upon. Both bills would clarify the definition of significant relationship in sexual abuse cases, ensuring that definition and corresponding penalties include and are applied to a contractor of a school, church, synagogue, or similar institution for sexual abuse, just as an employee or volunteer of the same. Clarify that GPS records from the Pretrial Services Agency are admissible in court as evidence of guilt in a criminal case or other judicial proceeding, and create felony liability for strangulation, which is widely recognized as one of the deadliest forms of domestic violence. While I did not and will not cover all of the provisions of B25-345 in my testimony, I want to express the executive support of the bill. We firmly support ensuring that our criminal justice system has the necessary tools to protect victims and potential victims of crime in the district, and to hold perpetrators of serious crime appropriately accountable. The Council has significant decisions to make in the upcoming months as it relates to the public safety and justice in our city. We must work together as those tasked with leading at this time to thoughtfully and expeditiously advance policy proposals like this bill, the Safer, Stronger Amendment Act, and others to come. We must demonstrate our responsibility to urgently address crime, to ensure an appropriate balance of consideration of both victim and offender, and to advance the stability and functionality of our public safety and justice ecosystem in a way that leads to enhanced safety across all 8 wards. I look forward to working together to do just that.
Great. Thank you so much, Deputy Mayor Appiah. Director Park.
Good afternoon, Councilmember Pinto, and thank you for allowing me to testify today on behalf of the Criminal Code Reform Commission regarding Bill B-25345. And just due to time considerations and the breadth of the bill, my comments today will be abridged, but the CCRC will be submitting more detailed and more thorough written commentary. So just trying to jump into some of the issues that I'll have time to do today. So first, Title II, it amends the unlawful possession of a firearm offense to criminalize possession of a firearm by persons who have been previously convicted of misdemeanor stalking or attempted stalking. So setting aside the policy merits of this change, I do want to note that the language under this proposal could face constitutional challenge under the Supreme Court's recent Second Amendment case law. So in Bruin, the Supreme Court announced a new test for establishing when a gun control measure violates the Second Amendment. And the court stated that the government must justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearm regulation, and must do this by showing a historical precedent from around the time of the founding that shows a comparable tradition of regulation. So there's a recent decision, United States v. Rahimi, in which the Fifth Circuit Court of Appeals struck down a federal law that barred gun possession by people who had a domestic violence stay-away order, arguing that there was no historical tradition of analogous or similar regulations at the time of the founding. Now, stalking offenses being relatively modern creations, it's possible that there may not be a similar historical tradition of this type of firearm regulation from the time of the founding. I should note the Supreme Court has actually agreed to hear the Rahimi decision on appeal next term. So the results of that case are unclear. At the very least, we hope that the court will give some greater clarity for how the Bruin standard ought to be applied. But barring a really dramatic departure from the Bruin test, it does seem quite likely that the government will have to produce some sort of historical analog to defend prosecutions from Second Amendment attacks under this proposed bill. Next, Title III makes some changes to propensity evidence rules. It allows, when persons are accused of sexual abuse, it allows that a court may admit evidence that the defendant committed any other similar sexual abuse. I just want to note that the term similar sexual abuse is somewhat unclear. And you can contrast this with the analogous federal rule, FRA 413, which specifies certain criminal offenses or certain specified types of conduct that can be admissible. So this is a really dramatic change to the current district rules on propensity evidence. So we would encourage the council, if it makes this change, to be as absolutely clear as possible as to what types of evidence really would be admissible in these cases. Next, Title 14 makes some changes to HIV testing rules. So the title would permit testing for a broad array of offenses. It would allow testing for persons who are charged but not yet convicted of these offenses. It would also allow prosecutors to independently request the testing. As to this latter point, it wasn't entirely clear to us why the prosecutor should have independent authority to request testing, especially in light of other newly proposed subsection G, which expressly bars the court or prosecutors from sharing those results with victims when they don't wish to be informed of them. It's possible that prosecutors may want to share that information with other people, such as the victim's family members, but that seems in clear tension with the spirit, at least, of subsection G. More generally, broadening the scope of when HIV testing can be authorized potentially creates some constitutionality concerns under the Fourth Amendment's bar on unreasonable searches. So the Supreme Court's been very clear that this kind of testing does constitute a Fourth Amendment search. They have never ruled on whether these HIV testing rules are constitutional, though several lower federal courts and state Supreme Courts have. Now, in our research, we found almost universally that courts have upheld these HIV testing rules, but they've often identified several factors that make these rules constitutional. They've often noticed that these tests only apply in cases where the crime or alleged crime was committed in a manner that creates a genuine risk of HIV transmission. The test results are also kept mostly confidential, and the tests produce results that provide information that's necessary for the health of the victim of the alleged offense. So at least in cases where a prosecutor is requesting a test and is barred from sharing that evidence or those results with the victim, it's unclear why these results are really producing information that's necessary for the health of the victim. And to be clear, we're not saying that this proposed changes would be unconstitutional, only that there is a potential risk that in some cases, as applied, it may violate the Fourth Amendment. Just something to keep in mind in drafting these rules. Next, so Title VIII created a new repeat offender penalty enhancement for the current misdemeanor sexual abuse statute. The proposed 3-year max sentence is very close to the max penalty that was authorized for the analogous offense, non-consensual sexual conduct under the RCCA. However, this bill makes no changes to the misdemeanor sexual abuse offense in and of itself. And that offense is overbroad, has significant proportionality issues, and the enhancements, at least in some cases, we think could exacerbate the proportionality issues. So again, the current misdemeanor sex abuse offense is extremely broad. It covers touching someone on the rear end without consent, but it also includes much more egregious conduct, such as engaging in sexual intercourse, knowing that the other person does not consent. All that conduct is a 108A misdemeanor under current law. The RCCA created multiple tiers such that non-consensual sexual acts, including sexual intercourse, were appropriately treated as a felony. So this proposal doesn't address that. And in some cases, like I said, it could exacerbate the penalty proportionality. So under this proposal, a person who touches someone on the rear for the second time would be guilty of a felony and subject to penalties 6 times higher than a first-time offender who engages in sexual intercourse knowing the other person does not consent. So we would recommend that the committee at least consider adopting the recommendations with respect to this offense that were included in the RCCA. And I do have to take this opportunity to remind the committee that I think this is a good example of the value of comprehensive code reform. I think this reform is well-intentioned and reasonable and addresses one of the problems with the current offense, but leaves myriad other proportionality problems entirely unaddressed. Next, the Title 12 creates a penalty enhancement for committing certain offenses in the presence of a child or witnessed by a child. So to note some among several ambiguities in the bill. So first, it doesn't clarify what it means to be in the presence of a child. If a person commits a robbery and their kid happens to be across the street or halfway down the block or all the way down the block, when is that child in the presence of that crime such that the enhancement is authorized? It's also unclear what witness means. That could be interpreted narrowly to mean that the child has to actually see the crime occur, but it could be interpreted more broadly to include cases in which the child perceives it. For example, if they're in the adjacent room and hear an instance of domestic violence occurring. And so I think the committee should have a clearer policy stance and then try to draft this enhancement in a way that makes it very clear when this enhancement does or does not apply. Also, with respect to intra-family offenses, there's no requirement that the child be part of the relevant household. So if someone commits a simple assault on the street in front of a child, the enhancement would not apply because a simple assault is not a crime of violence. If a person happens to commit that same offense against a person who is, say, in a domestic partnership with that person, in front of a child who's completely unrelated, the enhancement would apply. And it's not clear why, from the perspective of a child witnessing this type of violence, why there should be a distinction between those two kinds of cases. Next, Title 13 creates a new standalone strangulation offense. So as we've noted before, the RCCA had amended the definition of significant bodily injury to include strangulation such that it would be treated as a felony assault. So we certainly agree in principle that this type of use of force should be treated as a felony. This proposal does differ. One of the main differences is that it creates a separate standalone strangulation offense. And so this creates a major issue of does and under what circumstances should this strangulation offense merge with other offenses, most notably assault. And whether or not the merger occurs has a huge effect on the range of applicable penalties and whether or not they're proportional. So just to give an example, if a person engages in strangulation and which results in significant bodily injury, that person could be charged with both this new strangulation offense as well as felony assault. Now, if the offenses merge, the person would still be guilty of strangulation, and the max sentence would be roughly 66% higher than for committing felony assault by other means. If they do not merge, then the maximum cumulative sentence would be more than 2.5 times what a normal felony assault would be. So we're talking about a huge discrepancy depending on whether or not these offenses merge or not. And so the committee and the council, I think, should think very carefully about whether these offenses ought to merge, and however I come out in this decision, set the penalties accordingly so that the resulting cumulative penalties really are proportionate to the conduct. There's some other issues I'll just jump on really quickly. So the strangulation offense also doesn't include any defenses. So it's unclear whether or under what circumstances something like, say, self-defense or consent can operate as a defense to strangulation. So, for example, if 2 people are practicing martial arts and one person puts the other person in a chokehold, is that strangulation? Or does the fact that they consented to engage in that activity serve as a defense? And if so, does that defense still apply if the strangulation results in serious bodily injury, and why or why not, and what circumstances? These are kinds of issues that the RCCA had resolved through defenses to the assault statute. Again, showing why comprehensive code reform is so valuable. But we certainly would be happy to work with the committee to potentially draft offenses that specifically apply to this revised strangulation offense, should the committee move forward in that front. So that concludes my prepared remarks for this hearing. I look forward to answering any questions you may have. And as always, the CCRC is happy to work with this committee to propose alternate drafting options to address any of the issues that I've raised today or that we will address in our written remarks.
Great. Thank you so much, Director Park. Really appreciate those examples. Very helpful. And I do want to note we have also been joined by my colleague, Ward 3 Council Member Matt Fruman. We are going to do 10-minute rounds to start, and then if folks need more time, we can contemplate a shorter second round. Okay, so Deputy Mayor Pia, welcome, and thank you very much for your testimony. And as you kind of highlighted, the prioritizing public safety emergency that the council passed this summer was really a combination of a number of provisions put forth by Mayor Bowser and Safer Stronger legislation, and a number of provisions in the bill that one of the bills we're talking about today, the Accountability and Victims' Rights Act. And so we have the benefit of hindsight that we don't always have when it comes to permanent legislation to think about, were these interventions helpful so far? So can you speak to what we know so far, whether it's around violent crime, pretrial, the expansion of the camera program, GPS, protection of a child, anything that can guide the committee's efforts on what these interventions should look like on a permanent basis?
Sure. I mean, one of the things that Mayor Bowser has said, and that I think we all know, is that we have to reduce crime, right? So there are a number of different data points that we could look at, but one of the first ones that we have to look at is, are we experiencing reductions in crime? And so for the period, I'm going to use July 27th to September 11th because that's, I believe that the bill went in place at sometime in the middle of July. We saw an overall reduction of 26% in violent crime when compared to the previous similar period of June 10th to July 26th. And then one of the drivers a significant driver of violent crime in our city is robbery. And so in that same period, it's 46 days, July 27th to September 11th, we saw a 34% reduction in robbery. And so those are, at a time where each number represents someone who's being victimized by crime. You've heard different people talk about that. Any reductions would be significant, but certainly double-digit reductions are ones that we note, particularly because we know we had seen certainly escalating high numbers in the first half of the year. In terms of numbers of detention, I know that the U.S. Attorney was on Friday on the Kojo show and spoke about some of those numbers. I can tell you as the person responsible for the Department of Corrections that today we're at about 1,543, 1,535. We kind of are in the 1,500 range, which represents about a 200-person increase in pretrial in holds at the DC jail over the past about 3 months. So we started to see a little bit of an increase. We were basically in the 1,200 range for most of the year, but we certainly have seen a pickup in pretrial holds on the adult side. What isn't mentioned here too, but in the same, when we were also doing emergency, was clarifications around pursuit, which was important. I mentioned that because it's all of these pieces working together. That clarification really did help our officers to be in a position to adhere to the policy which has been in place for a good period of time around pursuing, which is really important. MPD, which we haven't put out numbers, we certainly appreciate that case closure is important, and the Metropolitan Police Department has closed, I believe we're at 44%, I believe, which is the use of 44%, which is right around the UCR, but I will say that we were at approximately 30% on our homicide case closures, and so we've seen a pickup there. We obviously, we have a new chief who will be before you all, I think it's next week, for her confirmation roundtable. All of these pieces combined, we always call the public safety and justice system an ecosystem because we say that all parts really have to be working together in order for us to be successful. And so we're finding through legislation and policy and how that's influencing practice, we are seeing results that we'd like to see continue.
Great news. Thank you so much. And I think that's really important clarification as well as we look at where we were this time last year in September, which can be confusing data source versus perhaps more instructive as it relates to the efficacy of this specific bill, where we were in June versus where we are in September. So thank you very much for that. Director Park, thank you for highlighting some of the specific examples of perhaps inconsistencies. And I would just say for the record, I agree with you that a comprehensive rewrite is much preferred, but we are where we are, and I don't want to let the perfect be the enemy of the good. And these are areas that we're still seeing a lot of significant gaps from our prosecutors' perspective and from watching these cases play out. And as we think about sexual survivors' rights and their needs to kind of move forward and bring justice in these cases, that's part of the reason we highlighted these changes. In terms of the strangulation, I'm interested in the coupling that you talked about, or the merging with the serious bodily injury and felony offense, because one of the reasons we pulled out strangulation was because of its predictive effect on future domestic violence that can grow fatal. So how would you propose recognizing the severity of strangulation in and of itself, especially because we've seen it so often lead to these future indicators, without merging it towards other assaults that sometimes can be much lighter in effect, whereas strangulation in and of itself is very serious in our view?
Yeah, actually, absolutely. And we've also listened to the testimony demonstrating that strangulation is strongly predictive of even worse incidences of violence in the future. Which is why to say we did intend to treat it as a felony offense, akin to breaking someone's bones, knocking someone's teeth out, beating someone to the point where they have long, wounds that require lacerations. And so I think even if the offenses were to merge, what's proposed here does provide, as I pointed out, a significantly heightened penalty as compared to even other felony assaults. There's no objective right answer for what the exact penalty ought to be, but I think, like I said, it would be about 66% higher than the max for a felony assault. So if someone, say, broke their partner's jaw with a strong punch, strangulation, even if it only resulted in, say, minor bruising, would still be subject to a 66% higher penalty. I think that's a significant difference. So even if these offenses merge, I think that the bill proposed does actually capture the heightened seriousness of this type of conduct.
Thank you for that. And I think that example highlights kind of where we've been in the past with our justice system. And one of the things that we're trying to be responsive to is the recognition that strangulation doesn't always leave scarring or bruising or blood, but can later result in much more drastic and dire circumstances. But I appreciate that. And similarly, as we think about the sexual assault and the misdemeanor, I think your example that you gave was quite powerful. But I don't know if you were able to hear any of the testimony from our public witnesses about, and particularly Ms. Olds, talk about her conversations with defendants who know that the district's laws may only result in such little consequence, so the repeated instances of sexual assault, even as a misdemeanor, go on here when they might not happen 10 minutes over the border.
Yeah, so again, I think it's reasonable to impose even repeat offender enhancements, even for what, as a first-time offender, might be a misdemeanor offense, and the RCA did include some misdemeanor repeat offender enhancements as well. The issue here is that, independent of that repeat offender enhancement, I think there needs to be an important change to the core offense itself, even for a first-time offender, that distinguishes between really dramatically differing conduct, so that's not all treated the same, especially in conjunction then, like I said, with this enhancement in which someone touches someone in the rear for the second time, which of course is serious conduct, would be treated, again, subject to a six times the penalty of someone who engages in non-consensual sexual intercourse. those penalties just seem disproportionate relative to the severity of the conduct.
Yeah.
So, yeah.
I would just say, though, as a reminder, that these are maximum penalties. These are not minimum penalties, and so that the discretion of the prosecutor and the judge, I think, is very important in these cases to determine the severity as we move forward. But I appreciate that, and we'll definitely continue the conversation. In last minute, this is kind of a lot for you, Deputy Mayor Pia, but there are 3 bills that we're focused on today other than the accountability and victims' rights. And just curious from an agency implementation perspective, what you think about OVSJG managing the expansion of private security, what you think about DFS's ability to maintain these rape kits for longer period of time, and if you think that the wheel lock incentive program could be effective.
Sure. So let me start with maybe the easiest. The wheel lock incentive program, we support, right? Like we believe that all of these programs can certainly be helpful in helping us to both empower residents, right, to participate in the process of safety, but also in helping us actually fight crime. The one thing I'd note on the wheel lock, which is just to change, they don't necessarily need to be registered with MPD. Like that's the one thing just for their purposes. On the other 2, I would say, you know, the private camera security program currently is a program that is very popular, and even our capacity, I think, currently at OVSJG is a bit stretched. With us even looking to expand, as we did under the emergency legislation and the Safer, Stronger Amendment. So what we want is efficiency and effectiveness, and so there are some capacity limitations, and also we want to present packages that make some sense. So I think the executive would be interested in looking, is there a way that we can utilize DEMPED and DSLBD with our businesses to help make sure that as we have a host of incentives or otherwise for businesses, that they're in places that make sense and that our system really is talking to each other. And so we recognize the ease of the program, and so that's something we can work on that side. But I know as we stand up different grants and otherwise, that having one for businesses with the sort of breadth of what's being offered at OVSJG is a bit different, and there may be a better fit. As for DFS, currently there aren't capacity to store that amount, the volume, and so certainly that is an issue that you'll see in the written testimony about the. It would be a significant increase in the needs for storage capacity, just based upon what we currently have and our predictions around what the capacity would need to be.
Got it. Okay, that's very helpful. Thank you both very much. Now I'll turn to my colleague, Councilmember Allen, for a 10-minute round.
Thank you. Appreciate it. Thank you both for your testimony. Let me start, I guess, with Bill 25343, so the private security camera program. So I guess I wasn't clear. The executive supports it, doesn't support it? Can you help us
Sure.
understand?
We support anything that's going to help our businesses, residents, or anybody to safeguard themselves. Certainly, I can speak for myself, having recently met with Giant and other of our businesses that we recognize are really struggling with theft and with robbery and with other things. And so we are interested in talking about policies and practical things like this program that will assist businesses. But we do also think it's important that they're aligned in the right place. One of the things about OVSJG is their programs are generally available to a wide range of people, and so changing this program a bit where it would be specific to just one category of specific businesses versus wider applicability of any resident or any business.
Let me go to that. So, I mean, this is the hearing on the bill. So.
Yes.
This is the place where we'd want to have the conversation, right?
Yep.
So we don't have the benefit of testimony about it right now. So that puts us shorthanded. But OVSJG already runs the private security camera program. They do it for businesses for the cameras on the outside of the door. How is it that it's hard to run it for the camera on the inside of the door? Well, they already have a very effective program. It does very well. Since I created that 8 years ago now, it's an invaluable tool for MPD. We've heard from our businesses and we've heard from MPD that having that video helps them be able to make an arrest. what's so different about being able to run a program for the camera inside the door rather than outside the door?
So it's not just cameras that you included, Councilmember. I believe you also have glass break sensors and others. The current program, as it is administered, requires that OVSJG inspect every camera, and they do. So where we're expanding to now have other apparatus like glass break sensors, that obviously increases what would have to be inspected for funding purposes or also just granting agencies due diligence. The other thing, as I mentioned, was...
Yes, Mayor, I'm sorry to interrupt, but they don't inspect cameras.
They inspect every location. We have one very committed employee who goes around from location to location in a car to look at whether people are meeting.
They put eyeballs on it to see that it's actually been put up. They're not inspecting the camera and the footage. So how would that be different than putting eyeballs on and saying, yes, you installed the camera?
I didn't actually say they inspect footage. So just for clarity, they do inspect to make sure it's meeting all of the legislative requirements. So different or not, what I have said is that it would be a vast expansion. One of the things that we have proposed for our residents is for those who who received cameras at the beginning of the program, right, that they would have an opportunity to update cameras. So we're already talking about just in the fundamental nature of the program and expansion that would require some resources. FY22, the program was $250,000. FY23 and 24, $500,000, which shows we have a doubling of the program already, both interest, and that also means the requirements on the agency. So when we talk about expanding beyond cameras to things like door sensors, a wheel lock program that is also being proposed to be added to OVSJ in a similar fashion, we have to recognize that one of the things people enjoy is the efficiency and ease of the program. That will change as we add further programs and different types of programs to the agency.
So yes, and certainly if we're talking about, as almost every bill is passed, there's a cost associated with it, and so then we have to find that, identify that. I think that's would be the expected route of then using the budget process for that. But there's no one that inspects 20,000 cameras in homes, and that's also not a requirement that's in the legislation. That was one that OVSJG put upon itself. But I also think we have to think about, and one of the things I'm interested in is how are we best using our resources. So if we can point to examples where the sheer amount of time that detectives are working trying to identify an individual in a place where there are no cameras, and then once we have a business that does have a camera and have video footage, then we're able to help identify that person, make an arrest, and have accountability. I'm happy to have a conversation once we get to the budget part of this to say what type of resources do we want to make sure OVSJG has, how are we making sure that we have the resources there. But I think we also got to be strategic about how much are we spending on the inability to hold someone accountable and the inability to be able to get something done when we have an effective tool. And again, I think we share the fact that OVSJG does a great job with this program, and it's a highly effective tool, and we want to be able to add that to others. I want to keep moving, so I only have one round, to Bill 25348.
Sure.
So I'm hearing you say that that's a DFS capacity issue, but I'm not hearing you say if you support the bill or not. So can you let me know where the executive stance is on that?
So the executive can't support the bill as written because if it's impossible, if there's an impossibility based upon capacity or otherwise, right, like we can't say as written we support the bill. So we are willing to discuss and work with the council on what is practicable and possible, but as it's written currently, it's an impossibility for the agency to effectuate, so we don't support it as written.
Okay. I mean, the executive has supported a lot of legislation that requires funding. So you're saying if there's ever a bill that has a fiscal impact, don't support it?
No, I made a specific statement about this bill. I'm not making statements of general applicability about fiscal impact or otherwise.
Okay.
I'm speaking about the current capacity of the Department of Forensic Sciences and the Metropolitan Police Department as the named agencies, that in the current state that the bill is, we can't support it because it's an impossibility for the agencies to effectuate.
What's impossible?
As I said, there are capacity limitations, and that
like
our
storage
estimate,
or what,
storage,
okay.
Exactly, storage. The Department of Forensic Sciences wasn't necessarily built to be a long-term storage facility. That, in fact, MPD's evidence, their evidence department would normally store these type of things, but they certainly don't have the capacity either. So if we're talking about vastly expanding the capacity at the cost of millions, that's certainly a discussion we have, but that is the reality. It would be irresponsible of us to say we support this bill as currently written when we know that neither agency have the capacity currently to effectuate it.
Okay. So not providing testimony to the hearing makes it very difficult for us to have that conversation, because this would be the place where we have it. So how many kits do you believe would be produced per year that DFS would have to be responsible for?
So that will be in the written testimony. I believe the record continues to be open, and certainly happy to have more specific discussions, but
if you looked at it, how many do you think it would be per year?
As I said, that's in the written testimony. I'm not going to have conjecture or speculation on how many we could hold.
Okay.
That won't help anybody, council member.
But this is the hearing on the bill. I have no testimony to be able to ask you about, so you don't know. Talking about it as an impossibility, the forensic nurses found a closet at MedStar to make it a possibility. I gotta believe that DFS in that beautiful big building, we can find a space where you can identify what the cost would be for a space. I don't understand how it's an impossibility.
One of the things that I would say is that fiscal impact, which I believe is a process that's undertaken by OCFO and otherwise, will identify what the cost is. Our estimate is that it would cost millions, right? So specific fiscal impact, I think, would be a more informative way of talking about what would be required to actually effectuate it. I can't speak to MedStar's storing things in a closet or otherwise. What I can speak to is that the current posture of the Department of Forensic Sciences and the Metropolitan Police Department is they don't have capacity.
Okay. So earlier today, the folks who actually do this already say we would have at an absolute maximum 150 shoe boxes per year. It would cost millions and millions of dollars to store 150 shoe boxes?
I don't know I can't speak to what people are talking about with shoe boxes or otherwise, or what is
Are you familiar with a PERT kit of what size it is?
I am familiar with the PERT kit, but
okay.
I can't say, when you're saying shoe boxes or otherwise, what I'm saying to you is this, council member, we could go around in circles, but what I can say to you is that the current capacity of either agency isn't there. So if we would like to work together on identifying capacity and in the fiscal impact process talking about that, we're happy to do that. But you asked, do we support the bill? And I said, as it's currently written, the agencies don't have capacity, so we can't support it as written. But we are happy to work with the
But you can estimate millions of dollars of cost.
Yes.
Yet you don't know how many it would be per year.
I can tell you that based upon conversations with the Department of Forensic Sciences and the Metropolitan Police Department, they estimate millions. That as those who regularly have to do building projects or pay for storage capacity in the district, that it is not unreasonable, actually, to believe that it could cost millions to store.
But you don't even know what it is you have to store, but then have millions. If you don't support the bill, it's just easier to say, I don't support the bill.
What I've said is that the executive cannot support the bill as it's currently written.
But doesn't seem to have actually evaluated whether or not and what it would look like.
Is that a question?
No, just a statement and observation. I have no testimony, so you didn't come to the hearing with any testimony about multiple bills here. You don't seem to have analyzed what it would take or what it would look like, but do seem to have a really big fiscal impact to try to say why it's an impossibility, while meanwhile other organizations have figured it out. And at the end of the day, what ends up happening is that victims and survivors of sexual assault are ending up being unable to be able to have prosecution or justice against the person who violated them. So I would have hoped that we would have had testimony today. Would have been a better way to have the conversation to help understand where the concerns are, where the constraints are. So it's disappointing. But I hope to work with my council colleagues to see if we can't figure this out, and would still love to work with you, with DFS and others, to think through how we get this done to do right by our victims and survivors. Thank you.
Thank you very much, Councilor Allen. And I'll just say, Deputy Mayor, I know you submitted written testimony this morning, and the hearing record will close on October 2nd. And I think DFS and OVSJG are planning to submit some testimony. And so to the extent that they have rough estimates of where some of those considerations would be, I think that would be really helpful for the committee.
Sure.
Councilmember Fruman, 10-minute round.
Thank you very much. I'll start by sticking on the same subject briefly, but not so much with a question. I mean, my sense is that the administration feels strongly about accountability, feels strongly about vindicating victims' rights, and that I would expect that in principle you would want to support something like this if we could sort out what you believe are the practical issues. You haven't quite said that, but I guess I'd be surprised if that weren't the case, if we couldn't figure out a way to fund it so that the concerns that you raise are addressed. I don't think I'm going to put a question mark on the end of that unless you want me to. Okay. But it is my hope that this is the kind of thing that can be sorted through, because all victims are sympathetic, but these victims are among them. Chairperson Pinto started where I was going to go, and you went through some stuff on what the last months have looked like, but I want to try to dig a little deeper or make sure that I understand it. So I thought I heard you say from July 27th to September 11th is a period, I guess, 46 days, something like that, and that you compare that 46 days to the previous 46 days, and you see 26% decline in violent crime, 34% decline in robberies. Is that right? And is that in your written testimony?
I don't believe it is. My written testimony was very general, but we're happy to provide whatever statistics. We have it broken up by 30 days, by overall, by 46 days, by any amount of ways that you can think of, but happy to submit that.
And is the source of that data the crime cards database, or is it something different?
So it's, I mean, the data's all, crime cards basically is a data aggregator, so you certainly could pull it in that way by PSA, by location, over citywide, by district, or otherwise. Yeah.
Okay, because this is going to be a really important conversation as we move towards finalizing this legislation, to make sure we understand what the impact has been, if there's been an impact. And it's hard to isolate. There's lots of things that are out there. I think that there was press recently about the acting chief making claims about reductions, and then an investigative reporter saying something different. I wonder if you could speak to that, help me understand that. Do you know what I'm referring to?
I can tell you that what that is. At the public safety situational update, the chief said there was a 30% reduction in the focus patrol areas. I will say that the way that we look at the focus patrol areas, there are significant reductions across them, right? In the 30-day period, which is one of the things that she looks at. You see reductions from anywhere from flat to an upwards of 75% reductions overall by area. So the overall numbers are exactly what Mr. Oberg said. I think it was 3.5%. But there's a number of ways that the chief is looking at data, and so I wouldn't say she misspoke. I would say that she did not complete saying like what period she was looking at, and so. Whether it's the focus patrol areas by district, whether it's the numbers I just listed or otherwise, we're seeing reductions across the board. The one area I'll say is we are sort of seeing some more of a shift to our more traditional crime patterns, where we see a bit more concentration in Ward 8 and the 7th District, and so we're focusing efforts there, versus what we were honestly seeing earlier in the year, which was much more diffuse crime across the city.
So, and this goes to the challenge we're all going to face, is there's a bunch of different ways to cut figures, and we're all going to want to dig pretty deep into what's going on, and let's be partners as we do that. A different set of data that you talked about was the pretrial detention, and you used the number 1,500, but then you also, and you made it sound like maybe 200 more detentions, but then you referred to that it historically had been more like 1,200. Talk to me about what that is, and talk to me about how much of that growth is in the juvenile and how much of that growth is in the adult space.
So I didn't speak at all to juveniles. I was purely speaking about the population at the Department of Corrections facilities, so the Central Detention Facility, Central Treatment Facility. So we, over the course of this year, have been anywhere from about 12 to 1,300 population on a daily basis. We're now averaging about 1,500 or so we've certainly seen increases in the population at the Department of Corrections. I will say in the 8 weeks, this is another, May to July, we had about 645 people who were pretrial original detainees, 75 for weapons charges. We've seen that jump to 131 people being held for weapons charges in the July 9th to September 2nd period. So we're seeing increases in the holds for weapons charges, which is something that we look at because you hear so much about the effect of CPLW, concealed pistol, and others on our violent crime patterns. And so we are seeing increases in overall population at the Department of Corrections and then also in that category of weapons charges.
And what's the capacity? If it was 1,200 and then it gets to 1,500?
I think it's 2,400. Prior to the pandemic, I would say on average, all of this is listed. DOC puts out a host of data. We generally averaged about 1,800 average daily population for a couple of fiscal years at the Department of Corrections facilities. And so certainly during the pandemic period and post-pandemic period, those numbers were significantly below that and still remain below the 1,800 mark, which is about where we were in fiscal year 19 and I think 18 as well. Yeah.
And so that goes to the adult, and on the juvenile side, which was a big subject of conversation at the time that we passed the emergency legislation, I know you want to be careful where you can't speak authoritatively, but do you have a sense of what's been happening on the juvenile side?
Sure, there has not been a population explosion. It stayed actually relatively steady, right around single bed capacity, so anywhere from about 70-something to 91, right? Single bed capacity at the YSC is 88. So, on the high end, we've been at 91, and at the lower end in about the mid-70s. So it's stayed pretty consistent. The one thing that I need to dig a little bit more into and that I'm working with is one of the detained population may have increased a bit. We have, prior to Director Abed, who has been there since July, we had a lot of committed young people, right, versus detained. So this is very juvenile justice specific. Our population of committed young people is coming down, which means the population of detained has gone up a bit, right? Because DYRS purely controls the committed population in their location, which is something we talked about at the hearing. That one way that we maintain homeostasis in population is making sure that if committed young people do not need to be at the YSC, that they're not there. So, you know, I think there were concerns about us just sort of going in a completely different direction in courts now, just detaining significant number of young people, and we haven't seen that.
So I guess in terms of the increase, there is some increase in the number of juveniles who are subject to pretrial detention. Exactly how large that is, you don't know.
I can get you the number, like the trend of increase.
But in the scale of it is very different. If on the one hand it's 1,200, 1,500, on the other hand it's 70, 90, could be 10, 15% increase, but those numbers are different in the different settings.
Sure.
What kinds of outreach are we doing to those kids, doing with those kids while they are in pretrial detention? One of the things that we heard about in this process was this sense that there were folks out there who wanted to have a chance to reach these juveniles to help them get off of a path that was going to lead to nothing good for them. What kinds of things are we doing in taking advantage of that pretrial detention?
So, I mean, one of the things is, right, like when young people are in pretrial detention at YSC, we have them there. So we're able then to do the types of assessments of what are their mental and behavioral health, what's going on with family, what is happening with education. We can get them re-engaged with school, which is so critical because when they're released, right, like we don't want young people truant. And really a huge piece is building connection with family. And so that's a focus for Director Abed and the DWRS team. I'm going to talk about something that has been deeply controversial. I use the juvenile curfew, enhanced curfew pilot as an example of the type of bridge building that we're trying to create across government with our at-risk young people and families. We have not had wild numbers picked up, but we have had a good number of young people picked up, and it is revealing where we need connections with CFSA and also connecting DYRS. We have had multiple conversations with DHS, CFSA, DBH, who are all in on making sure that we have an understanding of being able to screen families when they come to get their young people for need. Do you need TANF and SNAP, but you aren't able to go to DHS? Do you already have connectivity with one of our sister agencies? We're doing that work because we're able to say this young person was out at 3 o'clock in the morning. Like maybe there's something going on here. And that really has been like exciting and also a revelation of, yeah, we need to help bridge these gaps, and DWRS is really a good agency to help us do it.
So last thing, and then I have heard from lots of quarters that actually pretrial detention can have a negative consequence on juveniles, and the argument was made that this is an opportunity to have a positive impact on juveniles. And it's an abstract conversation to me at this point, and there is data on the one side. What kinds of things can you do to gather data to make the case that these pretrial detentions are actually helping in order to keep kids get kids onto a path that's more constructive for them? I've used up my time, and that could be a long answer, but I will, as we're going forward in the next weeks, that's going to be the kind of question that I'm asking you.
Sure. I mean, I can say, like, one of them obviously is arrests, right? Like, we want to make sure that young people are not being rearrested, which is such a base level one, but really is, like, when they're released from pretrial or they've gone through their disposition, are they then getting arrested? Are they engaged in school, right? Like, this is such a critical piece for young people, right? Like, are they connected to school now, right? Like, are they engaged in pro-social activities? Are they engaged in crew-based activities? Some of this really is person by person, and we really are oftentimes looking at young people that way, right? Like, so the aggregate data is a much smaller pool that you're pulling from, but happy to explore all of these different data points that we know indicate how a young person's doing, which is a little bit different than developmentally or otherwise than an adult.
Thank you.
Thank you very much, Councilmember Fruman. And we're going to turn to Councilmember Parker in a moment, but I just have one follow-up question about what Councilmember Fruman was asking you about. And when we look at the efficacy of the curfew, and you talk about kind of connecting young people to services, how has that process been going in practice in coordination with the sister agencies? And also, if you can briefly talk about as well, you mentioned the capacity being at 91 beds or capacity being 88 beds and the high end being at 91. Can you talk about the interrelationship between YSC and New Beginnings?
Sure.
So we can get a sense of kind of if folks are rolled over or
yeah, I can start there. So obviously both of those facilities are controlled by DWRS, and with the various populations, including the detained young people have to be at the YSC. That's part of their court order. But like I mentioned, there are committed young people at YSC. One of the things that we're working on, for whatever reason, previous leadership had chosen to close the girls unit at New Beginnings, which was leading to young people who are committed. There's very limited secure or residential treatment facilities for girls. So they were at the YSC for long periods of time. We are working on reopening that so that those young people who are committed, the girls, can have a therapeutic program at New Beginnings. But it's another example. We have also the population of Title 16 young people at YSC. There's a fluidity there that DWRS can control if they're at YSC or New Beginnings. Some are at New Beginnings, some are at YSC. So those are the type of, in those other populations, there's able to be adjustments made by the agency between facilities. On the curfew piece, it's not anecdotal that it's very much like child by child, the type of coordination that we've sometimes struggled with across system, where this is DMHHS and these are DMPSJ agencies. I use one child from last weekend as an example. He had been picked up overnight by MPD and brought in, and upon speaking with social workers, it was discovered he had been sleeping in a park by Cardozo for 5 days. And he was discovered because it was thundering and lightning, so he couldn't stay in the park. He had been stealing food from CVS. That's one child. What happened is we called CFSA and engaged, but by the next day, it was a teaming process. He was picked up on Saturday night. By Monday, where DHS got him a bed, right? We engaged with the school and were able to go up to his high school and have an actual meeting of DHS, CFSA, MPD. All of those were somehow touching these families who normally wouldn't know. That's really what the issue is a lot with our young people we don't know why they're out at 3 o'clock. This weekend, we had a set of 4 girls who were picked up at 3:30 in the morning because they got stranded at the Brooklyn Metro wandering around. One was 14, and their parents came and got them and were livid because they thought that their young people were someplace else that did not involve walking around in the Brookland area at 3:30 in the morning. So it's that type of thing where we're like, okay, maybe there's no issue there, but parent now knows, yikes, right? And that's ultimately what we want to do is empower a parent, but we've worked out a process that by sort of a slowly rolling into this, it's not like this mass of 100 kids. We're able to say, okay, you know what? It didn't work when we called. Do we need to refine who the contact person is at CFSA? Yes. And it's really been at the deputy mayor and the director and then the worker level where we're all on calls together. That doesn't always happen, right? But it is, so, yeah.
Well, thank you so much. I think that's really important clarity, especially as we think about the distinction between being detained and being committed.
Yeah.
And in our broader conversations about a one-size-fits-all not working for every child and really needing kind of all of those touch points. So thank you for that. Next, I will turn to my colleague, Councilmember Parker, for a 10-minute round.
Thank you, Chairperson Pinto, and thank you both for providing testimony. I'm going to continue with this line of questioning, and then I'm going to zoom into some of the legislation that is the center of today's hearing. Regarding the curfew, Deputy Mayor, would you classify it as a success? I know the data, we're still finding what is and what's not, but generally speaking, would you say to this point it's a success?
I mean, it's so early, right? We started, I think, the September 1st. I think there are pieces that are deeply successful, right? There were 2 things we really wanted. We were seeing too many young people shot, right? We cannot have our young people dying over sauces, yes, in U Street at 3 o'clock in the morning. So there's the real sort of base level, which are real things that are happening, that overall through all these efforts, we actually have seen a reduction, we have too many kids who've been shot, but we are seeing some stability there. We were so above where we were last year, which was already way above. Mm-hmm. We seem to have stabilized that through what we knew to be true. Our young people seeing us being we are all hands on deck, because we want you to live. So there's that piece of we're not mm-hmm. having children shot in the middle of the night or committing pattern offenses, which was the reason the areas were chosen, including in your ward, council members, there were these pattern robberies, 3 juveniles, 2 o'clock, 3 o'clock. So we definitely have seen a reduction in that. That's how we're getting to a 34% reduction in robbery. So that's one piece. The other piece is overnight, the midnight hour, the midnight shift is when we were seeing a lot of our crime. And so in the areas we named, MPD would normally spend hours, honestly. They first ask young people to go home and still do that. They would spend hours trying to either locate a parent or otherwise at the precinct. We need police to be policing during those critical overnight hours. So this is now putting the onus where it should be on social service professionals to do that work. So I would say that in that sense, very early, that those are successes.
And you teed up my second question. How were the areas selected that were part of the curfew?
Yep, so it's 2 things. One is where we're seeing large, I'll use U Street as an instance. We all saw during this summer that there was very large groups of young people out late at night committing what was some of it criminal and some of it mayhem, right? And I mean, we saw Howard and these various things in kind of that U Street corridor. In other areas, it's what I described, that we were seeing real patterns overnight of juveniles engaging in criminal conduct. And so a lot of the pattern offenses that we were seeing. And so those were really the 2 predominant. Where are we really seeing young people out in the middle of the night, really that 2, 3, 4 o'clock hour? And where are we seeing the types of pattern offenses where it would be like 230, 236, kind of up and down a corridor?
Got you. The robbery suppression unit, which is a new strategy that Acting Chief Smith unveiled when she came to Ward 5 and the Brooklyn community following a string of robberies in that neighborhood. I can share data from the commander that we went in the Brooklyn community from, let's say, 20, 25 robberies down to 3, which are still 3 too many, but the robbery suppression unit did seem to have some type of impact on what was playing out in the community. Can you just speak to how are you scaling that unit? How are you dispatching it? And how are we using data that we have available to target robberies that are still popping up across the city?
Sure, and I would say in your district, the 5th district, we actually have seen a 24% overall decrease since the initiation of the robbery suppression initiative in the middle of July. So, right, like 1 is too many, but certainly we're encouraged by that reduction in the 5th district. So the one of the things that the chief, and I don't want to steal her thunder, but would say is that I think the chief brings a fresh perspective on the agency working together. I think we recognize that we are down officers, right? Like we've had that discussion, but what it requires is new ways of working together. And so one of the things that's happening is types of, I always say grassroots communication, where it's like, if something happens in the 5th district, they're headed to the 4th district. So there's a much more real-time communication going on that's really helping us stop those patterns, including the activation of the JOC on the weekends, the Joint Operations Center, so that they're monitoring in a way that will help. If you see people hitting robberies in 5th district, we know they're headed to the 6th district. So we're able to real-time intercept some of that behavior. I think the scaling comes as one of the things the chief said at the public safety situational update is we've started to see, we have right now the strongest pipeline that we have had since 2020, right? We've got about 270 folks in the pipeline. We have our largest recruit class graduating next week that we've had in several years. And so as we have new officers enter, we'll be able to continue to scale. But the other thing that the chief brings and is doing is those federal partnerships we always talk about that really help us augment these type of activities, whether it's CSOSA and the marshals who've come to us to be like, hey, what can we do, to our partnerships with ATF. It allows for the type of force multipliers that really help us to scale in the way you're talking about.
My next topic is cameras.
Yes.
The mayor has announced the release of some hundreds of cameras across the district, and what I'm not clear on is the strategy around utilizing the cameras that we have, and how are we targeting areas with significant need and where community members are requesting cameras. I can tell you, and as you know, there are several communities in Ward 5 that are saying, we want a camera, so it's not a matter of like surveillance. Like, what is the strategy there, and can you provide any clarity around timeline for the new cameras that have been promised?
Sure, and so just for clarity, like, so there's the ATE cameras, that's the hundreds of cameras you're talking about, but CCTV,
yes,
I believe we have, oh, I don't want to get the number wrong, it's either 20 or 50. I need to get back to you on that, but that are already in the pipeline for deployment. The way that they determine that is really working with you all, right? Like, I think MPD certainly works with.
Well, respectfully, yes, that is what I've heard, but I have not gotten any clarity around date, timeline,
we'll get that for
quantity,
you because,
neighborhoods.
Yeah, so I can get that for you. The cameras, I believe that they're already in, or that we have them, right? Because part of this is pipeline, right? But I believe we already have those cameras. MPD has a process, like I said, of prioritization. One is they're not putting any up until they've had conversations with you, and also looking at crime patterns, right? Like there are some neighborhoods, generally the ones you refer to are the same areas that would see the clusters of crime that would necessitate cameras. So I'm happy to have MPD really share like what because I asked them the same thing, and they're like, it's working with council members, and it's looking at crime patterns, and it's talking with the commanders. Okay. So we can get the date of deployment, because I believe the cameras are in. But this
and that would be helpful for us to be able to communicate out to residents when they are asking.
Absolutely.
One last question, then I do want to turn to the legislation, and it's just generally about the district's public safety strategy. I have repeatedly said we need to zoom out and not be so hyper-focused on MPD and thinking about how we're going to keep the district safe. And this is another area where I lack clarity. What is the district's public safety strategy? Do we have one? And where should you point someone when they ask that question?
Yeah, I mean, I think, so we always say an ecosystem. There are 13 agencies, or 12 plus the National Guard, right, that are in the public safety and justice cluster, but that's one side, right? Each of them have statutory responsibilities and missions and key performance indicators, things they must meet that we say, you need to be excellent at this in order for us to have a functioning public safety and justice ecosystem, whether that's fire EMS responding well. I won't go into all that because you know that, but when it comes to plans, there are multiple plans. The Safer, Stronger plan, it's a good plan, right? That was done in 2015, and much of the work is being done on that. When you look at following plans, people talk about NIJCR plan. We are doing much of those things because many of them the same.
Well, here's my recommendation, respectfully. As a council member, I cannot articulate to neighbors what the district's public safety strategy is. And while there are certainly different pieces of legislation, I think many of them have merit, that's not quite a strategy. And so if I could make a recommendation, it would be helpful for the executive to say, and to call across government, what is our all of government approach to turning things around? In my last 20 seconds, I did want to just come back to Bill 25-348, and I heard you say, as written, the executive couldn't support it. Is there a commitment for the executive to work with this committee and the council to get this right, given that the majority of council members did support this? And I do think the focus on sexual assault is very important. Yes. Thank you.
Of course, yes.
Thank you very much. And Councilmember Parker, you weren't here when I shared that we just had this one round. So if you have a last question or anything, you're welcome to.
It's going to be more data related, and I'll follow up offline.
Okay.
Thank you.
Sounds good. Thank you. Thank you both very much. Really appreciate it. And Mr. Park, we'll continue to work with you as well on some of those improvements. All right. Thank you to Director Park and Deputy Mayor Pia. We are now going to turn to our next panel and last panel of government witnesses. Elena Suttenberg from the U.S. Attorney's Office. Katya Seminova, Special Counsel to the Director for Policy Public Defender Service for the District of Columbia, and Janice Bechtel, Chief Domestic Violence and Special Victims Section, the Office of the Attorney General for the District of Columbia. Thank you all. Welcome. And as you all know, it is the tradition of this committee to swear in all government witnesses who appear before it. So if I can ask you all to raise your right hand. Do you swear or affirm under penalty of law that the testimony you are about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth? Thank you all very much. I'd now like to invite you all to make any opening statement you may have. Elena Suttenberg, you may begin.
Good afternoon. Chairwoman Pinto, members of the Council. My name is Ilana Suttenberg. I'm the Special Counsel for Policy and Legislative Affairs at the U.S. Attorney's Office for the District of Columbia. I'm accompanied today by my colleague, Sharon Marcus Kern. She's the Chief of our Sex Offense and Domestic Violence Section. She's available to assist in answering any questions from the committee. I thank you for the opportunity to appear at today's public hearing to share the office's views on the proposed legislation. USAO strongly supports Bill 25-345, the Accountability and Victim Protection Amendment Act of 2023. USAO supports this bill because it will provide additional tools to protect some of the most vulnerable members of our community and hold accountable those who harm them. Our office is committed to aggressively prosecuting all forms of violence, including sexual assault and domestic violence against adults, teens, and children, and to protecting our community from these often life-changing acts of violence. This bill makes numerous important changes to the law, which I will summarize briefly today, but which I have discussed in detail in my full written testimony that I have submitted to the Council. First, this bill makes several common sense and needed updates to the criminal statute of limitations, which are consistent with the Council's previous expansions of the statute of limitations. This bill adds stalking convictions to those convictions that would bar people from possessing firearms under DC Code 224503. This category of convictions represents particularly dangerous behavior that may be indicative of future lethality and domestic violence in other situations. This bill adds new local evidentiary rules equivalent to federal rules of evidence 413 and 414. These rules would provide a court discretion to admit evidence of previous similar crimes in sexual abuse and child sexual abuse cases, but would not require the court to admit the evidence. The admission of this evidence would be subject to the general evidentiary principle that evidence may be excluded if the court finds that the probative value of the evidence is substantially outweighed by a danger of unfair prejudice. But this bill explicitly incorporates the balancing test that is in Federal Rule of Evidence 403. This bill makes several changes to current law that would further promote the health of crime victims with respect to HIV. When a victim has been exposed to HIV through the commission of the crime, the victim needs to have access to information that can inform their medical decisions and their ability to protect themselves from being infected with HIV. Consistent with the provisions in the Prioritizing Public Safety Emergency Amendment Act of 2023, this bill clarifies the definition of significant relationship in sexual abuse cases. This fills a gap in liability by clarifying that a contractor of a school, church, synagogue, or similar institution has the same liability for sexual abuse as an employee or volunteer of the same. Consistent with the provisions of the Emergency Act, this bill clarifies that GPS records from the Pretrial Services Agency may be used in court as evidence of guilt in a criminal case or other judicial proceeding. This is a common sense clarification that GPS records from pretrial services that, for example, indicate that a defendant was on the scene of a domestic violence incident or a murder can be admissible in that defendant's trial for domestic violence or murder. Consistent with the Emergency Act, this bill permits, but does not mandate, a judge to make a misdemeanor arrest warrant or summons extraditable, which means that it could be executed outside of the District of Columbia, including in neighboring Maryland and Virginia. Under this bill, a misdemeanor arrest warrant would only be extraditable if the judge finds good cause for it to be so. Good cause would be presumed where the offense is an inter-family offense or a misdemeanor sexual offense, though good cause could exist in other situations as well. This bill creates progressive sentencing for repeat misdemeanor sexual abuse, such that a person who has previously been convicted of misdemeanor sexual abuse charged with that same crime a second time may be charged with a felony offense. This bill makes several conforming changes to the recently passed Expanding Supports for Crime Victims Amendment Act that would enhance that legislation. Consistent with the Emergency Act, this bill allows a court to designate a case of special public importance where the child is a victim or is called to give testimony in the case. This bill makes a modest modification to a penalty enhancement that applies when a victim of sexual abuse is under 12 years old at the time of the offense to also include victims who are 12 years old. This bill creates an enhancement that would apply to an inter-family offense or crime of violence where the defendant committed the offense in the presence of the child or where the child otherwise witnessed the offense, including by sight, sound, or otherwise. As summarized by the U.S. Department of Health and Human Services, research shows that even when children are not direct targets of violence in the home, they can be harmed by witnessing its occurrence. Children who witness domestic violence can suffer severe emotional and developmental difficulties that are similar to those of children who are direct victims of abuse. Consistent with the Emergency Act, this bill creates a felony offense of strangulation, which is widely recognized as one of the most dangerous forms of domestic violence and a significant predictor for future lethal violence. This bill closes a loophole in the law criminalizing distribution and publication of non-consensual pornography by modifying the provision requiring an agreement or understanding between the parties that the sexual image would not be disclosed. Instead, the law would require that, essentially, the defendant knew or was reckless to the fact that the person depicted did not consent to the disclosure. This bill closes a gap in the senior citizen victim enhancement, which allows many offenses to be enhanced, but does not include assault with significant bodily injury as an offense that can be enhanced when it is committed against a senior citizen. As to Bill 25-348, the Ensuring Safe Forensic Evidence Handling for Sexual Assault Survivors, we appreciate the intent of the bill, which is to support survivors of sexual assault, even in situations where they do not wish to report the sexual assault to law enforcement when they undergo a sexual assault nurse examination. At the same time, we have some technical concerns with several aspects of this bill that may have unintended consequences, and we have concerns about the implications of storing this type of evidence at the Department of Forensic Sciences. We would be pleased to work with the committee to address those concerns. We also have significant concerns about the bill's proposed limitation on mandatory reporting for certain counselors who work with victims. Our office strongly supports the appropriate expansion of mandatory reporting laws as a means to protect children and to allow law enforcement to identify and stop child abuse. As previously stated by this committee in 2012 in the committee report accompanying mandatory reporting legislation, child sexual abuse is a deplorable crime that deprives victims of their voices and can cause emotional, physical, and mental trauma for decades after the abuse has ended. In order to end such heinous crimes, authorities have to know about the abuse, and such knowledge can only come from individuals who report to the authorities. Given individuals' hesitancy to come forward, encouraging reporting is key. This bill, however, proposes limiting the mandatory reporting obligations of sexual assault counselors, human trafficking counselors, and domestic violence counselors who may be the first person to speak with a child victim about what happened. Although there are other mandatory reporters that a victim may interact with as part of an investigation, such as a physician or a law enforcement officer, a victim's initial interactions and conversations with a counselor may inform what, if anything, the child discloses to a subsequent mandatory reporter or other trusted adult. We appreciate the Council's consideration of these important measures as we all work together to protect the most vulnerable members of our community, including children, victims of intimate partner violence, victims of sexual assault and abuse, and elderly victims, and hold accountable those who harm them. Thank you.
Thank you very much, Ms. Suttenberg. Ms. Seminova from Public Defender Service.
Good afternoon. I'm Henrietta Seminova, Special Counsel for Policy and Legislation at the Public Defender Service. Thank you for the opportunity to testify on Bill 250345. This legislation, which was developed exclusively with the United States Attorney's Office, will create ever longer sentences for crimes that are already severely punished, and it will irreparably harm the right to a fair trial without improving community safety. It is moving forward to a hearing now, less than 3 months after its introduction, with no input from the defense apart from this hearing. The focus on incarcerating more people for longer while eroding due process protections will not make the district safer. Instead, it will undermine the credibility of the district's legal system and lead to wrongful convictions while community harms continue. PDS's testimony will focus on 4 provisions of the bill. Our full written testimony will address additional sections of the bill. First, the evidentiary rules. Changing district law to allow for the nearly unrestricted use of character evidence in sexual abuse cases is not simply a matter of aligning district law with a non-controversial federal evidentiary rule. Rather, the proposed change would have the district adopt Rules 413 and 414 from the Federal Rules of Evidence. These federal rules come from the maligned and disavowed Violent Crime Control and Law Enforcement Act of 1994, the 94 Crime Bill. This is the bill that Hillary Clinton was speaking in favor of when she used the term super predator, now generally accepted as a racist term in that context. And this is the bill that former President Clinton later said that by signing, he made, quote, the problem worse. Although he supported the 1994 crime bill, then Senator Biden said that this evidentiary provision, which came as a Republican amendment, was, quote, not a fair thing to do to an individual. The impact of Rules 413 and 414 cannot be overstated. Through a single amendment tacked onto the crime bill, Congress overturned a rule of evidence that had been a pillar of Anglo-American law for centuries. For hundreds of years, it was the law that the prosecution could not introduce evidence as to the character of the defendant, including evidence of the defendant's so-called prior bad acts, unless those acts were relevant to a contested issue in the case. The general prohibition existed not because the evidence of prior wrongs has no relevance, but because the negative impact of the evidence would undermine the right to a fair trial and destroy the presumption of innocence. The proponents in Congress of the new rules, essentially the same rules that the United States Attorney's Office now urges the district to adopt, had one goal: securing more convictions. Then Senator Bob Dole argued for the passage of the new rules, claiming that, quote, if we are really going to get tough, if we are really going to try to make certain that justice is provided for the victim, then we ought to look seriously, meaning at this amendment. Former Senator Dole was wrong. Undermining the fairness of trials increases the risk of wrongful convictions. Wrongful convictions do not provide justice for victims. Wrongful convictions are simply unjust. While congressional debate on these rules ignored the rights of the accused and the need for fair trials, this council should not. The federal rule change also bypassed all of the regular channels for enacting federal rules of evidence, which normally go through an advisory committee. Commenting on the rules after they were passed, the Advisory Committee on Evidence of the Federal Judicial Center said, quote, "The new rules, which are not supported by empirical evidence, could diminish significantly the protections that have safeguarded persons accused in criminal cases and parties in civil cases against undue prejudice. These protections form a fundamental part of American jurisprudence and have evolved under long-standing rules and case law. A significant concern identified by the committee was the danger of convicting a criminal defendant for past as opposed to charged behavior or for being a bad person." While it is clear that Congress intended this rule change to be adopted by the states, states have not universally done so. Reporting from 2018 showed that only 16 states have adopted these rules, and that at least 2 states have rejected the rules as violating their state constitutions. For example, the Iowa Supreme Court rejected the rule change as violating, quote, "fundamental conceptions of fairness," and the Missouri Supreme Court held the rule violates constitutional protections vital to the integrity of our criminal justice system. This is not an area where the district should simply follow federal law. Further, it should be clear to the council that under current DC law, prior bad act evidence is already admissible in all cases for a broad range of legitimate purposes, just not for propensity. Evidence of other crimes is admissible when relevant to motive, intent, the absence of mistake or accident, a common scheme or plan, or identity. These bases of admission are not necessarily exhaustive. In sex cases, there is yet another basis for admission, unusual sexual preference. This exception permits the government to introduce evidence of prior sexual misconduct against different victims if it establishes an unusual sexual preference. If the same victim is involved, prior bad acts are always admissible under a motive theory. Chairwoman Pinto, you mentioned Harvey Weinstein's case in your opening remarks. And in New York, which has essentially the same rule as DC, that evidence was admitted as evidence of prior bad acts under a similar exception. This is no small matter. Unbridled admission of other misconduct evidence of a sexual nature will blind the fact finder to whether the government has proven its case beyond a reasonable doubt, erode the presumption of innocence, and result in wrongful convictions. As our Court of Appeals has recognized, this rule, so universally recognized and so firmly established in all English-speaking lands, is rooted in that jealous regard for the liberty of the individual which has distinguished our jurisprudence from all others, at least from the birth of the Magna Carta. It is the product of the same humane and enlightened public spirit which, speaking through our common law, has decreed that every person charged with the commission of a crime shall be protected by the presumption of innocence until proven guilty beyond a reasonable doubt. The council should reject this proposal and preserve the right of district residents to a fair trial. Next, raising the age for enhancements and lifetime registration in sex abuse cases. The bill also proposes multiplying maximum sentences by 1.5 and applying the harshest sentence of life in prison without release to sex assaults and sexual contact against children under the age of 13, instead of the current application of that enhancement for crimes committed against children under age 12, and requiring lifetime sex offender registration for additional offenses. These changes are styled as protecting 12-year-olds. To be clear, sexual assault and sexual contact against 12-year-olds are seriously punished. There is no consent defense to sexual contact between an adult and a 12-year-old child. There is no mistake of age defense for sexual acts or sexual contact committed against a 12-year-old child. First-degree sexual abuse against a 12-year-old is currently punishable by a maximum sentence of 30 years of incarceration. Conviction requires lifetime sex offender registration and the potential for lifetime supervised release. Under current law, enhancements for the use of a dangerous weapon, significant relationship, accomplices, and prior conviction already multiply all maximum sentences by 1.5 or increase 30-year sentences to life, regardless of the age of the victim. Given the long sentences already in place for sex offenses against 12-year-olds, this extension cannot be labeled a form of protection for children. Changing the statutory scheme that has existed since the passage of this chapter, and in this case that mirrors the age delineation in federal law in the United States Code, should be the product of careful deliberation. The Criminal Code Reform Commission and the advisory group to the CCRC, consisting of PDS, OAG, USAO, representatives from the mayor's office, and 2 district law professors, never considered changing the age delineation. It was never proposed as part of code reform or even discussed. It should not be undertaken now and in this fashion. This is precisely the piecemeal and reactionary legislating that the code reform project was meant to stop. There's too much to consider with respect to this legislation, and that cannot be done adequately and in this forum. The proposed change is not necessary, is harmful, and will not protect youth. Advocates for youth and families have ideas about how to help and protect youth. The district should listen and invest in those strategies. With respect to the statute of limitations, the district expanded the statute of limitations in 2005 and again in 2019. The prosecution has beyond ample time to bring criminal charges. 21 offenses have no statute of limitations and can be brought at any time at all. The offenses with no statute of limitations include murder and nearly all felony sex offenses. The reform proposed by the USAO would eliminate the statute of limitations for any attempt, solicitation, conspiracy, or assault with intent to commit one of the 21 offenses, and for any joinable offenses, including misdemeanors and minor felonies. Under the USAO's proposal in 2063, 40 years from now, a person could be charged with attempted fourth-degree sexual abuse for attempting to touch the buttocks of a friend who is allegedly too intoxicated to consent at a 2023 holiday party. For decades, 4 decades later, how could the accused find witnesses or remember anything about these events? As expressed by the United States Supreme Court, a statute of limitation is, quote, designed to protect individuals from having to defend against charges when the basic facts may have become obscured by the passage of time, and to minimize the danger of official punishment because of the acts in the far distant past. Considering that these allegations expose individuals to incarceration, supervised release, and sex offender registration, the balance between the interest in prosecuting offenses and the need to protect the right to a fair trial should be struck carefully. The Council has already done this in 2005 and 2019, and it should reject the proposal to once again go further. For enhanced penalties for child witnesses, finally, the proposal to increase penalties by 1.5 times when a crime of violence or intrafamily offense is witnessed by a child will not make the district safer or create stronger communities. The district already increases penalties for weapon and drug offenses in school zones, and criminal intent may be inferred if children are in the zone of danger created by an individual's actions. The reality of living in a city means that people, including children, may always be witnesses to events. Further, because sentences in the district are already long and many offenses are poorly defined, increasing maximum sentences only exacerbates disproportionality. For example, an 18-year-old who commits the offense of robbery by taking a purse that is left on a chair at a restaurant where a parent and teenager are eating would now face a maximum penalty of 22.5 years of incarceration. With respect to intrafamily offenses, this enhancement targets individuals living in small apartments where children may always hear and see what happens. This legislation would pull children into the criminal legal system, forcing them to serve as witnesses for the government or for the defense. This does not help families recover from conflict, it does not give them the resources to avoid conflicts, and it does not have any additional deterrent effect. Again, if the Council wants to help families and children, there are myriad ways of doing so, and this is not one of them. We welcome the committee's questions. Thank you.
Thank you very much, Savinova. Next, we will hear from Janice Bechtel, Chief Domestic Violence and Special Victims Section at OAG. Go ahead.
Good afternoon, Chairman Pinto and committee members. It's a pleasure to be here. My name is Janice Bechtel. I am the Chief of the Domestic Violence and Special Victims Section at the Office of the Attorney General for the District of Columbia. I am pleased to speak about 2 of the bills you're considering today, the Accountability and Victim Protection Amendment Act of 2023 and the Ensuring Safe Forensic Evidence Handling for Sexual Assault Survivors Amendment Act of 2023. OAG's Domestic Violence and Special Victims Section consists of 17 attorneys, victim witness specialists, and legal support staff who, in addition to holding criminal offenders accountable, work to help survivors of crime return to a sense of normalcy in their lives. We assist survivors in obtaining and enforcing civil protection orders for domestic violence and stalking. We prosecute sex offenses committed by juvenile offenders and offenses committed against vulnerable victims. And we provide protective measures for neglected and exploited seniors. We hear firsthand and on a daily basis the pain, fear, and uncertainty that victims face. And we strive to ensure they have the support they need and the accountability they deserve. We support the provisions of your bill that we believe will help secure justice for survivors of domestic violence and sexual assault. And we laud the goals of Councilmember Allen's bill, which I will turn to later in my remarks. The Accountability and Victim Protection Amendment Act will enhance our ability to bring and prove charges related to sex crimes and crimes against elders and children. Our written submission speaks to the benefits of a number of these provisions, but I will confine my oral remarks to just a handful of these reforms before turning to two areas we believe merit further discussion. First, we are thrilled about the provisions addressing unlawful disclosure and publication of sexual images. Eliminating unrealistic and unnecessary elements of crimes related to non-consensual sharing of sexual images will make it easier to address an increasingly common form of intimate partner abuse that often eludes prosecution. It is estimated that as many as 1 in 12 individuals have experienced the non-consensual sharing of intimate images, and victimization is greater among young women and those in the LGBTQIA community. Current law makes prosecution of such acts unnecessarily difficult, and this bill will remedy that problem. Second, giving our office the ability to obtain extraditable misdemeanor warrants will help us prosecute perpetrators who violate no-contact orders from other states or who cyberstalk their victims from outside the district. We have regularly encountered situations where a survivor is harassed with frequent, unwanted, and intrusive communications by an out-of-district perpetrator whom we've been unable to compel to face charges here in the district. The proposed change to the law will finally offer the relief victims seek, while also aiding in prosecution of criminal traffic violations when drivers flee the district after an incident. And third, we agree on the importance of creating a standalone felony for strangulation, which, although non-lethal, can nevertheless cause serious physical and psychological injury. Treating strangulation as a felony is especially important, given that it often precedes other more deadly violence. It is time the district joined 49 sister states in recognizing the gravity of this act. Although there is much to support in this bill, there are two provisions that merit further discussion. First, the admissibility and use of character evidence at trial. The default standard in prosecutions is that evidence of a defendant's prior bad acts is not generally admissible to prove guilt. This standard was developed because such evidence is likely to be unfairly prejudicial, particularly if the prior acts are uncharged and the defendant has not had an opportunity to defend against them. This bill proposes allowing evidence of prior acts in adult and child sexual assault cases to overcome the credibility gap that victims of sex crimes often confront. We understand the impetus behind this proposed change, but we also recognize that this would be a dramatic departure from a long-standing, carefully balanced evidentiary rule in this jurisdiction, a change which only a minority of states have adopted. Second, we have a similar concern regarding the elimination of the statute of limitations for lesser included or properly joinable offenses. Statutes of limitations are designed to protect fairness and reliability, interests that could be undermined when trials are commenced after the significant passage of time. At the same time, our community has deemed some crimes like murder and sexual assault so serious that they have no statute of limitations. It makes sense that the clock never runs out on justice for such severe violations of our social contract, and recognizes that, especially in the context of the shame and secrecy surrounding sexual abuse, it may take years for victims to come forward. The bill, however, proposes that other arguably less severe crimes like burglary or simple assault, if joined with a charge for which there is no statute of limitations, would similarly face no statute of limitations. While the goal of helping victims achieve complete justice is laudable, the rationale for statutes of limitations applies no less strongly for lesser crimes, even if they might be joined with charges for more serious crimes, which are not barred by limitations. We urge careful consideration and further deliberation of both of these provisions to strike the right balance between the due process concerns these changes present and the very real need to help survivors of sexual assault achieve justice. I will now turn briefly to the Ensuring Safe Forensic Evidence Handling for Sexual Assault Survivors Amendment Act of 2023. OAG wholeheartedly supports creating a storage protocol for all physical evidence recovery kits, or PERKs, colloquially called rape kits, including those collected from survivors who have not chosen to make a report to the police. Such preservation respects survivors' autonomy while maintaining a future law enforcement option should the survivor so choose. The current approach of leaving these kits in scattered medical institutions both in and outside of the district leaves too much to chance, and risks losing valuable evidence. So thank you to Councilmember Allen and the co-sponsors for considering needed reforms in this space. In light of concerns about the protocols and policies within the Department of Forensic Sciences, we encourage the Council to create robust and stringent accountability measures to guarantee this evidence is properly stored. We welcome the opportunity to collaborate on that and to develop protocols and mechanisms that protect survivors' confidentiality while ensuring they have the tools necessary to seek justice. We look forward to collaborating with the Council as these bills move through the legislative process and also welcome opportunities to address other aspects of victim support in the future. Our partnership is critical to reforming the district's criminal laws to ensure they more closely map our community's shared vision of justice and support for survivors. Thank you.
Thank you very much. Thank you all for your very helpful and powerful testimony. Ms. Seminova, I want to start with you and the conversation around the evidentiary rules, because I think this is a really important element of our American justice system, that a defendant is on trial for the crime before them. And in this exception that has been developed in our federal evidentiary standards and that we're considering today, part of the thinking is that there are certain crimes that have been demonstrated over time to be a pattern, dissimilarly from a viable defense for other crimes that may rely on economic disadvantage or moment of fury, as it's referred to. So is your view that there should be no distinction when it comes to evidentiary standards for defendants accused of the most egregious sexual assault cases?
The Court of Appeals has created a different exception regarding the admission of prior bad act evidence for crimes that relate to sexual abuse. So, for example, an unusual sexual preference can be admitted. Evidence of motive is considered differently in the sexual abuse context potentially than it is in the context of other crimes. The analysis that the court does is sufficiently flexible for across accusations and across offenses that are charged to look at the evidence that is being proffered of other bad acts, of alleged other bad acts, and to decide whether that evidence is going to a genuine contested issue in the case or whether it is being offered merely as propensity evidence. And that is the key there. And the current standard allows for the admission of this evidence under the framework that I discussed. Motive, intent, lack of mistake, unusual sexual preference, a non-exhaustive list that allows this evidence to be admitted, but truly for a purpose and not just for propensity.
Okay, thank you for that clarification. Because I think as the committee weighs the balance of the unique nature of these crimes and how infrequently victims are believed, thinking about weighing the balance of how these cases can be made effectively. Are you familiar with how there are a number of states who have adopted the federal evidentiary standard? Do you have any information on how that's worked in practice and if it has led to wrongful convictions?
Of how it has worked in states that have admitted have the states that have this? No, I do not know exactly the trajectory in those states, nor is it clear that in each instance that where it was admitted, it would not have been admitted under the recognized exception of 404B that existed everywhere else. I don't know that the same sort of rationale can be. That this rationale of victims of sexual offenses are not believed can be sort of applied as a blanket statement to all individuals, to all cases. That was certainly part of the rationale in 1994 with the passage of the crime bill. I think that not only are we socially in a different place, but I think the evidence is in a very different place where there is DNA evidence that is much more highly sophisticated, available, reporting trends are different. So I don't know that that same rationale that was certainly used in Congress when it was passed is applicable to the same degree today. And it certainly never should trump the right to a fair trial. And what states have found and what the justice system overwhelmingly has said and recognized is that this evidence of prior wrongs, deprives the individual of a fair trial on the actual charges that they are facing.
Okay. Well, thank you. And I hear you that there are a lot of other changes that we have in today's society, and DNA testing is one that you mentioned. So another thing that this bill seeks to do is around DNA testing and having the ability to use that information as part of a database. Is that something that you all continue to have concerns with?
It is in the second bill. Sorry, it's not in terms of, yes, it's not in that bill. It's in. Are you referring to the storage of PERT kits?
Got it. No, I'm thinking about your testimony for the Safer Stronger bill in June about the DNA and as part of the considerations we're making. But you're right about this bill.
Right, and that was arrestee testing.
Right.
For DNA prior to warrantless, sort of automatic testing at arrest, which I think is very different when there's no request made by the prosecution for testing. There's no judicial consideration of whether there is evidence that should be tested or evidence that can be compared. It is just a pretrial testing, or just even at arrest, which we very much disagree with and opposed in that bill.
Right. Okay. Thank you. Ms. Suttenberg, Ms. Bechtel talked about the statute of limitations concerns and in cases like burglary, for example, perhaps going too far in recognizing the victim's concerns and traumatization and likelihood that the victim in the sexual assault cases may take many years to come forward, but the same considerations aren't necessarily there for these other cases. Do you have a response to that and kind of what you're seeing in practice and weighing that concern of finding the evidence and fairness to the defendant?
Sure. So this bill proposes two changes to the statute of limitations, and I can address them each separately. The first thing that this bill proposes doing is allowing properly joinable offenses to essentially have the same statute of limitations as the underlying offense that the council has eliminated for the most serious sexual abuses and murder. So, for example, as I noted, that would mean that a person who is charged with rape, who was burglarized and raped in the course of that, could be charged with both rape and burglary. Otherwise, the burglary statute of limitations is only 6 years. This represents the totality of the conduct that person committed and the harms that were perpetrated upon that victim. The invasion of their personal space in the home may be just as important to them as the actual sexual assault itself. They're both harms that were perpetrated, and this would allow the prosecutors to charge the full extent of the harms perpetrated upon that person. The other one has to do with attempts, assault with intent to commit, solicitation or conspiracy. And that is because oftentimes the severity of the harm is the attempt and the completed offense can, depending on the type of offense, have very similar harms. An attempt and a completion could be the result of whether essentially a victim was able to fight back adequately, that it made it just an attempt. So that we think is a very serious harm, an attempted first-degree sexual abuse, an attempted murder. Those currently only have a 6-year statute of limitations, and we think that is not appropriate and is not consistent with the council's intent in ensuring that these most serious crimes do allow time for the victim to report what happened and the prosecution to commence. If I didn't adequately answer your question, please feel free to follow up.
No, that's very helpful. Thank you very much. And Ms. Bechtel, I know you can't speak to a specific case, of course, but can you talk about generally what you're seeing with juvenile cases in terms of the statute of limitations of the length of time it's taking generally for people to come forward? I know it's different in all cases, but can you educate us a little bit on some of the trends that you're seeing?
Certainly in the juvenile space, it is somewhat different because often, especially if we're talking about the felony offenses, the statute of limitations, we're typically aged out more by the child's age than we are by statute of limitations. So in the juvenile arena, it is not usually much of a bar. a case I've had that was the kind of the longest, and it was getting back DNA results, and it was a couple of years. And again, we just barely had the respondent was still just barely under 21, which allowed us to proceed. But most often they're going to age out before the statute of limitations runs.
I'll do it. In this last minute, Ms. Suttenberg, in terms of the GPS data, it's my understanding that the proposed changes codify current judicial positions on the use of GPS data currently. Can you talk about if this practice is necessary to do this? This is a question that's come up in recent weeks.
Thank you. We agree that this is a clarification to current law. There are some defendants in criminal cases who have sought to challenge this. Our position has been that this is admissible even under the current law without this clarification. This clarification ensures that there is no confusion, that there's no litigation on this point, and that we won't get a subsequent adverse decision that could have the effect of reversing a conviction where a trial judge made the decision to rely on this and a court of appeals decided that that was improper. So this clarifies that that is appropriate, which is very important to provide clarity to the parties and as to what the counsel intends.
Is there any concern that it will affect the defendant's openness with pretrial services?
This bill is very carefully limited to only apply to the GPS data that is collected. It's specifically not designed to apply to any statements that the defendant may make to pretrial services. Those would still be protected under the general confidentiality protections because it is so important that a person be permitted to have those types of confidential protections. So this would only be limited to the GPS data, and that is the only thing that would be changed under this legislation.
Okay. Ms. Semenova, do you have a response to that about the GPS data potentially undermining the openness or relationship with the defendant pretrial services agency?
And that was our testimony on the bill that preceded recess, is that exactly, that the relationship between pretrial and an individual who is supervised pretrial should be one where the individual can come to pretrial for help, for services, for any affirmative programming, and that it should not be used as another law enforcement tool.
Okay, thank you. Thank you all very much. I will now turn to my colleague, Councilmember Fruman, for a 10-minute round.
Thank you very much. And I'm going to stick on that for just a second because I'm trying to understand it. So a defendant can come for services during pretrial, and those conversations, I'm assuming, would be confidential and not subject to use in court, but the data from their GPS tracking, is that the same as going to seeking confidential advice about, different things that were going on? It strikes me that there's a difference there. So am I understanding it correctly? Explain to me why the data itself, because the whole idea of the GPS tracking is to know where the person is to keep them and make sure that they stay out of other kinds of issues. So help me understand that.
I think the pretrial use of electronic monitoring is something that is used by the court to have information about the defendant's compliance with conditions. And so that information is provided to the court to address compliance. And it's another matter to provide that in a different criminal proceeding as evidence against the individual. And so that undermines the sort of the general purpose of supervision to promote a productive relationship and supervision. So it does not impact, it is absolutely admissible in terms of compliance and in terms of in any subsequent case, should anything be charged or should there be a decision about detention, that information can be used to make a detention decision without limitation under current law.
Okay, so that's helpful. I still have to grapple with it, but that's helpful to see how you are thinking about it. And I do have to say that your testimony on the statute of limitations issue, on the propensity issues, very, very helpful to me. We are in a time where everyone is concerned about crime and thinking about what are the things that we can do to try to strengthen prosecutions, et cetera, and to make sure that we're doing what we can to keep people safe. And it is really important to have the flashing yellow or flashing red lights about you can overreach in different places. And so it's a really important role that you're playing in that testimony. I am trying to go ahead.
Before you move on, can I add one thing on the GPS
Please do,
piece?
please do.
A person being on GPS pretrial, it's also as an alternative to being detained, right? So if you think about that, as we've determined this, a judge might say, all right, I'm not going to detain you, I'm going to put you on GPS as a way to allow them to be in the community for safety. So then if they then abuse that and commit a crime or somewhere they aren't supposed to be, I do believe it's more than just about compliance. It is about community safety. So if we're then not allowed or hamstrung and we can't use those GPS data, I think that's really a...
So, I mean, and it's an interesting thing because I actually am struck today that we've had 6 government witnesses on public safety issues, and 5 of them have been women, which I think speaks to something. I don't know exactly what that is, but I see it as progress. In your testimony, you and Ms. Semenova don't have the same testimony, but you have overlaps, and then there are differences, and you can see why it is while we all are grappling with these things, trying to figure out, because what you just described is part of my instinct about how it's used, so I was trying to understand how Ms. Semenova saw it, and I get that as well. We're going to have to figure out where that all takes us going forward. On the statute of limitations issues, which I think that you and Ms. Semenova were closer to each other on the statute of limitations issues. On the joining offenses, I don't know if that's the right expression, Ms. Suttenberg, but I don't understand if there can be a prosecution for the rape, why there would need to be a prosecution at a later date about the burglary. And to the extent that you say, well, there's a cumulative thing, there's another harm from the burglary, that would be true from the burglary before that had a statute of limitations to it. What happens in a setting where someone's acquitted of the rape, but then could they be convicted of the burglary because it was in the setting was an adjoining offense? How does that work?
Sure. So the properly joinable statute just has to do with what can be joined in that one case. So when we're talking about it, we're saying in this one case, a person can be charged with rape and burglary. Let's say 10 years have gone by. Under current law, they can only be charged with rape, and under this proposal, they could be charged with burglary as well, so those could proceed to trial together. A court could find that they were not properly joined and sever the cases. The court would have the discretion to do that under certain circumstances if they were not appropriately joined. So it would be the same prosecution in which they'd move forward. If there was not a different, if there was no statute of limitations that was relevant to the case, then those would move together anyway. And so when we're just kind of talking about cases where there's a longer period of time that has passed, but they would still be the same prosecution. As to your second question, though, about what would happen if there is an acquittal or something on the main charge, my understanding is that it's based on when they are charged, because the statute of limitations deals with the time of charging, so they would be allowed to continue to proceed even if the most serious offense were acquitted. But just to be clear, that would mean that the jury found, beyond a reasonable doubt that that person committed whatever offenses the court deemed were properly joined with the underlying offense.
And I think I'm hearing that as a court could find burglary and rape were properly joined. The person was acquitted of rape, convicted of burglary. Ordinarily, the statute of limitations would have barred that burglary, but now that becomes a possibility. I just am trying to understand how it all works, because some of these things, it is the case. And this goes to the rules of evidence. I remember studying this, and I can imagine the frustration of prosecutors where there are things where you feel like it could be very compelling and get to a prosecution, but centuries of rules have said, no, you can't do that because it creates so much prejudice that it clouds the access to a fair trial. In some ways, that's easier for a court to deal with than a legislature, but I do think we have to grapple with that. If we change those rules, how does that fit with very broad principles trying to maintain fairness? And I'm not trying to say where it is that I come out, but I'm grateful for the testimony that raises that issue today.
And if I could make one more point on the properly joinable offenses, if you kind of scroll down in the statute, when you look at the offenses that are subject to a 10-year statute of limitations, the properly joinable language is there. So those are the less serious cases that the council has deemed not eligible for no statute of limitations, but only for a 10-year statute of limitations. So in those cases, you can charge the properly joinable offense. Likewise, before the council completely eliminated the statute of limitations for the most serious sexual crimes, which we absolutely support, there was a 15-year statute of limitations that now says just repealed in the statute. But there was a 15-year statute of limitations, and it also allowed for the properly joinable offenses to be charged with that. So it used to be the case that rape had a 15-year statute of limitations, first-degree sexual abuse, and a crime could be properly joined. And then when the council moved it up and elevated them in their level of importance, a conforming amendment was not made to the statute.
Okay, very helpful. I'm going to leave a minute 12 seconds on the clock. Thank you very much for your testimony.
Thank you very much, Councilmember Fruman. Just a couple more from me. Ms. Bechtel, in working with young people, there is a provision in this bill around domestic violence when a young person is present, and there was some testimony from some of our public witnesses today about if that goes too far, if that could inadvertently limit a victim actually reaching out to law enforcement. I'm just wondering if you have a perspective on if you think that's the right intervention or perhaps another intervention to support young people and children, especially when their parents are engaged in domestic violence.
That is one certainly that's been knocking around. Oh, thank you. Thank you. That's one that's been knocking around for years, and I know there's kind of historically been some tension between the child protection world and the domestic violence world, protecting kids and protecting domestic violence victims, and I think that one has kind of fallen right in the middle over the years because I think what I believe it was Michaela Deming that talked about the concern about the victim herself or the being targeted. So I'm not giving you a 100% answer because I do think it's a complicated one, but I do think that from the overall that it is more likely that the victim is the system's going to find the right person, the primary aggressor, not the victim. And I think it's fairly rare, at least again in the district, that a victim may get arrested when there's the chaos of what's going on with the police there and everything's happening, but in terms of what's actually going to go forward, I think our system is pretty good at it. And by having that, again, is the person at the house sitting there thinking, oh, I'm not going to do this assault because the kid's here? No. But does it have additional consequences, and does it start getting around that, this is more serious and we need to take it more seriously? I think yes.
Thank you very much. Appreciate that. And Ms. Suttenberg, we had testimony from Director Park earlier about the limitation this bill provides for access to firearms if you have a previous stalking offense. And we know the predictive indicators that can also have on domestic violence. Do you have any response or information about the constitutional legal issues that could arise with that provision change?
So my understanding, my recollection from Mr. Park's testimony is that he was referring to the recent Supreme Court case law, and I understand that the Supreme Court will be hearing some cases this term on that issue. I mean, I know I can't speak for the entire Department of Justice. I know the Department of Justice has filed very substantial briefings in that case, and so I would really defer to the Office of the Solicitor General, who is, I believe, taking the lead on behalf of the Department of Justice with respect to litigating those serious cases that would have major implications for a lot of provisions, not just this minor adjustment to the statute.
Got it. Fair enough. Well, we will definitely continue to work with you all and others on that provision. And I do want to note to Ms. Semenova's testimony about the timing of this bill, and just to be very clear. And today I announced a kind of broader package of initiatives called Secure DC for a lot of interventions that I think will be helpful. Today's hearing is on one piece of this, but I and my team and the committee absolutely look forward to working with you in the Public Defender Service, with the Attorney General's office, with the U.S. Attorney's office, other advocates, to make sure we're getting this right. And part of my announcement today was really to lay out transparently for everybody in the public what the committee's strategy and priorities are for this fall, so that we can have more voices as part of this to make sure that we're getting all of the balancing right, and that we're having the anticipated impact that we hope to have. So just wanted to clarify that for the record, but as always, look forward to working with you and your team. With that, we are concluded with today's hearing. I really want to thank you all for your expertise in doing this important work, and for sharing your testimony today, as well as all of our public witnesses who are here today. You can still submit written testimony for anybody who would like to. The record will close October 2nd, 2023, and you can email that testimony to judiciary@dccouncil.gov. With that, the time is 3:27 p.m. on the same day that we began. We are adjourned.